Testing 1 2, testing 1 2 1 2, testing. Testing 1 2 1 2, testing 1 2. Testing 1 2 1 2, testing 1 2. Good morning, everybody. May I have your attention, please? May I have your attention, please? Welcome to the Constitutional Court. We are about to start. Please make sure that you switch off your cell phone, please. Please ensure that your cell phone is off. Thank you.
Please rise for the Constitutional Court.
Thank you, Mr. Turnbull. Thank you, Mr. Bossman. Thank you, Mr. Marcus.
Justice and other justices, I'm here together with Ms. Kamisha Pilla and the Honorable Democratic Party.
Thank you, Mr. Kass. Thank you, Mr. Skakani.
here for the IFP with my learned friends, Jonathan Jones and Vera Sam.
Thank you too, Mr. Kemp. Thank you, Mr. Tlokwe. Mr. Tringo, I assume there is no waiver. Is it a fair assessment?
No, I think I should, because I am going to deal at the outset with what I think is the most important part of the case.
Yes.
And for that reason would welcome the court's questions.
Oh, from the word-go.
Indeed.
Thank you.
I propose to address four main topics. The first is the law, and on that score, the IEC's position on four issues of law. I will secondly deal with this court's judgment in Cum's case, its ratio and its implications. In the third place, with the Electoral Court's judgment in this case, submit that it was wrong on the core issue. And I may tell you that on this score, my learned friend Mr. Marcus will deal with a subsidiary aspect of that judgment. And I will deal in the fourth place with the alternative application for direct access and alternative relief. On this score too, I will address merely the relief sought by the IEC, and I won't deal with the other proposals made by the other parties, because my learned friend Mr. Sikakani will address that in his address, and my learned friend Ms. Blizzard will deal with it in reply if needs be. So I start with the first chapter on the issues of law. And for that purpose, we have prepared a brief statement of the IEC's position on four aspects of law. I have distributed amongst my learned friends, and I wonder if I might hand it up to the court. It doesn't constitute submissions, it is merely the bottom line, the conclusion on each of four issues of law. If I might be given leave to hand it up to the court and then speak to it. There's one for the judges and for the clerk.
You may proceed in the meantime, Mr. Tringo.
The first proposition of law is this. It is that we accept that the IEC may only register voters in the voting districts in which they are ordinarily resident. And for that purpose, the IEC must obtain from the voter seeking registration the voter's address, if she has one, or the voter's enough particulars of the voter's ordinary place of residence to determine in which voting district it falls. The IEC is not required to verify that information, but it is the IEC's duty, once having obtained that information, to ensure that the voter is registered in the voting district in which her ordinary place of residence falls.
While you are there, did you say we may interrupt or not interrupt?
No, certainly, Chief Justice.
All right. What then would be available for a person who is not convinced that the determination that certain voters belong to a particular district is correct? What would that South African have to look at to satisfy himself or herself that the conclusion arrived at by the IEC is the correct one?
Chief Justice?
I'm not saying what the IEC does is wrong. I'm just saying, in the event of a challenge, what are we going to compare what to what?
Well, we submit that anybody who challenges the role would have to show that the voter is not resident in the district in which they are, for which they are registered. There is a second issue that you raised, Chief Justice, and that's this. What record must the IEC keep of the address of the voter, and I think that that is what you are interested in.
Not because the law requires it, but just to play it safe.
Indeed.
Yeah.
That is indeed the issue that we address. That's the second point of law that we address in our note, if I may refer to it. We say that the question is, must the IEC record the address? In other words, keep it and record it in its system. We say the following. Firstly, Section 8.1 requires the IEC to make the requisite entries in the voter's roll. Regulation 10 says that the entries that must be made are only the ID number, the name and ID number of the voter. Therefore, the IEC was not required by law to record the addresses of the voters at least until December 2003, when Sections 16.3 and 16.4 were introduced. When they were introduced, they didn't say that the IEC must now keep addresses, but we accept that it probably implies that the IEC must henceforth keep those addresses.
I interrupt again. Does it imply or does it require of the IEC to do that? I ask the question because Section 16, subsection 3 provides for political parties, and I assume by extension independent candidates, it may be a subject matter of debate, to have access to a national voters' roll that has in it physical addresses. How then would that be possible if it were open to the IEC to choose not to reflect the physical addresses?
We approach this case on the basis that Section 16.3, in other words, the section to which you refer, does imply that it should keep and record those addresses. So that 16.3 and 4 introduced that requirement by implication, but it only did so in December 2003. As at that date, there was already 18 million voters on the voters' roll. And that's really where the heart of this case lies.
Well, that's interesting. Here's another difficulty. What if from 2003 that was not done? What are we to do then? And are you in a position to say from 2003, in other words, after Section 16, subsection 3 were passed, that was done? And if it wasn't, what should be the implications of that?
And my understanding of the evidence is that it was generally done, but the evidence is ambivalent in the erudition with which it was done. It was certainly not done as a rule until December 2003. It was generally done from December 2003, because you'll remember that at the time that this case arose, there were no longer 18 million voters without addresses. There were 16 million voters without addresses. In other words, all the new, or most of the new registrations, and even some of the old registrations, brought that number down from 18 to 16. But I can't assure you that it was fastidiously done from December 2003.
Are you in a position to say what percentage of registrations that took place ever since the amendment kicked into operation were compliant, so to speak?
I don't think so, Chief Justice. But frankly, that is simply because the case against the IEC has never been one that said that you have failed in your duty since 2003. The case against the IEC has consistently been, and I'm getting to it now, but has consistently been that what you were required to do was not only henceforth to record addresses, but to go back to the 18 million and find and record their addresses. And that's really where the dispute between us lies. The essence of the case against the IEC is that it should have gone back and found the addresses of the 18 million, or at least those of them who have addresses. That is the case, and you will see in the Electoral Court, in this particular case, the heart of the cause of action against the IEC was that there were 4,000 people on the roll without addresses. And the case made against the IEC was there ought not to be people on the roll without addresses, because you ought to have gone out and found addresses for them.
Well, that I understand, Mr. Trengove, except for one thing. If it was the IEC's position that the proposition that we should have gone further, in other words, covered the period before 2003, is incorrect. The correct position, according to our understanding, is that we were only under some implied obligation, or whichever way the IEC chose to put it, to reflect the addresses after 2003. Ought not the IEC then to have said, in line with our understanding, or the understanding of our mandate, this is what we have done to comply since 2003, or with the advent of the CAM decision?
Yes. Chief Justice, may I come back to that issue in greater detail when I deal with the Electoral Court's judgment in this case? Because that, with respect, was not the basis on which the cause of action against the IEC was formulated, or the case was developed. The case against the IEC was there are 4,000 names on the roll without addresses, and that means those people are illegally on the roll, because you ought to have found addresses for all of them. So the question was not, the attack against the IEC did not make that distinction between before December 2003 and after 2003. It was a general proposition that nobody ought to be on the roll without an address.
Are you sure we shouldn't give you 10 minutes just to make your case before we interrupt you? You still maintain that position?
Maybe what I should do is just to take you through the propositions of law.
I think so.
Mr. Trengove, on the exchange that you've been having with the Chief Justice.
He wants to take us through the...
Oh, okay.
Yes.
I'm interested in the table, if you can also have regard to the table that appears at page 421 of the record.
Just to manage it, Mr. Trengove, just do what you were minded to do, and signify when you're comfortable that we may interrupt.
Chief Justice.
Thank you.
As you'll see from this note of ours, the first proposition is that we accept that the IEC has always been obliged on registration to make sure that the voter's address or description of their place of residence falls within the voting district in which they are registered. And with respect, the IEC says, and there is no serious challenge to that evidence, that it has, as a general rule, always fulfilled that duty. That evidence is quoted in our heads from page 8 in paragraphs 21 and 22. So it is uncontroversial that the IEC was always under a duty to make sure that an applicant for registration is registered in the right voting district. About that issue, there is no debate, and there is no serious challenge to its evidence that it has always complied with that duty. There have, of course, been mistakes and there have been lapses, but as a general policy, it has always complied with that duty. The second question that we address is, was it obliged then to record that address? And that is where there is a difference between the parties, because we submit, for the reasons we set out in our paragraph 2, that there was no duty on the IEC to keep those addresses on record after registration has occurred. If there is such a duty, then it is one that was introduced by implication by section 16.3 in December 2003. And we're going to argue the case on the assumption that 16.3 did introduce such a requirement, but only did so in December 2003. And then, of course, the cum judgment in this case, of this court, recognized that duty, and in paragraph 5C, explicitly requires the IEC now to keep addresses. But I emphasize that paragraph 5C makes it quite clear, firstly, that it is a prospective duty imposed on the IEC, only from the date of judgment, that's from the 30th of November last year, and the duty imposed on it is a duty to keep the address on registration. In other words, it is quite inconsistent with the case made for the respondents that section 16.3 imposed a duty not only to keep addresses on registration, but imposed a duty on the IEC to go back to find the addresses of the 18 million already on the roll in December 2003. So that is as far as the duty to keep those addresses. And we emphasize that neither section 16.3 nor this court's judgment in cum, nor paragraph 5C of cum, said or implied that there is a duty to go back and find addresses for voters already on the roll. There is simply no such legal obligation imposed on the IEC. And that is why we say in our paragraph 3 of our note that the absence of a voter's address on the roll does not imply or even suggest that the voter's registration is invalid. And that is, there are two categories of voter on the roll without addresses, but perfectly validly registered. The one category is people registered before December 2003 because their addresses weren't kept and put on the roll, and despite the fact that their registration was valid. The second category would be those registered since December 2003 who don't have addresses, who were registered on the basis of a description of their place of residence, but who do not have a convenient address that you can put into the roll. So that the mere fact that there are names on the roll without addresses does not imply or even suggest that their original registration was in some way irregular or flawed. And that is the case against the IEC, that there were 4,000 names on the roll without addresses and therefore the roll is defective. We submit that there is a flaw in that reasoning because a name on the roll without an address does not imply irregular registration. And the most vivid illustration of it is that two of the independents, that's the second respondent, Ms. Kaba, and the third respondent, Mr. Tlokwe, they are two examples of exactly what we're talking about. People who were lawfully registered before the IEC kept record of the addresses, but to this day are on the roll without addresses. And when that point was made in the founding affidavit, if I may just give you the reference, but the reference is at page 405 in paragraph 43.4. But the interesting part is the response to it, which you'll find at page 556 in paragraph 78.5, where the answer is filed on behalf of the respondents. And in response to this statement in the founding affidavit that two of the independents are examples of people who are lawfully registered but don't have addresses on the roll, the response is in paragraph 78.5, I further submit that the second and third respondents will confirm in their supporting affidavits that, 1, they have been residing at their current addresses for many years. 2, they have supplied their addresses to the Commission when they registered. 3, the addresses are street addresses that are perfectly verifiable. 4, their addresses do not fall without the category of places in rural areas where verification of addresses is not possible. 5, that both of them have a cell phone and a bank account. 6, that by virtue of the above, their names will appear on various national databases. And then 6 again, I therefore categorically deny that the only means of correcting the voters' roll would have been an exercise of simply removing voters, etc. So what they said is that we accept those people were perfectly validly registered, but their addresses aren't there. But the case made against the IEC is that you had a duty to go out and find addresses of people of that kind. And then the argument they make here is to say, I was perfectly contactable. I had a cell phone, I had a bank account. Your duty to find the addresses of 18 million people included a duty to find me, and you could and should have found us. Well, that's a different...
Mr. Trengo, may I just ask if you're going to deal with Mr. Marcus's argument on behalf of the ANC, that part of the CUM order applied because of the apparent shenanigans in relation to the Tlokwe by-elections, and therefore that there was a duty at least to find addresses of voters in the by-elections who didn't have addresses?
Yes, in the heart of the CUM case was proven, accepted, irregular registration of 1,040 voters, 25% of the registration since 2000. So that the CUM order must be understood to be in the first place an order about 1,040 proven irregular registrations. And so on that score we accept that interpretation, but precisely because that case was concerned not merely with names without addresses, but concerned about proven irregularity.
Just let me know if it's time to interrupt you. I was just allowing you to round up before we could put questions to you.
Well, can I deal with the last issue of law, which is the fourth issue, and that is, we've now said the IEC were initially not required to keep the addresses, became required to do so since 2003, but there was no duty to go back to find the addresses of people already on the roll. There is then the fourth and last question, and that is it obliged to include those addresses in the voters' roll made available to the public, the political parties, and the independent candidates? And with respect, there are 3 sets of provisions which deal with that issue. And we deal with them in our paragraph 4, because the 3 sets of provisions deal with 3 different occasions on which voters' rolls are made public, and the rules that govern them differ. There is firstly section 16(1) and 2. They require the IEC to make the ongoing voters' roll available to anybody at any time on request, either for inspection or a copy at the prescribed price. So that is concerned simply with the ongoing voters' roll, which is made available to anybody at any time on request. And we submit with respect that that voters' roll is one that does not include any addresses, because it contrasts with 3 and 4, which does provide for the inclusion of addresses in the voters' roll. 16(3) and 4 operate at the time of national or provincial elections. And what they say, they were the provisions introduced in December 2003, what they say is that at a time of national or provincial elections, the voters' roll must be made available to the political parties, including the addresses of the voters. But it then, at the same time, because it specifies that on this occasion addresses of voters must be included, it introduces safeguards of the privacy of the people whose addresses are now made public. It says that this voters' roll may only be made available to political parties contesting the election, and those political parties may only use the voters' roll for the purposes of the election. And it reinforces that limitation by a serious criminal sanction, so that it is clear that when Parliament decided on this occasion and for this purpose to make addresses available to outsiders, it is confined to this particular occasion to political parties for purposes of fighting the election, subject to a privacy restriction.
Ready to be interrupted?
Indeed.
Or do you still want to be protected
I'm just
from
about
us?
there. I'm just about there, Justice.
You're about ready. Let me just go back to the point that the Chief Justice raised with you quite early. From December 2003, did the IEC have a duty to record voters' addresses?
We accept that they did, yes. Let me say, the duty, if there was one, is implied by 16.3, and it is not open and shut and clear that it does imply
implied?
such a duty. But
The section tells us that you provide political parties with addresses,
we're available, yes.
which means you have to keep them so that you can supply them.
We accept that
You accept that?
there is an implied duty to keep the address.
So aside from us in CAM, Parliament tells all of us that the IEC must keep addresses of voters in the voters' roll and make these available to political parties. It's a clear duty that Parliament sets, not us.
Indeed. That's the effect of 16.3 and 4.
Let's go somewhere else to your note. In 4.3 of the note you gave us this morning, the note suggests that Section 6.2b of the Municipal Electoral Act envisages a voter's roll without addresses.
Yes.
What is the justification for that proposition?
Well, we make the same submission, Deputy Chief Justice, about 16.1 and 2 on the one hand, that's in our paragraph 4.1, and about 6.2b of the Municipal Act on the other, simply because none of them say, well, let me first say, they predate December 2003, so that they existed at a time when there were no addresses kept, or no duty to keep addresses.
But we know that the definition of voters' roll in the Local Government Municipal Electoral Act means the national common voters' roll. So we have the duty introduced in December 2003, and the municipal electoral law tells us that talks about a roll, and 6.2b in particular makes such segments available for inspection. And also 1 says the segments of the existing roll, but we know we have a definition of roll. It refers to the normal national roll.
No, with respect, we don't have a definition of the national voters' roll. The section 8.1 of the Electoral Act says that the entries made, that the requisite entries must be made on the voters' roll. That's all we know.
Referring to the definition of voters' roll in the Municipal Electoral Act.
Yes.
It tells us it's the same roll as the national roll, common voters' roll.
Yes.
And we know now that we're talking about the same roll,
yes,
whether for local or provincial or national elections. Does the duty in 16.3 then extend to municipal elections?
Yeah, well, there's a misunderstanding between us, Deputy Chief Justice.
Yes.
The misunderstanding is this. I accept entirely that elections at both levels of government, or all 3 levels of government, are conducted on the same voters' roll. The question is, what does that voters' roll include? It certainly did not include addresses before December 2003. And
okay, let's debate that also. Why not?
Well,
the law says that you will determine where a voter lives.
yes.
And IC tells us we have determined that without fail, but we did not always keep the records. Why? Why not?
Well, firstly because there is nothing that had required the IEC to to keep the addresses and put them in the roll. And the two provisions which do speak to the content of the roll.
So once they determine the addresses, what do? Do they destroy them?
They kept them, but in the course of time, a lot of them had gone missing. And they also make the point that very often the addresses on those forms were inadequate, so that when the voter came with inadequate information, they would sit down with an electoral officer who would question them and by question and answer determine where they lived, and on that basis registered them. So the records were both, some of them were inadequate and a lot of them went lost.
And the Chief Justice asked you after the amendment, did the IEC in December 2003 keep the record of the addresses?
Yes, it did. I can't tell you that it did so fastidiously and carefully because there was no great emphasis on it, and the issue isn't squarely addressed in the papers.
And does that include descriptions of where voters lived?
I don't understand that it ever included in the roll the narrative of descriptions of where voters lived. No.
No, but when they inquire where a voter lives, the voter would sometimes provide a description.
Yes.
Otherwise, the IC official will never be able to satisfy herself.
Always provided a description if they didn't have an address. And that is beyond doubt that they always got that information.
Yes. Now the question is, was there a recordal of that description after 2003? We've agreed already the duty exists, the statutory duty put up by Parliament. So the question is,
No. There was a duty to record addresses. If people didn't have an address, there's no duty to record the narrative that placed them within a voting district.
Then you must give address a very narrow meaning, isn't it?
Well, I
to go past that one.
I submit with respect that address is a description, an identifier of a place of residence, not a narrative which says between the two spaza shops under the water tower.
In the Kham case, what were we confronted with? How was it possible to have false registrations?
Justice, Deputy
Because
Chief
there is
Justice,
the mischief that the judgment sought to get at. How was that possible?
Can I perhaps just complete my answer to your earlier question? There was always, and there still is, a description of the voter's roll, because Section 8.1 says that the electoral IEC must record the, quote, requisite particulars in the voter's roll. And Regulation 10 has always said that the particulars that must be recorded are the names and ID numbers of the voters. So the starting point is that a voter's roll is a list of names and ID numbers, not addresses. The first time that it was suggested that addresses must also be included is under Sections 16.3 and 4. But they don't say you must disclose the voter's roll. They say you must disclose the voter's roll, including the addresses. And then they add to that a restriction to make sure that those addresses are not abused. It would be wholly inconsistent with that parliamentary scheme of 16.3 and 4 to read 16.1 and 2 as meaning that addresses have always been included in the voter's roll and have always been accessible to anybody on request without the restrictions imposed by 16.1 and 2. So the status quo, at least when 16.1 and 2 was introduced, was that the roll is freely available to anybody at any time, but it does not include addresses. 16.3 and 4, for the first time, required disclosure of both of a roll with the addresses, but subject to severe restriction. You asked me about the CUM case. The CUM case, indeed, Deputy Chief Justice, was a case about irregular registrations. It was proven, and the IEC investigated and accepted, that 1,040 people had been irregularly registered. And there was never a proper explanation given for that lapse. So, and that was really what COM was about.
And if the law as set up in 2003 had been followed, would there have been room for false registrations?
No, but it had nothing to do with the law of 2003. It is common cause that the IEC has always been required to ensure that people are registered in the correct voting districts. And that had nothing to do with the law of 2003. That requirement is a requirement there from the outset and was not followed in those 1,040 cases. So that it is true that there was a lapse in COM. That was the subject of this court's censure in COM. But it was an aberration and not the normal practice that was followed. And an admitted aberration.
Mr. Trengove, I still have questions for you. And maybe before you go any further, and maybe also just to caution your colleagues, I hope nobody is going to suggest that any of the players list of all the court is trying to disenfranchise 12 million people.
Indeed.
I've seen that in the heads of argument coming up, because that will call for some real answers if anybody comes up with that.
Yes.
I'm just cautioning that whoever comes up with that argument must be prepared to answer. This is what I need to understand. Let us assume that this court's judgment in COM was wrong. But it's there, it stands. What is it that the court required of the IEC to do in relation to the national voters' roll as it affects Tlokwe? For a conclusion to be arrived at that now we have a national voters' roll that complies with the court order. How far back did COM require of the IEC to go in terms of ensuring that the addresses are reflected?
Now, with the greatest of respect, the COM order itself said in 5C that the IEC must henceforth keep the addresses on registration. And let me just read 5C because it makes it clear, doubly clear, that that it is concerned with the future and not the past. It says, it is declared that when registering a voter to vote in a particular voting district after the date of this order, the Electoral Commission is obliged to obtain sufficient particularity of the voter's address to enable it to ensure that the voter is at the time of registration ordinarily resident, etc. And then D followed from that the roll must be made available at the time of municipal elections. But the part of 5C that I wish to emphasize is this, is that it says, it speaks about a duty at registration, at the time of registration, not a duty to go back and find addresses of people who are already registered. So it was confined to a duty to do something on registration.
Yes.
And that duty is imposed with effect from the date of the order. That's with effect from the 30th.
Let's take it in stages. Did COM make new law or simply restate the law as it existed at the time?
5C certainly did.
Did we change anything and come up with anything new in relation to the law that governs the registration of voters?
Not the law that governs registration, no.
So it was restated.
It was restating the law. We have, as you know, Chief Justice, we have some reservation about 5D.
We'll get to that.
But
yes.
That's got nothing to do with the process of registration.
Right.
That's got to do with the form of the roll made available to people contesting elections.
So on your understanding of 5C, does it have any impact on the voters' roll that affects Tlokwe that cost the applicants to approach the court in the first place? In other words, does the order in COM 5C, order 5C, require of the IEC to do anything in order to correct the national voters' roll as it affects Tlokwe, or did the court merely give direction in relation to what is to be done going forward?
We submit with the greatest of respect that what you're talking about is paragraph 5C, and 5C says you must from now on get those particulars when you register voters. It said nothing, not only is it silent on the past, but it is inconsistent with 5C to suggest that there is a duty to go back and find addresses of people who have already been lawfully registered. 5C just doesn't make sense if there were a duty of the kind that the respondents contend for.
Which part of the order addresses the concerns that caused people to approach the court in the first place, if any?
I mean, what the court did in COM was to set aside an election already held because the roll on which it was held was admitted to be flawed. That was the guts of COM. But as far as the orders going forward are concerned, it did not suggest that the flaws in the roll had to be cured by going back and finding addresses for the 18 million who were already on the roll in December 2003.
And what on the IEC's understanding of the COM judgment, I'm sorry, I'm not too clear with the pronunciation, I don't mean any harm. What, according to the IEC's understanding of the COM judgment, was required to be done to remedy the complaint that caused the independents to approach the court in the first place?
Well, the primary duty was to address the 1,040 irregularly registered voters. And the IEC explained that it did subsequently investigate all of those cases, and it removed those which were ultimately indefensible. 700 odd of them were removed from the roll. Not because they didn't have addresses, but because they were found to have been irregularly registered in the wrong voting district.
And what about the addresses? What was the understanding in relation to ensuring that addresses are reflected going forward?
Going forward, the only understanding is paragraph 5C, which says you must record them on registration. In other words, henceforth, make sure that you keep the addresses when people register. It didn't address, and it said, and in 5D it said that those addresses must be made available where available, must be disclosed where available. What the court didn't address is the 18 million who are still on the roll without addresses. That was not what COM was about. That was the issue in the Electoral Court, but not in COM.
I think I must reserve my other questions so that I don't monopolize the questioning.
May I go?
Mr. Trengo.
Before you move away from the Chief Justice's interaction with you, why is your case at all that the COM judgment disenfranchised 15 or 18 million people?
No.
That is not your case, is it?
Why
are we dealing with that at all?
The Electoral Court, because that was the effect of the Electoral Court judgment, but not COM judgment. No. The Electoral Court misunderstood COM. But it certainly suggests that any...
Show me the part in the Electoral Court judgment which deals with the historic
Chief Justice, I'm going to do that. I'm going to do that. May I deal with COM first and then get to the Electoral Court judgment?
Very well.
Because my submission will be that they misunderstood COM. I will deal with Kham only to identify its ratio. I'm not going to read the relevant paragraphs, but may I just give you the paragraphs of Kham, which we submit with respect, capture its ratio. There are a number of them. They are paragraphs 58, 68, 72, 73, 76, 77, 80, and 92 to 94. And the ratio expressed in those paragraphs may be quite succinctly summarized, and that's this. The court set aside the election because of a combination of three flaws. The first and the main flaw was that there were 1,040 of the 3,832 registrations since 2000. So let me just repeat those numbers. New registrations were 3,832. Of those new registrations, 1,040, which constituted 27%, were incorrectly registered, and that irregularity was conceded. The second flaw was that the roll did not include any addresses, so there were no addresses in the roll at all. And that the court held was in breach of section 16.3. The third flaw was that the roll was released late and not by the deadline required by section 16.2 of the Municipal Electoral Act. And it was the combination of those three factors, those three flaws, which the court held rendered the election not free and fair. But it is clear if you read these paragraphs that the most important of those flaws was the first one, the 27% of irregularly registered voters.
Mr. Trengo, are you done on that point? Yeah. You know, I don't know about you, but I find the case to be very difficult, and I want to make the most of your benefit optimally from your collective wisdom before we go. Let me just seek clarification on this point. As we sit and stand here now, what is it that section 16 subsection 3 requires of the IEC to have done since 2003 for the national voters' roll to be in a correct state? Let's forget a bit about what COM said, what the Electoral Court said. As the law stands, what obligations does section 16 subsection 3 impose on the Electoral Court? I beg your pardon, the Electoral Commission, and I'll have another question afterwards. What is it required to do?
16.3 requires the IEC to keep those addresses given to it on registration and then to disclose them to the political parties on request under 16.3.
To the extent that there is non-compliance, what is it that is required of the IEC to do so that the national voters' roll is in an acceptable state at some point, whether at the time the elections are conducted or at some other stage? What is required of the IEC?
Well, we submit that there is no evidence that the roll is flawed. In other words, there's no evidence that the IEC did not discharge that duty. What is common cause the IEC did not do is to go back to find the addresses of the 18 million already on the roll in December 2003. And that is with respect what this case is about. Did it have such a duty or not? We submit not.
Well, my question is slightly different. What I need to know is this. If the correct meaning of section 16 subsection 3 is with effect from December 2003, it was required of the IEC to reflect the addresses that were available to it from that time, so that when political parties require the national voters roll, the addresses apparently required by Section 16.3 are reflected there. If anybody gets hold of the national voters roll and realizes that that is not the case, I mean, anybody can just get hold of it, pay the fee, get hold of it, and tell whether there has been compliance or non-compliance. Now, if there hasn't been compliance, what is to be done?
Well, Chief Justice, the question, you speak about the addresses where available, and that's really where the difference between us lies. We accept that the IEC was required from December 2003 to keep the addresses and put them in the roll when disclosed under 16.3. But we do not accept that there was a duty to go back and find the addresses of the 18 million already on the roll. Now, and therefore, when the IEC makes a disclosure under 16.3 today, we submit that that duty is limited to those addresses which it has kept since December 2003, because they are required to be available. It does not include the old addresses of the 18 million people who were already on the roll. Our learned friends interpret 16.3 differently. They say where available doesn't mean the addresses that you have on your system. They say it means the addresses that you are able to find if you go out into the field and in search of addresses. They say that's what where available means. Now, if they are correct, then the IEC did not comply with the Act. So
I'm sorry, I interrupted. Now, you know, you're an experienced counsel, you've acted as a judge. You know, a judge never knows until he or she begins to reflect on the judgment.
Indeed.
What the correct position is.
Absolutely.
And that explains these many questions. But on the assumption that their interpretation of 16.3 is correct, what then should happen?
Well, that's why...
If on the assumption that there has been non-compliance, what then should happen?
If they are correct that there was a duty on the IEC to find the addresses of the 18 million, then it's clear the IEC did not comply, and then the appeal cannot succeed, and then the alternative direct access application comes into play. So, but it is as stark as that. The question is, did Section 16.3, when it was introduced in December 2003, imply not only that the IEC must henceforth keep addresses, but imply that the IEC must go back and find the addresses of the 18 million?
What if it implies that the IEC should have kept the addresses from 2003?
No, we accept that it implies
Except that
Yes.
it implies that.
Yes.
Why are we seized with 18 million at all?
Because the case against us is that there are 4,000 people on the roll who don't have addresses and therefore are irregularly registered. We say
Yes.
no, that logic doesn't apply.
And from that you infer that the Electoral Court meant to disenfranchise 18 million people.
Yes.
Is that where it comes from?
Well, yes. And let me...
But did it ever in its judgment deal with 18 million?
It dealt...
Or the historical voters' roll?
No.
No.
No. But what...
So you before us, because you infer from the Electoral Court judgment that it meant that IEC has a duty to correct the historic voters' roll.
Deputy Chief Justice, in fairness to the Electoral Court, may I ask to take you to the two paragraphs of their judgment on which we rely. They occur at page 365 of the papers, and it is paragraphs 12 and 13 of the Electoral Court judgment. And you will remember that the background was...
Which volume? Is it 4?
Volume 4.
316 or 369?
365.
Thank you.
Paragraphs 12 and 13 of the judgment. The background was this. The independents came to court, and the core of their complaint was that there were 4,189 names on the rolls released to them without addresses. That was the cause of action. The case was there is more than 4,000 names on the roll without addresses, and that is irregular because these days all voters must have addresses. And that was the complaint that the court addressed. And it said on that score the following in paragraph 12. The fact that the voters' roll contained registered voters without addresses was common cause. Counsel for the Commission advised this court that the Commission had commenced the cleaning up of the voters' roll, but that the process had not yet been completed. This admission implies that there are indeed voters on the roll, as it was before the Constitutional Court, who should not have been included therein. It was submitted that the removal of voters from the roll would have the effect of disenfranchising them. The argument cannot be sustained. If a voter was wrongly included on the voters' roll, the removal of that voter would not disenfranchise him or her, as he or she should not have been included in the particular voters' roll in the first place. We submit with respect that logic says that where there is a name on the roll without an address, then it means that that voter was irregularly registered, and that voter does not belong on the roll. Now, the court did not appreciate, probably because the facts weren't canvassed before it, that what that implied was that the 18 million who are now down to 16 million would be disenfranchised.
No, but where does it imply that? This is a specific case about specific set of facts, and the court may very well have referred to the duty that arose in 2003. And on the face of it, if there is no address, then the registration is irregular.
No,
unless the ANC uses the caveat and say, IEC said there were no addresses available.
no, but what this...
Sorry.
What this...
But you invite us to make a decision about the historical voters' roll, and I'm probing the cogency, the basis for us making that decision at all.
Well, what I'm addressing...
Why is it before us?
Well, what I'm addressing is the cause of action made by the plaintiffs in this case, by the respondents in this case. The cause of action they made was that there are 4,000 voters on the roll, on the segment of the roll, without addresses. The fact that they do not have addresses means that their registration was irregular. And the court even said, because they don't have addresses, their registration is irregular, and to remove them would not disenfranchise them because they shouldn't have been on the roll in the first place. It is that logic which is incompatible with the fact that there were 18 million people on the roll without addresses when this rule came in.
But why must we telescope the court's judgment? It deals with lack of addresses in Tlokwe, and in it we see 18 million people on the historical roll. Just help me understand, why are we seized with that particular issue?
No, what you asked...
If you say to me, in relation to the 4,000, the court was wrong to assume all of them should have had addresses, it's one argument. Quite another to say this holding endangers existing registrations on the voters' roll.
No, but with respect, we're simply meeting the case made against the IEC. And that case, if I may go back to two sentences of this court, the first and last sentences in paragraph 12. The fact that the voters' roll contained registered voters without addresses was common cause. This admission implies that there are indeed voters on the roll, as was before the Constitutional Court, who should not have been included in it. So the logic upheld by the Electoral Court was that any voter on the roll without an address is a voter who was irregularly registered and should not be there.
Mr. Trengov, does the court simply say, like as before the Constitutional Court, here we again have voters without addresses, and this is irregular? Why does that imply that I might be irregularly registered?
Well, because
if I don't have an address?
It misunderstands cum judgment. The cum judgment, there were two things. Firstly, cum held, and it was conceded, that 1,040 of those registrations were wrongly registered. It had nothing to do with the absence of addresses. They were registered in the wrong voting districts. That was the primary concern in cum. The secondary concern in cum was that there were no addresses given for anybody. So that cum does not support the ratio of the Electoral Court, which says that when there is a voter without an address, the inevitable inference is an illegal registration and a voter that does not belong on the roll. That is this ratio, and that is the basis on which the court held against the IEC. The logic is, if there is a voter without an address, then the voter was irregularly registered and its name has come off. That was the logic of the judgment. And with respect, that logic is correct if our learned friend's case interpretation of the law is the correct one. If there was a duty on the IEC imposed in December 2003, not only going forward to keep addresses on registration, but to go back and find the addresses of the 18 million, then that logic is correct. But if you accept that there was no duty to go back and find the old addresses of people already on the roll, then this logic is flawed, because this logic doesn't allow for the fact that there were already 18 million people on the roll when the rule was introduced in December 2000.
People on the roll from 2003. And the court, there were people who were registered after December 2003. And the Electoral Court was entitled to infer that the voters' roll must have addresses, because that's the duty. And if there are none, on the face of it, the registration would be regular. What is wrong with that reasoning?
No. Well, what is wrong with this reasoning is it simply says a voter without an address is irregular. It doesn't say a voter without an address is irregular only if the registration took place after December 2003. It didn't inquire into the question whether these registrations occurred before or after December 2003. And what it must always accept is that there are, at least on our interpretation, and we submit on any sensible interpretation of the law and of cum, there are two categories of people who will never have addresses. The first is, or need not have addresses. The first is those of the 18 million registered before December 2003, and the other, going forward, those who do not have addresses, who merely have a description of where they live.
Mr. Trengov, can you please give me your understanding of parity of the cum judgment, and in particular the phrase that relates to the national voters' roll to be used in the ward in that election, including the addresses of all voters.
Yes.
Which voters are we talking about there? Where it says all voters.
Well, it says all voters where these addresses are available.
Pre-203.
No, we submit that means it is true that 16.3 does impose a duty on the IEC to include addresses where available, where those addresses are available. The question is, what does that mean? We submit that where available means available to the IEC, i.e., on record with the IEC. Our learned friends interpret that to mean capable of being found in the market. We submit with respect that that's a wholly unrealistic interpretation. This section, 16.3, and the court here simply followed the language of 16.3, but this section must be understood against the history of the section. Parliament knew when it was introduced in December 2003 that there's already a voters' roll. It already had 18 million people on it. we accept that it implied that you must henceforth keep those addresses on registration. And therefore it said, and then when the political parties want the roll, you must give it to them with those addresses that you have on hand, i.e. those that you have kept since December 2003. It could never have implied that you must also go back and find the addresses. And that's why they said, frankly, that's why they said where available, because they recognized that there are 80 million people for which they don't have addresses available. If they had, they could never have implied that the duty is also to find the addresses of the 80 million, because if that was so, then IEC was in breach of the law on day one, in January 2004, because nobody could conceivably have thought that it could overnight produce the addresses of everybody who has an address out there, in other words, of the 80 million. So,
Mr. Trendle, what in your view is the functional value of the provision or providing of voters' rolls with addresses?
Well, we submit that both the history and the language make that clear. Like the history is, we're told, is that in 2003, in the run-up to the 2004 national and provincial elections, the political parties made representations to the IEC and said, won't you please give us the addresses because we need it for our canvassing purposes, for electioneering purposes. The two sections were then introduced in response to that request and said in their own terms that the addresses must now be given, but only to the political parties, and they may only use it for electioneering. And what must be given to them are the addresses where available. And we submit with respect that it recognized that there is already a big role with lots of people without addresses. And all it said was, yes, we'll give you the addresses where available. We will henceforth keep them and give them to you.
As part of the functional value, can't one also add that it may, besides just canvassing, but it may also be used for purposes of actually checking the accuracy of the registration itself, because we now know that incorrect registrations happen. Tlokwe tells us so. The fraudulent registrations in Ejozini, which I think in paragraph 60 of the replying affidavit the IEC admits, also tells us that this happens. So as part of the functional value, the political parties and independent candidates in the case of municipal elections may use the role to check if indeed the registrations are correct. So it's not just canvassing. Would you accept that as well?
No, with respect, Justice Malanga, we don't. For these reasons. The first is that the history tells us that the purpose was different. The second is that this duty to provide the addresses is only imposed by 16.3 and 4, and that is the duty to give the addresses after certification of the voter's roll. This other consideration, namely this other use that one may make of addresses, and that is to check the voter's roll. There is a process, and Section 15 of the Act describes that process, but there is a process before certification of the roll, where under 16.1 and 2, the roll is available to anybody at any time on request. Political parties can get it and they can check it, and then they may challenge it under Section 15, and those challenges can be adjudicated. But all of that is a process which predates certification of the roll. And the 16.3 and 4, which require the addresses to be disclosed, is the requirement that relates to the certified roll in national and provincial elections.
But surely you cannot say that what the people get given at the time of challenging, in accordance with what you refer us to, will be exactly the same as what finally gets certified. No, if you accept that it will not necessarily be the same, why is it then that it cannot, the roll with addresses cannot also be used for the purpose that I put to you?
Because if you look at 16.1 and 2, that's the roll that's ordinarily available to everybody. It says nothing about addresses. And it would be highly anomalous to read an implication in 16.1 and 2 that the addresses must be disclosed to anybody who can use it for any purpose.
I'm talking about political parties and candidates only, Mr. Trango.
Justice Madlanga, we're talking about the role that is made available to everybody in the run-up to certification, in other words, before certification. That role is made available to them under 16.1 and 2. That is an access to the role by anybody at any time for any purpose, without restriction on what they may make of that information. Now, 16.1 and 2 say nothing about the addresses, and we submit that it would be anomalous to interpret 16.1 and 2 to mean that what must be made generally available also includes the addresses.
My focus is on 16.3 and the obligation in terms of 16.3, Mr. Trengov. So I don't quite see the link between that and 16.1 and 2. I don't see the link. My point was, once certified, is it not so that at a functional level, political parties and candidates may then use the certified role to actually pick up possible inaccurate registrations? As we know that the IEC is not immune to such inaccuracies, Josini tells us so, Tlokwe tells us so. Why is it that it cannot serve that functional value?
No, Justice Madlanga, you're quite correct. It can serve that purpose, and that is the way in which errors in the role can be detected. If you ask me whether it was enacted to serve that purpose, my submission is no. But that it can serve that purpose today, that is so.
Let us, sorry, thank you. Now let us take the point further. I would imagine that the two facets of the functional value which you now accept are not ends in themselves. Would you not accept that they actually serve the section 16, or rather 19.2 and 19.3 right to fair elections? Do they not actually enhance or add value or add content to the exercise of that right? Would you accept that or not?
Well, they certainly...
Putting it differently, if you have an inaccurate voter's roll, that may well give rise to unfair elections, CAM tells us so.
Yes.
And if you have fraudulent registrations, as happened in Josini, which the IEC accepts, again you may have unfair elections.
Yes.
And if again political parties are not given an opportunity to canvass using a voter's roll with addresses, again unfairness in the election process inheres there as well. Would you accept all of those propositions or not?
Justice Madlanga, you asked me really two questions. The one is, can those addresses be used to show up flaws in the voter's roll? And if so, is that a good thing? Yes and yes. It can, and it is a good thing.
Taking it further now to section 19 of the Constitution.
May I complete my answer, though? What the section, however, makes clear is that it strikes a balance between the need for addresses for electioneering. Let me say, it firstly says it may only be used for election purposes. It doesn't say it may be used to challenge the roll. So the purpose for which it is enacted was to allow the political parties to use the roll for election purposes, for electioneering. But secondly, the section makes it quite clear that it strikes a balance between privacy and politics and electioneering. And it imposes a strict limitation on the political parties to use it only for electioneering and not for any other purpose. So if you ask me, can it be used for other purposes, and is that a beneficial use? That may be so. But the purpose for which Parliament enacted this section was for electioneering, subject to a privacy restriction, because it recognized that the section invades the privacy of people. Chief,
No. Oops. I beg your pardon. I beg your pardon. Is the other reason not to ensure that the voter, upon registration, votes at the correct district? Because if he or she is voting at the wrong district,
yes,
because the address was not given as prescribed in the regulations, then it is open to the official to refuse to register.
Indeed, but Justice Nkabinde, that duty to ensure that voters are registered in the correct voting district, that is a duty imposed by Section 8.3. And that duty has always been there, and we accept that if there is a breach of that duty, then the registration is irregular. But that is a duty that exists quite independently of the two further questions. Do we have to keep the address, and do we have to give the address to political parties? Those are two subsequent questions. But you are quite right. The first and primary duty is to register people only in the correct voting district.
Look at, I beg your pardon, if you look at the founding affidavit, page 105.
Sorry, page?
Page 105.
105.
105. I think we must look first at page 95. I'm looking at the unpaginated volume. It's paragraph 6. Do you have that document? It is the annexure to the founding affidavit, which deals with the ethics and the affirmation statements.
Sorry, Justice Nkabinde, I thought you said it was the founding affidavit. Is it
The founding affidavit in this court.
Is it an annexure to the founding affidavit?
Let me just have a look at, I think it is MSM 6.
And it is page 105, I think you said.
Yes, the document starts at page, immediately after the founding affidavit, after that list of names.
Page. You said it's page 105.
Maybe I should just take you to the document, Mr. Trengove. It's paragraph 6. It's headed required documents. It says the following documents are required for every eligible voter to register in the correct voting district. A valid green barcoded identity document. B, correct and accurate completion of an REC1 form. C, correct and accurate completion of an RECAS form in cases where the voter does not have a formal address. Now, at 105, this document tells us what should happen if the voter does not have the address. And we know that certain voters did not provide addresses as required in terms of Section 7, read with the regulations. Now, page 105 gives us that document, which is RECAS form. It appears that this document is completed by IEC. That is, in the case where there is no address, the duty is upon IEC to do what's seen to be reflected on 105. Am I correct?
Indeed, Justice Nkabinde, but you must bear in mind that this form RECAS was developed after COME in order to give effect to COME. The IEC jacked up its processes to make sure that it complied with COME, not only in relation to people who have addresses, but also those who don't, and give a narrative description of where they live. And that was why this form was developed, in order to register with the care that COM required. So that is quite correct, but it is a post-COM process.
In relation to Appendix 1 in the regulation,
Yes.
was that applicable prior to come
Indeed.
or after?
No. Appendix 1, the REC form, was the form that's always been prescribed. It required the address to be given, but insufficient provision was made for people who don't have addresses but merely a narrative. And that was why, after come, the additional form RECAS was developed to cater for those people. But you are quite correct in this sense that the requirement that the REC form be completed, that the voter's address be given, and that the registration officer satisfy themselves that the voter's address falls within the right voting district, that duty has always been there, and we accept that.
And if there are no addresses at all, it means the registering official can refuse to register.
If the voter doesn't give any address, or doesn't give an address which is sufficient to satisfy the voting officer that the address falls within the right voting district, then they can refuse registration. But Justice Nkambine, if I may just emphasize again, that goes to the requirements for registration. That doesn't speak to the two further questions. After registration, do you have to keep the address? And secondly, do you have to give it to the political parties when they ask for it under 16.3? Those are subsequent questions. But at the point of registration, you're quite correct, and that requirement has always been there.
Doesn't it follow that if the initial step is flawed, then the subsequent processes will also be flawed?
Yes, that's absolutely so. But it's common cause that the IEC has, as a matter of course, always followed the procedure of ensuring that the given address falls within the right voting district. So if you say, if that process is flawed, the registration is flawed, yes, we accept that. But that is not the case here. The case is not that at the time of original registration, the IEC did not go through that process of satisfying itself that the given address falls within the voting district. The complaint is you didn't keep that address and you don't give me that address today. That's a different complaint. But the evidence
Mr. Trango, you, in response to my question, you gave what I see as a very restrictive interpretation of electoral purposes in section 16.4. Why is it that electoral purposes cannot include checking whether or not people have been registered properly? Because that actually relates to the election process. Why can't that be part of electoral purposes, election purposes rather?
Because the process for finalizing the roll is a process catered for under section 15, and it's a process that is undertaken before certification. I accept that you may use the addresses for a subsequent court case, as was done in this case. So I've accepted that it is possible to use that information to challenge the roll. But if you ask me, for what is the purpose for which Parliament enacted this rule, then my submission is that Parliament enacted 16.3 and 4 not to allow parties to challenge the roll, but to allow parties to use the addresses in their canvassing for an election.
Thank you. I'm not sure what your answer was ultimately to my earlier question on whether what I've referred to as the functional value of the role was. I made the point that is it not so that functional value actually goes to the question of the fairness of elections. Do you accept that or not?
No, with respect, let me just understand it correctly. Of course, it's very important that elections be fair. Of course, the roll has to be accurate and reliable for elections to be fair. And if there are, and the addresses is one of the ways in which one might check whether the roll is accurate. So if you ask me, can addresses be used to ensure that the roll is fair and therefore to ensure a fair election?
Well, there was also the further part or facet or on the functional value, which is to assist you in canvassing. And if there are inaccuracies, including fraudulent registrations, that affects that. So in that context, with that context in its totality, would you accept or not that the functional value does bear relevance to the fairness of the elections?
I'm afraid I can't do better than to say addresses can be used to check the roll, and an accurate roll makes for a fair election. But what we're debating at the moment is the proper interpretation of sections 16.3 and 4. And for the proper interpretation, one looks at the purpose for which that section was enacted. And we submit with respect, the purpose for which it was enacted was not to check the roll. The purpose for which it was enacted was to accommodate the political parties' electioneering.
Let me move to my next point then on the basis of an assumption. Assuming that we were to make a holding that there is this connection, there is a connection between the fairness of the elections and what I refer to as the functional value.
Yeah.
Would you not accept that this, or rather section 190, subsection 1B of the Constitution becomes relevant, and that is the section that says that the Electoral Commission must ensure that elections are free and fair. And this is not subject to any election, or rather any legislation. This comes directly from the Constitution itself. And unlike paragraph A of subsection 1, which refers to national legislation, this is a standalone obligation on the IEC.
Absolutely.
Yeah. So based on the assumption that I say let us move from, would you accept a proposition that says the obligation on the IEC to have addresses on the voters' roll would have been an obligation that was there pre-December 2003?
No, with respect not. There is nothing in the Act or the Constitution that says you can only have a free and fair election if the addresses of the voters are given in the voters' roll. The IEC always has the duty to ensure free and fair elections, and free and fair elections can only be had on a voters' roll that is substantially accurate. But the mechanism by which one gets there, and whether you include voters' addresses in the roll or not, is not fundamental to the question whether the election is free and fair. Otherwise, you would have to hold that our elections have never been free and fair because there has never been such a voters' roll. And no suggestion in the legislation that one requires those addresses in order to have a free and fair election. At best for our opponents, one may say, addresses are a nice to have because it promotes an accurate roll. But you can't for the moment suggest that it is a precondition for a free and fair election.
I thought we can turn attention to something else that just bothers me. If you could ask your Leonard Jr. to give you the Municipal Electoral Act.
Yes, I have some.
You have it.
I have some of its provisions available, Deputy Chair.
I know it predates the 2003 amendment, but look at its provisions, Section 7. Parliament tells us who may vote in municipal elections. And look at 7.2.
Yes.
What should we make of that?
Well, I'm not sure what you mean. What it says is, if somebody arrives at the polling booth and their name is not on the list, but they claim to have properly registered, then there's a process which allows them to vote if they make an affidavit and satisfy the election officer that they are entitled to vote.
Yes, but 7.1 makes quite plain that you vote only in the district where you are registered.
Absolutely.
And that your name would appear in a certified segment of a voter's roll.
Yes.
For that particular voting district.
Yes.
If you claim otherwise, then you have to provide a range of things, and Parliament lists them.
No, not if you claim otherwise. If you claim that you should be on the roll, but
Yes.
you're not.
Yes. If you claim you should be on the roll, but you're not,
Yes.
then you have to provide a whole range of things.
Yes.
And significantly, this, without doubt, includes the obvious thing, the place where you ordinarily reside.
Yes.
Now, talking about functional value, isn't it quite plain in municipal elections in particular? But you can't have fair elections unless you vote in the district where you are properly registered.
Indeed. Absolutely. But
and that you determine only by determining where one is ordinarily resident.
Absolutely.
And again, that you determine by being furnished with an address where one lives.
On registration, yes.
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 But isn't that, you've debated several functional values, but isn't that the obvious functional values that we can't hold municipal elections? And that's what we are seized with here, in the Kham case, where there is no meticulous determination of where people reside.
Now, with respect, Deputy Chief Justice, one conflates two things. The first is you're absolutely right, that on registration, the address must be given, and the IEC has a duty to check and ensure that that address falls within the right voting district. On that score, there is no doubt, there is no debate, and I agree that the fairness of the election depends on the proper discharge of that duty. And that was why this court held in Kham, those elections were flawed because more than 1,000 of those voters had been wrongly registered. There was an error made at the point of registration. There's a separate question. Having completed that registration, and assume for the moment, one must assume a regular registration, is there a duty to keep that address and to give the address to the political parties when they ask for it? But that is a separate question. If you haven't kept the address, you may have failed in your duty to keep the address, but it doesn't retrospectively render the registration invalid. So that, yes, it is fundamental that people be correctly registered, but no, it is not dependent on whether the address is kept and included in the roll that is disclosed. Chief Justice, I have overshot my time allocation.
Before you go, Mr. Vimpru, I just want to understand what you have given us in volume 5, which is a table that is in paragraph 66.2 in page 421 of the record.
Page 41 of the papers.
Yes.
May I just turn it up? 421.
Volume 5. Now, I think we have now established that Section 16.3 requires that any voter registration from 2003 must include the addresses of voters where they are available. And the IEC is obliged to record the addresses of those voters where they're available for purposes of accommodating political parties. If you have regard to the table, it is notable that a significant number have registered since 2003. Am I correct?
Yes, Justice Kampepe, but you must...
And of the voters who have registered subsequent to 2003, there were no addresses which were captured of those voters. Now, I cannot understand why there has been no concerted attempt on the part of the IEC to attain addresses over the following 13 years. How is that possible? Can you explain it to me?
Yes, Justice Kampepe. These are people who don't have addresses. These people don't have addresses.
And
remember,
in order to ensure that the integrity of the elections are maintained, is there anything anywhere else which explains how the IEC was able to be satisfied that they are ordinarily resident in the voting districts in which they registered? No. If that should be a problem raised by the political parties, how would the IEC assist the political parties in that respect?
Justice Kampepe, these are, let me just recap. You'll see the total of these people is 7.8 million. And you'll remember that at the time the papers were filed, the numbers were broadly that there are 24 odd million voters registered altogether, of which about 8 million don't have addresses at all, and these are they. And then there were another 8 million who are people who have addresses, but their addresses are either incomplete or have not been properly recorded. So there were 16 million people in all for whom there were no or incomplete addresses. But of those people, and in relation to 8 million of them, the addresses simply had not been kept since the time of their registration, and for that reason was not on the voters' roll. But in relation to these people to which you refer, they are people who don't have addresses. They are people who come into the registration to the IEC and say, I don't have an address. I live in such and such an informal settlement next to the spaza shop under the water tower. Here on your map, that is where I live. And then the electoral officer says, show me on the map, and as long as the electoral officer is then satisfied that this person lives in the right voting district, they are then registered. But they don't have an address. There is nothing that one can put in the vote, that one can sensibly put in the voters' roll, because they were registered on the basis of a narrative and an explanation of where they live. And I don't understand our learned friends, for the respondents, to say that addresses must be disclosed for those people who do not have addresses, who merely satisfy the electoral officer by a narrative description that they live within a certain voting district. We all accept that there are 8 million people of that kind who do not have conventional addresses, who can only satisfy the IEC by a narrative description that they live in a particular voting district. And we don't understand our learned friends to contend that that narrative description must in some way be incorporated in the voters' roll. So they are the uncontroversial voters without addresses in the voters' roll. The controversial voters are those people who have addresses, but whose addresses aren't there because they historically weren't kept. Thank you.
Mr. Trango, I'm sorry. You've been on your feet for almost 2 hours. Could I just sneak in two quick questions?
Certainly, Justice Chapman.
Can I take you to volume 3, page 268?
Can you tell me what document it is? Because my papers
It's the answering affidavit deposed to by the Chief Electoral Officer.
Page 268.
Of volume 3.
Yes, I have it.
At paragraph 24.2, it seems to me that the Chief Electoral Officer did not understand section 16 sub 3 to be imposing the obligation to seek and obtain addresses upon registration since December 2003. Because here he says, after 30 November, that is the date of delivery of the CAM judgment, the Commission has this obligation, which suggests that from December 2003 until November last year, the Commission did not understand 16 sub 3 as requiring it to ask for addresses, keep them, and provide them to political parties and candidates when elections are held.
In fact, just to add to my brother's question for further clarification, it seems to suggest that the requirement to record addresses never used to exist until the Constitutional Court made it a requirement. Correct.
Let me just make this clear. There are two questions there, and it's important to distinguish between them. The IEC says it has always known that it is necessary to obtain the address from an applicant for registration and to ensure that that address falls within the right voting district. So on the duty, that's the duty under section 8.3 of the Electoral Act. On the process that has to be followed on registration, there has never been any doubt. It has always known what that duty is, and it says, in evidence which is substantially uncontradicted, that that has always been its general practice. What you referred to is the question whether it appreciated that since December 2003, you are required not merely to get the address for registration purposes, but that you are then required to keep that address and to put it on your system and give it to the political parties. That issue, you're quite correct, is not properly canvassed on the papers. They don't say, we realize that there was a duty to do so, and for that reason consistently did so since December 2003. But that issue, nobody has accused them of not keeping the addresses since that date. So that issue as to what their practice was since December 2003 is simply not canvassed on the papers and therefore unclear.
My question is premised on the statement on paragraph 24.2, which says, after 30 November, the Commission has an obligation. And as I understand it, it's the same obligation that is imposed by 16 sub 3.
Indeed, but that's an obligation to keep and disclose addresses. That's got nothing to do with the obligation to get the address at the time of registration to make sure that the person is correctly registered in the right voting district. And
I'm sorry, Mr. Trunk, I'm sorry, my brother is still busy with you, but I'm saying it also brings in an unfortunate understanding of the judgment of this court, and that is the impression it inadvertently, and I use the word inadvertently deliberately, inadvertently suggests that before this court's judgment, there was no obligation to do that. It is this court that caused problems for the IEC. 16.3 never used to require the IEC to have address is recorded. And that's unfortunate, because it's not this court that came up with that, it is the legislation itself.
Chief Justice, yes, you're right. The question how the IEC understood and applied that section is never squarely canvassed. What they do say is that after come, we jacked up our processes, we retrained our 51,000 election officers, we put out a new manual, we developed a new form to make sure that we comply with paragraph 5C of the come judgment. And you're quite correct on that score. But what was not canvassed, because it was not raised by either side, is, well, what did you do between December 2003 and the come judgment? That issue is just never canvassed. Justice Jafta, may I just say that what you mustn't infer from the paragraph that you've read is that the IEC was not fastidious in making sure that people were registered in the correct voting districts, because that issue is squarely addressed and canvassed and is substantially uncontradicted. And that evidence is quoted in our heads of argument from page 8 in paragraphs 21 and 22. So the fact that they might not have understood 16.3 doesn't imply that the registration was in any way flawed or deficient. They might, at worst for them, might have been deficient in the duty to keep those addresses and put them in the voters' roll since December 2003.
My second question relates to the debate that we had earlier on with the Deputy Chief Justice about the understanding of the Electoral Court's judgment, the two paragraphs that you referred us to. And my question is, shouldn't really we understand those two paragraphs in the context or the facts of the case? In CAM, there were about 1,040 irregularly registered voters, which the IEC admitted were irregularly registered. Here again, we have a similar situation. The independent candidates raised an issue in respect of about 4,000 voters. The Commission itself says, I noted that about 4,500 voters may be affected by that. Of that, we have called upon 1,600 voters, given them notices because we have realized that they were registered at incorrect wards. We have called upon them to show cause why their names should not be removed from the roll, which suggests then that even here, on the facts of this case, there are some irregularities relating to about 1,600 voters, which the IEC itself says they were not supposed to have been registered, their names should be removed.
Justice Jafta, I'll have to check the facts because those are not how I understand them.
Okay.
Let me say this. My learned friend, Mr. Marcus, will deal with a suggestion that there was, in this case, voters who were irregularly registered, and I will leave that argument to him. I understood that suggestion to be made in relation to 500 voters and not 1,600, and I'm not sure whether you or I might be confusing, might be confusing the corrective steps they took pursuant to COM. But what I address, as opposed to my learned friend Mr. Marcus's address, what I address is the core of the case. The core of the case had nothing to do, or was not that voters had been irregularly registered. The core of the case was that there are 4,000 voters without addresses. And the argument was that if a voter is on the roll without an address, then his registration is invalid. And that is the argument that the Electoral Court accepted, that merely because the voter is on the roll without an address, COM says, according to the understanding of the Electoral Court, COM says those registrations are invalid and therefore should be removed from the roll. That was the ratio of the Electoral Court judgment.
I'm sorry. For the benefit of Mr. Marcus, can I take you to page 262 of the same volume, where the Chief Electoral Officer describes or defines the core complaint? (262), paragraph 7. He says the core complaint of the applicants is that the Commission has not furnished a voter's roll that complies with Section 16 sub 3 of the Electoral Act. In the result, charged the applicants, it has been impossible for them to verify whether the voters whose names appear on the certified voters' roll and are indeed ordinary residents in wards 1, 4, 11, 12, 18, and 20 of Tlokwe, or that they are eligible to vote in those wards.
Yes.
So that's the core complaint.
Yes.
And the IEC, in its letter on page 286 of the same volume, at paragraph 8.10.5, says, after a thorough investigation, 1,601 of the 4,531 persons were confirmed to be located outside their voting districts.
Yes. Well, my learned friend will deal with that issue.
Okay.
But let me say that the paragraph that you read, as opposed to the paragraph that you read from the affidavit, makes the complaint as we understand it. It is a complaint that says there are people on the roll, 4,000 people on the roll, without addresses, and that's a violation of Section 16.3 that says you must give us their addresses. It doesn't say that that there was any other irregularity attaching to their registration. And that is, Justice Jafta, where we part company with our learned friends. Their case, upheld by the Electoral Court, is that where there is a name on the list without an address, then the registration is invalid. And that is so only if 16.3 means that the IEC was obliged to go back and find the addresses of the 18 million. It's only on that premise that one can make such.
Sorry to interrupt you there, and I'm indebted to the Chief Justice. Mr. Trengo, I understand the ANC's argument that Mr. Marcus is going to present to say the COM order has to be interpreted in the light of the shenanigans. Therefore, those 4,500 addressless voters had to be followed up in the context of COM, and therefore there's no question in COM of disenfranchising people or going back to pre-2003 or even before 30 November last year.
No, indeed. And that is because COM found and accepted and conceded that there were irregular registrations. It triggers, of course, a conclusion not only that those people are ineligible to vote, but that the roll is unreliable and should be cleared. But that all
Sorry,
of that,
by supplying addresses.
By supplying addresses. But all of that flows from the fact that there were 27% of the new registrations were conceded to be irregular registrations. That didn't flow merely from the fact that there were people on the roll without addresses. Indeed, in COM, there were no addresses on the roll whatsoever. But the court didn't say for that reason everybody on the roll has been unlawfully registered.
Well, Mr. Trengova, I need clarification on a few things. I think at least twice you have alluded to the entitlement by political parties to the voters' roll that has addresses. I wasn't too sure whether that is intended to suggest that, by the way, these are independent candidates and therefore not entitled to have access to this which the legislation specifically makes available or provides for in relation to political parties. Are independent candidates entitled, or do you take a particular position?
Chief Justice, may I give two answers to the same question? The first is this: I live in a world in which this court is always deemed to be right, and the presumption is irrebuttable. So that, yes...
Even if it might be wrong.
Well, in my world, the court is never wrong. So, and certainly paragraph 5D of its come order says that the section 16.3 also applies to municipal elections. If you were to ask me whether you should consider or reconsider that conclusion, then my submission would be, with the greatest of respect, that the conclusion was based on a premise that the section applies to municipal elections, and that the premise was never interrogated or consciously determined. But there are a variety of reasons why we submit that it doesn't. And may I just say that...
Shouldn't we leave it on the basis that a decision has been taken and nobody has appealed to this court against its own decision?
Certainly we would never... we would accept.
Shouldn't we leave it there? Because unless you really want to make a submission on it.
Now, let me in seriousness say this. We submit with the greatest of respect that the premise of that finding was not correct for a variety of reasons. Both Section 3 of the Electoral Act and Section 3 of the Municipal Electoral Act says that the Electoral Act only applies to national and provincial elections, generally speaking, and applies to municipal elections only if and to the extent that it is made applicable by the Municipal Act. Now, the first fact is that the Municipal Act never makes Section 16.3 and 4 applicable to municipal elections, so that on the face of it, the sections are not meant to apply to municipal elections.
The position is astounding.
May I?
We don't have to debate it now. It's totally astounding. The definition of voters' roll refers to the same definition as in the Elections Act, and it's clearly incorporated by implication. But we don't have to debate that. I mean, the matter is settled.
Yeah.
Your views may be interesting, but I think the matter is settled.
Well, then I have no further submissions to make.
Let me move on to the next question. I'm sorry I provoked you to say, to mention something but didn't allow you to go all the way. The mistake is mine.
No,
I apologize to you, Mr. Tremble. Now, the available addresses or addresses available to the IEC. Focusing only on the ordinary grammatical meaning of that phrase, do addresses or physical addresses become available at the to the IEC at the time of registration, or even if they are availed to the IEC at the time of registration, should 16.3 be understood to mean that they may well be made available to you, but if you choose to push them aside or burn them so that they are no longer available to you, then when political parties come and say, give us the national voters' roll that has physical addresses, it then becomes open to the IEC to say, you know what? If you care to know, when they registered, they gave me the addresses, but I didn't need them. So they are not available to me. I can't give you the national voters roll that has physical addresses because I chose not to record them. So I'm seeking to understand, is it for the IEC to choose whether or not addresses are to be available, or should availability be understood within the context that there are many settlements in this country, some occasioned by poverty, and therefore people find themselves in a space where their homes are without addresses, and therefore, if you don't have a number, not even a street number, a street name, your address is not available to the IEC at the time of registration. And even if the IEC were to come back to you later, your address would still be unavailable to the IEC because you simply don't have a verifiable a verifiable address, in the sense that there is no number or street name. What does it mean?
Chief Justice, we submit with respect that it says one thing expressly and it implies a second thing. The thing that it says expressly is you must disclose the addresses where available. And we submit where available there means, it says where available, yes. And we submit that where available there means if you have them. We accept that it also implies that you must from now on keep all the addresses given to you. But it doesn't say or imply that you must find the addresses, even if you, the historic addresses, even if you no longer have them.
If as at, well, from, with a fact from December 2003, you are the IEC, here is section 16.3. It says, you know what, when political parties approach you and they want the national voters roll, give them the address, I beg your pardon, the roll that reflects addresses where available. As you register potential voters since the coming into operation of the amendment, is it open, is it to be understood to ever be open to the IEC to say, you're giving me the address, well, I'm not going to record it. And if that were to be the attitude, how then would addresses ever be available if the IEC were not required to record them?
No, Chief Justice, you're quite correct. We submit that since the enactment of 16.3, there's a duty on the IEC, an implied duty on the IEC, to keep the addresses given to it on registration. And that was the duty that this court's order recognized in paragraph 5C. It's precisely that duty. But in conformity with the order, we submit that that is a duty to keep the addresses given to you on registration. That's what the order says, and we submit with the greatest of respect. That order accords with the proper understanding, proper interpretation of 16.3. It does not say or imply that you must also go back and find the addresses of the people already on the roll.
5D reads of the order, it is declared that in all future municipal elections or by-elections, the Electoral Commission is obliged, in terms of Section 16.3 of the Electoral Act 73 of 1998, to provide all candidates in municipal elections on the date on which they are certified with a copy of the segment of the National Voters Roll to be used in that ward, in that election, including the addresses of all voters where these addresses are available. What obligation does 5D impose on the IEC in relation to the addresses? Is it to ensure that since 16.3, apparently requires, just to accommodate your viewpoint, apparently requires of the IEC to have recorded physical addresses since December 2003. Going forward, in the elections to come, the IEC would be expected to have complied with 16.3, or what does it mean?
No, it means exactly that, and you're quite correct.
Yes.
What it means is you must disclose all the addresses where available. We submit where available mean all the addresses you have, and that must be read together with the implication that from December 2003 you must keep all the addresses given to you, so that we accept that that duty includes a duty to disclose the addresses of all those people who registered from December 2003.
Now, purely on the basis that there is a need to avoid any further embarrassment by the IEC. I mean, the IEC has maintained an admirable credibility, I think, over the years.
Yeah.
Just to avoid giving anybody a reason to question the effectiveness of the IEC and its capability to discharge its constitutional mandate properly. Does 5D not impose an obligation also on the IEC to go back so far as practicable and check in relation to all other?
No, with respect, Chief Justice, COM simply didn't consider that question.
Yes.
It didn't consider, it's simply that where available in 5D correctly recites the language of the section of 16.3, and it is absolutely correct as far as it goes. What COM never considered is what that means. We accept, so that COM doesn't guide us on the meaning of that language. We accept that it means at least that the IEC must, since December 2003, have kept all the addresses of new registrations, and that those addresses have to be disclosed under 16.3. The question that COM doesn't answer is whether the IEC was also obliged to go back and find the addresses of the 18 million who were already on the roll in December 2003. And frankly,
after those who were enrolled after December 2003,
no.
What do you understand it does it require? Does 5D require of the IEC to make sure that those are properly registered?
I'm not sure that that is what 5D says, but we accept that the duty under 5D is a duty that must be read with the implication arising from 16.3, that all the addresses must be kept from December 2003. So 16.3 and 5D read together both say that you must disclose all the addresses of all the voters that you have, and you must at least have those addresses of voters who registered since December 2003. That much we accept.
On the assumption that the IEC is expected as a time of the certification of the national voters roll to reflect known addresses, and dealing with a question that it's a near impossible task to accomplish, what is to be done?
No, but
What can be done? Maybe we should start there.
It depends on what you mean by known addresses, because they already reflect all the addresses now known to the IEC.
Let me give an example then.
But if you mean addresses disclosed to them in 1999, which they have since then lost, then that's a different issue.
No, that's not what I mean. This is what I mean. Maybe my first question should be prefaced with another question. How long does it take that South Africa to conduct a census? Generally, do you have an idea? Is it a year? Is it 6 months?
It's a question of months, but I'm not sure how long.
And as I understand it, stats Stats SA, according to the papers before us, is one of the agencies in a committee roped in, I think by the minister, to help track down the addresses of those who are registered without addresses.
I would imagine.
That's my understanding of the papers before us. Now, if Stats SA is able to do this within months and is available and willing to assist the IEC, why does the IEC need 4 years to accomplish the same task?
Chief Justice, let me say, I can merely tell you what the IEC says, why it would take them so long. I don't understand Stats SA to have a reliable list of addresses of everybody. In fact, one knows that they do their population counts often on aerial photographs and extrapolations of samples. So the suggestion that they have a reliable list of addresses of everybody in the country is not accepted by my client.
I don't know how I wanted to know whether they do it in months, because I know they do visit us in our homes. They even ask you about your salary. So I wanted to find out if they can do that within months. Yes, they interviewed me several times. If they can do that within months, and we're trying to make sure, all of us, I believe, that the elections proceed as planned, so far as possible.
Yes.
If they can assist the process, and this thing can be accomplished within months, does it not then create a possibility that what we thought could only be done after 4 years might be done much earlier?
Chief Justice, my clients who are the experts in this area say no, and they in fact deal with it in 2 places. They deal with it in their founding affidavit from page 428 in paragraphs 74 and 75.
I've seen that.
But the more interesting part is in the reply, where they also address where they also deal with the criticism of their prognostication. In reply, they deal with it from page 897 in paragraphs 15 to 17. And let me just say this, that one thing that I understand from my client is that there's a correlation between time and money. And one can't simply say to them, do it more quickly, because more quickly requires more resources and it is more costly. So one would always have to strike a balance.
Because it may impact on the preparation for the elections, I suppose.
No, but indeed. And we all agreed that this is an important project, but you just had a little sample of these 2 weekends that they organized that cost hundreds of millions of rands. To imagine how much it will cost to recover the addresses of the outstanding 12 million people. So that we submit with respect that we have their best estimate of the time it will take them, and that is at least until 1919. If the court is not satisfied with that best estimate, then the only other alternative would be to make a let's see how we go order, which says take certain steps between now and the end of next year and report back, and we will monitor you as you go along. But what you can't do with respect is to make an order inconsistent with what they say is their best estimate of the best they can do, simply because we as lay people are critical of their assessment, because that may be ordering them to do something which they have said they can't do and which they may turn out to be unable to do.
Well, the bottom line is always this, though, Mr. Trengove. Whatever a party's position is, it remains the responsibility of that party to articulate its position clearly and fully in court, rather than give the court an incomplete story, and when the outcome is not favorable, to then give a fuller picture outside. We need a fuller picture here, so that it can guide us as lay people to arrive at a correct decision.
I submit with respect, if you look at their paragraphs 15 to 17 of their reply, that that's exactly what they do. But if the court is not satisfied, or if there are further matters that the court wishes to interrogate, then by all means, my client offers its full cooperation. What I submit would be irresponsible to do is simply to cut their estimate by half on the basis that they must, on some basis or other, achieve what they say is impossible.
Irresponsible from which side?
No. All I submit is one shouldn't arbitrarily depart from the estimate that they make.
Talking about responsibility, are you still urging us that we run the 2019 elections on what might be a defective voters' roll?
Yes.
Does the time extend beyond 2019?
They have said that their best estimate is that they will be able to find all the addresses by the end of 1919, and that's why they have asked for time until June 2020.
What is the estimate in relation to the obvious obligation that sits in Section 16? What about addresses which they're obligated to keep and record from December 2003? How long will that take?
They have not...
Understand, and we're talking about historical role. Whether it is before us or not, we will decide. If it is before us, is one debate. If it is not, what probably will be in any event before us is certainly the duty from 2003. How long would they rectify that?
That issue is not canvassed on the papers, so it's not clear that those addresses aren't already on the roll anyway, or if they're not, how long it will take to get them. So, Deputy Chief Justice, I simply can't answer that question because that issue was never canvassed on the paper.
The calculation, you remember the question from my sister Justice Khampepe, of the 18 million much vaunted everywhere in the public space, includes registrations after 2003, doesn't it?
No.
No.
No. Those were the people who were already on the roll in 2003.
The roll by 2003?
Yes.
If we took the view that there was a duty, in fact we haven't come, from December 2003, would the IC need any time to rectify the roll from 2003?
That issue is not canvassed on the papers, so we don't know whether the roll doesn't already include them, or if it doesn't, how long it would take to get them.
Well, you might have to get instructions on that, because the debate does drift in that way, Mr. Trangove.
No,
for instance...
Yes, I shall do so, but it would be an issue that would require careful consideration, because there's both a determination of what is lacking, if anything, and then an assessment of what it will require to supplement.
I'll show you what my difficulty is. If we were to take the view that there's no basis and reason for reopening the details currently recorded up to 2003, and that there was no such duty, assuming we go along with you on that, then the only question would be from December 2003. And suddenly the moratorium beyond 2019 takes a different picture. And that is why I am urging it upon you that you take instructions on the matter, and we might hear you on...
Certainly, Deputy Chief Justice. May I just say this, though, that was not the case made in the Electoral Court or on the papers in this court. It would be a new case, and I will certainly take those instructions, but that is not what this case has been about.
Mr. Trangove, I mean, a bit of sophistry there. You see, in Kham, the decision is based on the obligation that pre-exists set by Parliament in Section 16(3) and 4. So we didn't create new law. Chief Justice made the point over and over again. We articulated a duty that pre-existed. So if we are going to deal with this section at all, we may very well hold that the duty was always there from 2003 December.
But that's uncontroversial, Deputy Chief Justice. That's
Yes,
what we
and the
accept
question
that.
is, then the IC would not need any time at all to remedy the voter's roll. Is that right?
No.
If the cut-off point is December 2003.
I'm afraid I can only say, as I've said before, that issue is not canvassed on the papers, and for that reason I don't know what the answer to that question is. My impression is that they did keep and record those addresses, but how fastidious they were, how thorough they were in doing so, I simply don't know, and I can't give you any assurances. So if your question is that if you postulate that they were not required to go back to find the addresses of those already on the roll in December 2003, but they were required to do so since then, and you ask me to what extent did they do so, and if not, to what extent, how much time do they need to complete that task, then I simply don't know, because those issues aren't canvassed.
It goes to the direct access application, so it would be helpful to hear your clients on that in reply, or they may seek leave to give us the facts in another way. Thanks.
I'll certainly ask the questions, Deputy Chief Justice.
Before we adjourn, because we're going to adjourn now, and this is for all counsel, we still have to hear 6 others, and it's already 12:30. So we may have to cut down on the lunch hour. Just check whether 30 minutes would be enough for lunch, and also what time can we break for lunch. We never used to adjourn for lunch in cases like this in the past until I was advised that not everybody can be without food. So reflect on that and let us know, and also if you could really narrow down on issues that each must deal with. We don't have to repeat what has been traversed before we come on to speak. Otherwise, the court will adjourn until just after 1:15. how many of those whose addresses they had whose addresses they had, their addresses were affected by the mishaps?
No.
So as to be able to determine whether this problem can be resolved within a matter of months or not. Because you're only able to say it will take long if you know whether it's 5 people or 500,000 or 2 million people. Is there a sense of how many people are affected who had disclosed their addresses?
Chief Justice, may I go back to the table that Justice Kampepe referred to at page 422 of the papers? Because it gives us the numbers of people who have been registered since 2003 who do not have addresses. And you'll see they are the people registered on that table at 422 from the year 2004. Now, the best that my client can do as they stand here is to say that by far the overwhelming majority of those people are people who do not have addresses. But they can't say precisely what numbers are the people who do not have addresses on the one hand and those whose addresses they've lost on the other. That is except to say that the former category is by far the overwhelming majority, they can't be more accurate as they
Well, the number of those registered, and I'm just doing a rough estimate, having looked at 2000 to 2002, the number from 2003 is about just over 7 million people.
Well,
yes, because you have 355,000 plus 15,000 plus 24,000. That's certainly much less or lower than the 800,000 that stands there beyond the 7 million.
Yeah, but the 7 million includes, on the previous page, about 2 million people.
As well. I'm sorry. I made a mistake then. I beg your pardon. So would it be roughly
it's 5 million?
Roughly 5 million. Now, do we know more or less, without committing itself to anything, from the IEC's perspective, more or less, how many of the 5 million are without addresses and in which provinces? KZN affected by fire, which other province affected by what?
No, I'm afraid I don't. What they told me is that they are unable to tell you today what that number is as they stand here. They can't do better than to say that they know for certain that by far the overwhelming majority of the 5 million are people who do not have addresses. But they can't be more accurate.
Okay, but there was an incident in KwaZulu-Natal.
Let me say, I didn't ask them for a catalogue of incidents.
Yes.
In telling me why certain addresses had gone missing, they say, for instance, there was an incident at a warehouse in KZN which was either flooded or burned down. And so I mentioned that example, but I didn't ask them to list all of the causes of lost registration forms. That certainly can be given, but my client would need some time to collect its information and give it to you if you so wish.
It would, I don't know, subject to what colleagues have to say, it would help a lot, because the more information you have relevant to the decision you have to make, the easier it will be to come up with a decision that is backed up by facts. The difficulty, as I said earlier, Mr. Trengrove, is to have an incomplete account of the problems or the challenges that confront the IEC, make a decision, and subsequently be accused of having been unfair to the IEC when you are not favored with the information you require to arrive at a decision.
No, certainly, Chief Justice. If I understand then what you wish them to give you are the causes of addresses going missing since 2003.
it would help to have that information, and also, say incidents where, how, and is it the entire province, is it a region? And obviously when these things happen, a fire and so on, you'll have them recorded. In the media, can even attach some media clips to say IEC warehouse with records raised by fire or something, just to give us a sense of what's happening. Obviously, the other parties, I'm sure, may have to respond. But what I say to you is subject to the attitude of your colleagues when they rise to address us.
Thank you, Chief Justice.
Yes.
Before you sit down, the other thing that I didn't quite follow well, where addresses were provided, but were not recorded.
Addresses were?
Where addresses were provided, but were not immediately recorded, but only recorded months after the elections. But aren't the addresses necessary for the voters' roll that's given to the parties? Do you understand my difficulty?
Yes.
In other words, 16.3 tells us that you need addresses and they have to be furnished to political parties.
Yes.
If you record them long after the elections, I don't quite follow how.
No, I understand that question, and I, however, do not have the answer. I didn't ask that question, and I shall do so.
It's difficult to understand because my limited understanding says it is not on the day of the elections that you record people's particulars. There's a period such as the one we have passed through when we all invited to come and verify the correctness of the information on the voters' roll, and new would-be candidate register their names. That's when you capture the information, and that's when you can, if you are able to, factor it into the voters' roll to be verified in due course. So I don't understand, you record them, they are here, they are available, but you will only wait for the elections to come first, and thereafter I don't understand it. So clarification would help in due course.
Yeah, let me just explain how I understood it, but it doesn't answer the Deputy Chief Justice's question, and that's this. There is invariably, before certification for an election, a huge registration drive. That registration drive attracts a lot of registrations. You'll see in that list, there's 1 year where more than 1 million people are listed. That is in a registration drive in the run-up to an election. And they say that those people are then registered and their forms are kept. But because there are so many of them, and because the IEC is so heavily engaged in the run-up to the election, those people only get recorded on the system after the election is done. It raises the Deputy Chief Justice's question, how do you reconcile that with your duty to give the political parties a role with the addresses if those addresses aren't immediately recorded? Well, I'll have to get an answer to that question.
Well, what I don't understand is, as you register those new would-be voters,
yes,
as you insert their particulars in the roll, why leave out the address if the plan is to also include the addresses there as well? I don't understand it, but anyway, that's by the way.
Yeah, I'll certainly raise that question, Chief Justice. Thank you, Chief Justice.
Thank you, Mr. Trengove. Mr. Marcus? Do you need 10 minutes?
If I'm afforded my immunity, I undertake to cut down my argument to not more than 20 minutes.
All right.
Thank you. Chief Justice, with your leave, I propose to address 3 issues which flow directly from the appeal from the Electoral Court, and they go to the correctness or otherwise of the Electoral Court's decision. The first issue concerns the proper interpretation of the word available in section 16.3 of the Act. The second is merely one additional submission to that already advanced by my learned friend concerning the proper interpretation of the CAM order. And lastly, we will address the question of what was the actual complaint which served before the Electoral Court and what was it that they were called upon to adjudicate. If I can then turn to the first of those three issues, and it's the meaning of the word available. The debate between the parties before this court really turns on two possible meanings of the word available. On the one hand, there is the interpretation which the IEC advances and which the ANC supports, and that is that available means available to the IEC on its record-keeping systems. In other words, the addresses which it actually has on its record-keeping systems. The competing interpretation, which is advanced by some of the parties before the court, is that the word available means that the IEC is under an obligation to provide a roll with the address of every registered voter who has an address. So available in that context and on that argument means where it objectively exists. In support of the interpretation which we advance and which the IEC advances, we have found an authority which we submit is of analogical assistance to this court. It's the case of Reynolds Brothers versus the Chairman Local Road Transportation Board, and it's 1985, volume 2 of the South African Law Reports, page 790, Appellate Division. And it concerned that phrase contained in Section 18 of the Road Transportation Act, and leaving out unnecessary wording, it said that in an application for a road carrier permit, the board shall not grant any application unless it is satisfied that it would be unreasonable in the circumstances to expect the applicant to make use of any available railway service for the conveyance of goods to which the application relates. Now, I don't want to get into the facts of the case because obviously the court will read that for themselves, but the issue is really whether a railway depot some 100 kilometres from the mill in question was an available railway service. The board had refused the permit, the company took it on review, and the High Court had taken the view, in rejecting the review, that there was no warrant for concluding that the legislature intended that the railway service should be immediately or readily or conveniently or economically available, or that any particular degree of availability was intended. And it was that decision which was reversed by the Appellate Division. And the critical passage which we commend to this court is at page 804, where the court said this: the legislature did not intend that railway services were to be regarded as being available, regardless of their distance from the place of business of those for whom the services were to be available. In case of doubt, a realistic rather than a highly unrealistic concept of availability would be attributed to the legislature. And that, with respect, is the approach which we submit is the appropriate one in a case such as this. And so we therefore submit on that point that available means the addresses which the IEC has on its system. If I could then turn to the second point, which turns on the proper interpretation of the CAM order. As we understand it, several of the respondents argue that the CAM order imposes an obligation on the IEC to produce a voter's roll with addresses to the extent that they are available of persons who, for example, registered prior to the 2003 amendment, and indeed to those who registered thereafter but before the CAM order. Purely by way of example, the DA makes that argument at pages 23 to 24, paragraph 23 of their heads. What we would submit would be of assistance in the proper approach to what the CAM order says, is to have regard to paragraph 6 of the order, because that is the operative order which regulates the prospectivity of the orders in both 5C and D. And what we would with respect point out is that paragraph 6 of the order is in two parts, separated by the conjunction and. It reads, the orders in 5C and D are prospective in their operation from the date of this order and do not affect the validity of any election or by-election held prior to the date of this order. Now, it is true that those two parts have been conjoined in one order, but we submit that their effect would have been identical if they had been separated in two separate orders. And we would with respect submit that the first part of the order, which speaks of the prospective operation, stands quite independently of the second part, which turns purely on the effect of the order on the validity of elections which have already taken place. What we would submit, flowing from those two submissions, is that the Electoral Court misinterpreted and therefore misapplied the court's order, this court's order in CAM, firstly, by finding that Section 16.3 obliged the IEC to provide the candidates with all the addresses of registered voters and not only those that had been entered on the IEC systems. And the second error we submit the court made was by extending the IEC's obligations to obtain particularity of historically registered voters despite the prospective operation of Order 5 by virtue of paragraph 6 of the order. What we would submit is that that error, of course, induced a wrong outcome. But in order to get to that point, which is the third of my submissions, it's critically important we would submit to properly identify the complaint which served before the Electoral Court. Now, as we see it, the core complaint was that the voters' roll which had been supplied to political parties did not record the addresses of some 4,160 voters whose names appeared on the roll. And that appears to be indeed really the only issue which was advanced, if one has regard to the way it was formulated by the applicants in the Electoral Court at paragraph 3.4 in volume 1 of the record. It says the first respondent is in practical terms and by virtue of the belief and decision in 3.3 above of the view there is no duty or obligation on the first respondent to provide the applicants with the addresses of an extent of 4,126 voters that have been registered to vote in the Tlokwe by-elections and of whom no physical addresses appear on the certified roll.
Please give me that reference, Mr. Marcus.
It's in volume 1, it's page 15, and it's paragraph 3.4, which would also need to be read with page 19, paragraph 4.8. There we are told that on the 16th of February we instructed our attorneys of record to record the results of the investigation as an official complaint with the first respondent. This was done in a letter of even date attached here to his PM3. In the said letter, we recorded various complaints, but of relevance to this application, stress that, is the fact that we detected and indicated in paragraph 4 thereof an amount of 4,160 voters in wards 1, etc., that have no physical addresses reflected on the voters' roll. And if you go to the letter of complaint, which is referred to in that paragraph, it's Annexure PM3, which begins on page 55, but the relevant paragraphs are on page 56. Once again, you will see in paragraph 4 It says, ex facie, the contents of the voter's roll. The voter's roll provided to our client does not comply with paragraph C and D of the order of the Constitutional Court, in that the following numbers of registered voters in each respective wards of the by-elections does not reflect a verified address of the voters, and you can see the total is 4,162. And then I draw attention to what is in 5, because this is an additional complaint. It says, apart from the above-mentioned non-compliance with the order of the Constitutional Court, our respective clients' own investigations with regard to voters that are currently wrongly registered in the wards where the by-elections are due to take place reveals the following numbers of illegally registered voters per ward, and that is where we get the figure of 565. So, what is absolutely clear is that the mere complaint, the core complaint, indeed the one which the Electoral Court considered concerning the 4,000 odd voters, was a complaint of the absence of addresses simpliciter, nothing else. The complaint was merely that we have gone through the roll, we've identified 4,160 voters' names who's there, and there are no addresses linked to those voters. Now, in our respectful submission, based upon this court's judgment, the submissions that you've heard, the absence of an address cannot in and of itself constitute an irregularity. That flows from section 16.3, which, as we know, only requires the address where it is available, and therefore the mere fact, the mere absence of an address is not an irregularity. As for the 565, if there was evidence to justify the assertion, because it was nothing more than an assertion, that there were 565 voters who were actually residents in districts in which they were not ordinarily resident, that would certainly constitute an irregularity, the degree and effect of which would of course have to be independently assessed.
The 10 minutes has expired.
Thank you.
So proceed with that on that understanding.
In relation to the 565, I beg your pardon.
The mere appearance of somebody on a voter's roll without an address is prima facie unlawful. It calls for an explanation, doesn't it? Section 16 tells us you must have an address where it is available.
Well, the explanation...
So the caveat requires an explanation. Here, it is not available, but the default position is you will have an address inserted. Isn't it so?
Justice Moseneke, I'm slightly hesitant to say prima facie unlawful, but I accept the core proposition which you are putting to me, that it calls for an explanation.
Yes, the law says you must have an address.
Yes.
Except if it's available, whatever available means. So it calls for an explanation. Sorry, there's no address because it is not available. Otherwise, on the face of it, it's an illegality, isn't it?
The IEC provided an explanation. The explanation is to be found in the... And again, I'm confining myself at this point to the case before the Electoral Court, because as I will demonstrate in a moment, there is what we would respectfully submit to be an impermissible attempt to raise the spectre of the 500 in this court, but I'll come to that. In the Electoral Court, the IEC advanced an explanation, and it's to be found in their answering affidavit, volume 3.
In which court?
In the Electoral Court.
Yes.
And their explanation is in volume 3, page 278, at paragraph 35. And in summary, what their explanation is that the 4,160 fell into two categories. The first was those who had registered before the CAM order, and the second was those who had registered after the CAM order, but where the voters did not have a physical address. So the IEC did indeed offer an explanation, and that is the one to which I have referred. But in relation to the 500, if there was evidence before the Electoral Court that they were indeed registered in the wrong ward, in the sense that they were registered in an area where they were not ordinarily resident, then that would constitute an irregularity, and its seriousness would depend upon the relevant facts. But the Electoral Court had no evidence before it whatsoever, other than the mere assertion that there were some 565 falling into this category. They were not told anything about how that 565 had been identified, other than that it was the product of an investigation, the details of which were never ever disclosed to the Electoral Court at all. And indeed, if one goes to the judgment, it appears that the Electoral Court didn't deal with those 500 at all.
I'm sorry, Mr. Marcus. What about the report contained in the letter attached to the answering affidavit of the IEC, where the IEC says, we have investigated. In fact, we find that about 4,531 people are affected. Of those, 1,601, we have sent notices to the various voters to show cause why their names should not be removed from the roll, because it says they were registered in wards in respect of which they had not given addresses. Their addresses referred them elsewhere.
Justice Jafta, that is correct. If you go to the letter, the explanation to which I gave the reference in their answering affidavit is to be found also in that letter. It's on page 210 in paragraph 8.6, where they answer specifically the complaint in paragraph 4 of the complaint, that is the one to which I refer, and they give the explanation that follows. And in addition to that, they give details of what they have done in order to remedy the defects which had arisen. And in addition to that, they address themselves to the 565. You will see that in paragraph 8.9 and following. All I am saying...
My question is directed at what they say at 8.10.5.
Yes.
Because that gives an impression that as the facts were before the Electoral Court, there was a number of people, at least 1,600 of them, which the IEC itself, on investigation, found that they had been irregularly registered.
Justice Jafta, there's no dispute about that. That was the product, however, of the IEC's own investigation and the steps that they took to put it right. My point is a slightly different one. My point is, what was the complaint that the independents brought to the Electoral Court which gave rise to this very dispute?
Mr. Bakas, I'm sorry to interrupt you. I was just pointing you to those facts in the context of the criticism leveled against the Electoral Court to the effect that there were no facts before it indicating any irregularities.
Justice Jafta, I think we're at cross purposes. There are two... The way the complaint was formulated in the original letter of complaint was twofold. There was one complaint about the 4,160, and there was a second complaint about the 500 odd. The complaints were different. The complaints about the 4,160 was the mere absence of addresses. Nothing more, nothing less. The complaint about the 500 was different. The complaint about the 500 was that they were wrongly and therefore unlawfully registered in wards in which they were not entitled to be registered. The Electoral Court didn't deal with that latter complaint because, in a sense, they were not really called upon to do so. The way the argument was framed in the Electoral Court focused purely on the 4,000, and the complaint in that regard was the mere absence of addresses. Yes, it is absolutely correct, as you have pointed out to me, that the IEC, perhaps pursuant to its duties, took steps to investigate how it is that there were 4,000 odd without addresses, and we know the results of that investigation. All I'm saying is that was not the complaint which served before the Electoral Court.
There's an obvious incongruity there, Mr. Marcus.
I beg your pardon, Justice?
I understand. I said there's obvious incongruity there. Remember where we started when my brother, Justice Jafta, came in? You were saying the court was wrong because the only complaint before it was that there are 4,000 people whose addresses are not available. On that ground alone, it held against the IEC.
Yes.
And yet, in fact, if you go to the court's decision, you can see in paragraph 12, I think that's where it makes its factual finding. The question is, what is wrong with that finding? Let me see. No, yeah. In 12, it says the fact that the voters' roll contained registered voters without addresses was common cause. Counsel for the Commission advises court that the Commission had commenced the cleaning up of the voters' roll, which coincided with the annexure, of course, provided by the IEC, but that the process had not been completed. This admission implies that there are indeed voters on the roll, as it was before the Constitutional Court, who should not have been included. Now, if you go and look at what my brother Justice Jafta referred to on page 211, and look at 8.10.5. There the IC says, after a thorough investigation, 1,608 of the 4,531 persons were confirmed to be located outside of their voting district based on the addresses provided. Accordingly, the Commission sent notices to 1,601 persons notifying them of its intention to remove them from their names from those segments of the voters' roll and requested them to make representation in respect thereof. Yes. Of these, 1,509 persons were removed from the affected segment and re-registered in their correct voting district. Now that is inconsistent with a mere answer that says the addresses are not available.
Yes. Justice Moseneke and Justice Jafta, you'll appreciate that this letter was written before this application was launched. So the question was, in the face of what the applicants in the Electoral Court knew the IEC had done, what was their complaint then? This was information that they had. They had been told that this is what the IEC had done because there was a build-up to this court case.
Well, the Electoral Court tells us what the complaint is.
I beg your pardon?
It doesn't have to be reformulated. The Electoral Court tells us what the complaint is. Look at page 363 in his judgment. It tells us. And then it proceeds to make factual findings on the basis of concessions by the IEC. And then says, well, not much has happened. You're still cleaning up the voters' roll, and there are people who, on your admission, should not be there. You have given others notices not to be there. And therefore, and it says, you are pretty much at the same place as where you were before the Constitutional Court. And therefore, the claim is valid. Why is that wrong reasoning?
The reasoning has to be directed to what the complaint was that served before it and what the evidence was to support that complaint. There was certainly a build-up towards the application in the Electoral Court in which the IEC had been notified that the central complaint was that there were 4,000 odd names on the roll without addresses. The IEC addressed that complaint in the letter to which Justice Jafta and you have both referred, and thereafter the independents came to court and their case before the Electoral Court was unequivocally a simple case. The mere existence of 4,000 odd names on the roll without addresses was what they contended to be a fatal irregularity. Now, I would with respect submit that that was a misappreciation of what in fact the case was that they brought to the court, what the Electoral Court was called upon to adjudicate, and of course the eventual outcome would have been infected by what we submit to be those misdirections. I do accept that in relation to the 500, had it been established, that certainly would have presented a problem. The difficulty, however, was before the Electoral Court, there was no evidence whatsoever other than the mere assertion concerning the presence of those 500 names. What has happened in this court is there is an attempt on these papers to introduce new evidence that was not available before the Electoral Court.
But I think the point, sorry for interrupting Mr. Marcus, is that this is a symptomatology. That the absence of addresses gives rise to disquiet on the part of the independents, and their own investigation, which they might not be able to prove for the purposes of their application in the Electoral Court, underscores their anxieties because of all these unaddressed registered voters. And as Justice Jafta points out, the IEC's own investigation substantially bears out those anxieties.
I understand at the level of a perception, or however one puts it, that where one encounters a significant number of voters without addresses, the question arises, well, why is this? And I can equally understand a party perhaps drawing the inference, not in the technical legal sense of the word, well, there may be an irregularity here. Once they had done that, the IEC addressed the problem. If this court were to hold that the IEC addressed the problem inadequately, then the argument that I advance will carry no water. What we would submit, however, is that two things. Not only did the IEC address the problem, but at a point after it had been addressed, and the applicants before the Electoral Court knowing what the IEC had done, they came to court not on the basis that you haven't done a proper job, not on the basis that your investigations were inadequate, but purely on the basis that they have identified voters who do not have any recorded addresses. That was the case. Theirs was not an attack on what the IEC had or hadn't done. What we
Mr.
would...
Marcus, I'm sorry.
Yes.
Of the 1,600, we know that the IEC determined that they were incorrectly registered because they had provided addresses. Of the rest, the balance,
yes,
the explanation is that addresses were not provided because they were not available. Am I correct?
That's my reading of it, Justice Jafta, because you have to read paragraph 8.6 before that together with 8.10.
Yes.
Yes.
Correct. Now, my difficulty is, how did the IEC, because seemingly, when one looks at the background, the IEC did not know from the outset why 4,500 voters did not have their addresses. They had to investigate. They investigated. Now, I'm curious to know, what was it that the IEC found in respect of the balance, that they were properly registered in the correct wards, even though their addresses were not available?
Well, Justice Jafta, given whom I represent, I can't answer that question. But I suppose the second part to that question is, I think in fairness to the IEC, that is not a question they were called upon to answer. So the short answer, I perfectly understand the curiosity underlying your question, and it's a natural question to pose. But I can't answer it, and I don't believe, in all fairness, that the IEC was called upon to answer it either.
And in all fairness, how would the independent candidates know that what the IEC say is correct? If the IEC says those people were correctly registered even though we don't have their addresses. What are the objective facts to show that?
Well, I appreciate the dilemma in which the independents found themselves. I can do nothing more than reiterate that had they squarely posed the challenge, perhaps my answer, my learned friend's answer would have been different. And that's why this is not a, can I stress, this is, I don't want to be misunderstood as suggesting or implying that this is a mere technical point about pleading. The point about this is that it all happened urgently. There was very, very little time. And in those circumstances, of course, things can fall through the cracks. But at a very minimum, in fairness to the IEC, they came to court on the particular case that had been advanced. And what we are seeing here in this court, certainly in relation to the 500, is the presentation of evidence which was simply not placed before the Electoral Court. And on that score, we would simply say this. We would say, first of all, it is not permissible for them to do so now. But more importantly, yes.
But it seems to me the IEC understood their case slightly differently, because in paragraph 7 of the answering affidavit at page 262, the IEC itself sets out the core complaint as it understood it. And in that paragraph, it includes the legibility of voters to vote as part of the complaint.
Yes.
Now, if that is so, somebody would be eligible to vote only if they are registered in the right ward. Am I wrong to assume that?
Justice Jeff, I'm not entirely sure which paragraph you were referring to, but
paragraph 7.
Paragraph 7, the way they put it is the core complaint of the applicants is that the Commission has not furnished a voter's roll that complies with Section 16.3 of the Electoral Act. In the result, charge the applicants. In other words, this is the accusation coming from the applicants. It has been impossible for them to verify whether the voters whose names appear, etc., are residents or that they are eligible to vote. So, yes, it is correct. The complaint was, you have not furnished a roll in relation to these 4,000 with addresses. That's the complaint. Question is that a legitimate complaint? It's only legitimate if one concludes that there has been a breach by the IEC in one or other of their obligations. That, with respect, is a very, very difficult and different case to make, particularly given the fact that we know that an explanation was furnished. I don't think a replying affidavit was even put up in the Electoral Court, if memory serves. There were only the founding and the answering. And the question was, well, what was the Electoral Court to make of that complaint and that evidence?
Was it not incumbent upon the IEC to say, you say you don't know, you can't determine whether these voters reside in those districts. Here's information that shows they reside there. You say you don't know whether they're eligible to vote in those wards. Here's information that shows that they are eligible to vote.
Justice Jafta, if that's the conclusion that the court reaches on a fair assessment of the case that the IEC was called upon to answer, then this part of my argument will fail. My submission is that that would be an unfair reading of the case.
No, if you are incorrectly accused of wrongdoing, especially a credible body like the IEC,
yes,
to discount the potentially damaging possibility of public perception that you live in some room for unfairness during the electoral process. What you need to say, I think, is, I don't know what your problem is. I've done my spade work. I've satisfied myself that all these people who are going to vote are in the right wards, they are in the correct voting district. Here is the proof. Failure to do so seems to suggest, and I must emphasize seems to suggest that you can't vouch for the correctness of the placement of the voters. You can't tell us with confidence that everybody who will be voting is entitled to be voting in the allocated ward. And that's where the problem is.
Two submissions, Chief Justice. The first is to once again draw a distinction between the 4,000 on the one hand and the 500 on the other. In relation to the 500, that was a specific complaint, and had it been pressed before the Electoral Court, what is being put to me now would undoubtedly have called for an answer from the IEC. But the 500, which was the potentially dangerous complaint which was advanced, was simply unaccompanied by any supporting evidence whatsoever. The second answer that we would submit, and it goes back to the letter to which Justice Jafta draws my attention, concerns what it is that the IEC did when they received that complaint. And the question that we would submit has to be posed is, how does this court assess what it was that the IEC did having received that complaint? And we would submit that the test has got to be one of reasonableness, not one of perfection. A perfect voter's roll might be aspirational, but it is simply unrealistic and probably doesn't exist anywhere in the world. What is posed by the facts of this case, then, is a different question, and that is, in the face of that complaint, this is before the IEC application to court, did the IEC take reasonable measures, yes or no? And to the extent that the applicants in the Electoral Court thought otherwise, we would respectfully submit that ought to have been a frontal challenge to enable the IEC to deal with it.
Do the reasonable steps taken by the IEC demonstrate that everybody will be voting in the ward in which they reside? That's the bottom line, because that's what the Act requires.
If it is being suggested to me, Chief Justice, that they would have to be satisfied of that question in relation to every one of the approximately 22,000 that I think have been identified as the numbers in the relevant wards, that would be a standard of perfection. But if they had taken reasonable measures to ensure that their voters' roll is safe, that the outcome of the election would be free and fair, then my answer must be in the affirmative. They have done what is required.
I'm sorry, Mr. Marcus. I don't want to belabor this point unduly, but here is my difficulty. If you're being accused of some dereliction of duty, such as the IEC appears to have been, to demonstrate that the criticism is unfounded, or it's unreasonable, or it's unfair,
yes,
you do your spade work and then come and say, we have complied, because it's our responsibility to comply. And this is how we have ensured that, unlike before, nobody will be voting in the wrong or incorrect voters' district.
Yes.
Has that been done?
Well, in our respectful submission, yes, it has been done. And I again draw the distinction between what happened before the application to court and what happened in the application to court. Before the application to court, the independents had identified their cause of complaint. They had notified the IEC, and the IEC told them what they had done. That's the famous letter to which we have referred. The question was, if the independents thereafter were dissatisfied with what had been done, what was it that they were incumbent, what were they required to do? What we would submit is that they were required to come to court and to say, look, this is our complaint, this is what the IEC has done, but we're not satisfied for the following reasons, and therefore The absence of this explanation or that explanation is a prerequisite to determining this matter, but that's not what they did.
Let me ask you a different question about available. I haven't read the judgment you referred us to, but I think I've got a fair sense of what principle you sought to extract from it. Isn't there a fundamental difference, though, between being expected to regard as available some, is it train station or something, some 100 kilometers away from where you are, as opposed to determining availability in relation to an address that was actually given to you, or an address that could take a telephone call or a visit by your people on the ground closer to where the wards are to determine whether or not people actually stay there or not. Isn't there a...
Chief Justice, I don't for one moment suggest that the facts are remotely the same. I urge the case upon you purely for an approach to the problem. The approach that the appellate division adopted was, to use their language, a realistic rather than an unrealistic one. And there is a further, perhaps linguistic argument that flows from section 16.3. It imposes an obligation upon the IEC to provide something. They have to provide a voter's roll with the addresses where available. Ordinarily, I don't suggest this is without ambiguity, but ordinarily where there is an obligation to provide something, it means that you must furnish something which you have, not something which you must still obtain.
No, that I understand. Yes. I'm confining myself to the meaning of available within the context of this case. If an address is given to you, or if an address is easily ascertainable, is that comparable to a situation where the station is 100 kilometers away? Because otherwise that case is not of much assistance insofar as we're talking about, I'm looking for the phrase again, I've got it somewhere here, realistic concept of availability, as you put it.
Yes.
I think isn't it a realistic concept of availability to say, if it's given to you, if it's easily ascertainable, as opposed to a far removed station?
I accept,
then
Chief Justice,
the two are incomparable.
Yes. I accept that availability might entail, in an appropriate case, a question of degree. And in answer to your question, and I can only answer it at the level of abstraction, there may well be some cases in which, yes, it is relatively easy to ascertain a particular address, and in other cases it won't be. Sometimes it will, sometimes it won't be.
In this case, is it realistically available when you have been provided, or when you can with ease determine the address? Or is it unrealistic?
Well, I'm hesitate to answer that question on behalf of the IEC.
You're making some submissions on their behalf.
But you're asking me a factual question, Chief Justice, with respect. It's a factual question, and the best I can do...
It's not factual. It's not factual.
Well,
but if it is, it's not. It doesn't relate to facts that you can't deal with, because we're talking about realistically available. And I have posed a question. Say it's given to you, the address,
yes,
or it's capable of easy verification or ascertainment. Why is it unrealistic to expect of the IEC to do that which is capable of easy achievement?
Because there's a world of difference, Chief Justice, between ascertaining, for example, one particular address or a handful of addresses on the one hand and a vast number of addresses on the other. Point number one.
4,000?
Well...
Within how long? From February?
Well, the election was looming.
From November, rather?
Well, presumably
1,000?
one has to ascertain it from the date at which the issue was pertinently drawn to their attention as a potential complaint concerning the election. And in that regard, it was a relatively short period of time. As to how it's to be done, well, it depends upon manpower resources, it depends upon electronic databases, and that's why I'm simply hesitant to answer that question at the level of fact. I don't suggest it's impossible.
Well, I heard you. Let me ask you a different question. And that relates to the scope of application of the CAM decision.
Yes.
I don't know whether it applies to Tlokwe only or whether it is of nationwide application. And I'll tell you because I need you to help me here. If we say it applies only to Tlokwe, the CAM decision, what then is the position of a voter in Pofadder who say, you know, I've asked these people for the national voters roll as it applies to Pofadder. There are no addresses at all. Why are the Tlokwe people entitled to addresses and I'm not? Does it mean that person would have to bring an altogether new application for his or her situation to be clarified, or are we to understand the CAM decision to apply to all other people who find themselves in the same position as those in Tlokwe?
Chief Justice, our answer is this, that by virtue of Orders 5C and D read with 6, the CAM decision has application to all local government elections. However, the question is, how do we apply that in relation to the very Tlokwe by-election, which was the subject of the matter before this court, and a new by-election about to take place in precisely the same district? That is why we suggested in our heads of argument that at least implicit in this court's order was that the IEC had to take reasonable steps to correct the defects which had given rise to the setting aside of that by-election. And again, that's a question of fact. The IEC has given evidence as to what it did. If you were to conclude that that was insufficient, then the result would probably be the same. There is this difference, however, and I think it is an important difference, and it raises a difficult issue around remedy. A critical difference between what happened in CAM and what's happened here is this. In CAM, the by-election had already taken place. And by the time the matter had got to court, the court assessed what had actually happened against 3 series of irregularities, which my learned friend has identified. This particular issue, the Tlokwe issue, is different because it comes to court in anticipation of a by-election yet to take place.
So I interrupt you. Will that by-election ever take place?
I think by the 16th of August it will. But Chief Justice, it's important because the question to be posed is a different one. In the CAM case, this court was at least able to take a retrospective look at exactly what happened. In this particular case, the Electoral Court, and indeed this court, is asked a different question. They're asked to anticipate what would happen if the election were allowed to take place and to reach a conclusion that if that were to occur, it could not be free and fair.
You see, 4,000 people want to vote, and the independents are aware of that, everybody knows. IC is pressed initially, it does investigation and cleans up, finds people wrongly registered, people in wrong districts, and cleans all that up on your approach. And thereafter, 4,000, another company has put up about 4,000 people. The crisp and terse answer of the IEC, the addresses are not available. would anybody know where the people are entitled to vote? So the independents go to court and say, sorry, there are 4,000 people. They've done all sorts of things. They found all sorts of wrong registrations. They say they've cleaned up, but there are 4,000 people who the IEC says their addresses are unavailable. Then comes the question that Justice Jafta pressed on you, and that the Chief Justice also pressed on you. Why is that adequate? How would the IEC be able to persuade the Electoral Court that the people are entitled to vote? And the Electoral Court says no and holds against the IEC. What is your response to that?
The response is
they have a duty to make sure the right people vote. They come back and say, we don't know what their addresses are. Why? Because they're unavailable. Why is the court wrong in holding that is inadequate?
The response is twofold, Deputy Chief Justice. And in some sense, it's a speculative one. In the first instance, the court would have to have regard to what it is that the IEC actually did. Having received a complaint from the independents, we know what they did. It's set out in their letter. That combined with what the case was, the cause of complaint which they advanced in the Electoral Court, and then the question would have to be posed, assuming that the court is dissatisfied with the explanation that was given in the letter, assuming that the court was also dissatisfied with the answers given in the answering affidavit in the Electoral Court, could the court reach the conclusion that this by-election would not be free and fair? If the answer to that is in the affirmative, one cannot...
IEC is a respondent and it bears the duty. It has been put to you a few times. And it wants 4,000 people to vote whose addresses are unavailable. And we know what the law is, Mr. Marcus. 16.3 tells us so. The Calm judgment reaffirms and states that nobody votes unless their addresses have been properly ascertained, particularly after irregularities that the IEC tells us about. Just before the by-election, the second round of the by-elections, why is a blank, bare denial or statement, we don't know their addresses, adequate to satisfy 16.3?
Because it depends upon the circumstances in which the complaint is given. I don't want to repeat my argument, but if the court is against me in relation to the case pleaded by the independents, well, then I'm afraid I can't...
Can we go...
Yes. Yes. I'm merely postulating the possibilities, that's all.
Yes. Let's go to just to another area in your submissions. What in the Electoral Court judgment requires us to deal with historical registrations on the voters' roll? What in their judgment makes us to be seized with a decision about 16 million that sometimes is 18 million?
Yes.
Why is that before us? Sometimes 12 million.
Deputy Chief Justice, I have been careful to confine my submissions to you on the merits of the appeal. The question of the wider implications of the Electoral Court judgment would only arise if the appeal fails and the IEC's application for direct access is granted. Then and only then do the potentially wider implications of the Electoral Court judgment arise.
Moved on, I understand that.
Yeah.
I thought so your submissions are limited to that. You don't have to go there if you don't have a brief to go there.
No.
So you don't want to go there. Essentially, you're not briefed to go there.
Other than to submit with respect to the court that in the event of the court reaching the question of direct access, then we would support the relief identified in prayer 6 of the IEC's notice of motion, which is the prayer dealing with the relief consequent upon direct access and the timetable which they have sought in relation to rectifying perceived defects in the voter's roll.
So
that might change in the light of the information which the IEC is going to present the court, but on available information we have no option but to accept the IEC say-so in that regard.
So you must have exhausted your submissions.
I have.
Thank you.
Thank you very much, Chief Justice.
Thank you, Mr. Marcus. Yes, Mr. Skakani, you're next. While you're getting ready, Mr. Skakani, which aspect or aspects do you want to focus on?
Yes, Chief Justice, I'm dealing with two broad topics. I think my learned colleagues have dealt with the aspects that on the basis of which we support the appeal. So there are two broad topics that I'm dealing with. One is linked to the debate that the court had with Mr. Marcus, which is about the meaning of where available. And I'm dealing with one aspect there, which is what we've identified in our heads of arguments in our papers as how the right to privacy is implicated. That's the first topic. The second topic that I'm going to deal with, and I think this is the topic that may have caused some controversy about some vitriol about whether or not there is a possibility of disenfranchisement or that the calm judgment does that, which we do not say. So
yes, featured quite prominently, I must say, and the millions.
Well, Chief Justice, I will make attempts to tone down the vitriol in that aspect, because I will locate disenfranchisement within a particular context, which is what now, in the event that this court is not with us on the appeal.
I would be interested in that, because the bottom line is counsel needs to help us assist the process so far as we can, so that voting does take place without violating any aspect of the law. We have a collective responsibility to do everything within our power to get to that point. So that would be very helpful.
Absolutely. Chief Justice, we have to accept right at the outset that, well, let me say there are two.
Before you go on, do you need your 10 minutes? Or can we interrupt you anytime?
I deal better with the punches later when I've thrown my. I would prefer to throw my punches and then take them, if the Chief Justice doesn't mind. Well, Chief Justice, can I preface the two broad positions that we're making with this submission? Our submission in respect of the appeal, in respect of what we call the error in the Electoral Court's judgment, are really about two broad propositions in that judgment. Now, I had a question to Mr. Trengov about that question, whether or not we are correct to say there are those broad propositions that the court in the Electoral Court says, well, where there are voters without addresses on the voters' roll, then they are registered in the wrong ward. If that is the broad proposition that is being made in that judgment, well, we take issue with that broad proposition because, as I will explain later, it has consequences for quite a number of other people, because there are many reasons why there would be no address. The second proposition that we take issue with, if we are right, that we are reading it correctly, that it's a broad proposition that has implications for any voter through North who does not have an address. And if this broad proposition is correct, and this is the broad proposition that we take issue with, that the absence of an address means that the process, the registration is flawed. If that broad proposition is what the Electoral Court meant, well, we submit that it failed to understand correctly Cam's judgment, because in our view, that is not what Cam's judgment says. So that is how I preface the two broad issues that I want to talk about. The first issue about privacy, I will not traverse what Mr. Marcus has dealt with, which is the other meaning of where available. But we accept the proposition that 16.3 is the law that compels, that obliges the IEC to ensure that their addresses were available. We have to accept that that is the law. There has been a debate about whether that happens after December 2003 or after the Cam judgment. Well, we have to make one proposition that I don't think any party can escape, is that the law is what it was since 2003. And I have no answer as to why certain things may not have happened thus far. But there are many reasons, Justices, that will result in the voters' roll not having names and sometimes no addresses. And if we accept that the broad proposition made by the Electoral Court is correct, then it has serious consequences for people who are already in the voters' roll. Now, the right of privacy, we mention it here because this court has, in a number of cases, stated its importance. Now, as an explanation of availability, let's postulate this position. Politician X, in terms of the law, must have access to my address. And I do not want my address to go beyond the point of the IEC. I do not want the honorable members to bother me. That's the first proposition. The second is there may be a number of categories, there are many categories in society who, not just because they are exercising the right to privacy, have circumstances because of their professions that would make them not wish to have their address communicated. And I'm explaining this simply to say there are many reasons why the address would not be available. Now, of course, those categories are, we've stated them. You may have people who live under witness protection programs. It could be people who work for intelligence services. It could be abused spouses, usually it's women. And it could be some judges. Those are the categories of people. It's not exhaustive. I'm just highlighting to the court that the right to privacy may be exercised by those different categories of people. But even if those people did not exercise that, it was not about their professions. We submit to this court that it must take into account in assessing why a name would be there without an address, that there may be in future and in the past voters who do not wish to have their names and addresses and other details communicated, and they want to exercise that right. So we raise that point to explain the meaning of where available. And therefore, the proposition that it is flawed when the address is there, in our view, is incorrect and has consequences that have made us refer to what we call disenfranchisement. The next point we want to make is that Section 39 of the Constitution provides that legislation, including, of course, what we're dealing with here, the Electoral Act, Section 16.3 of the Electoral Act, must be interpreted in a manner that promotes the object of the Bill of Rights. And of course, the right to privacy is highlighted by this court in the case that it did in the investigating directorate, serious offenses and others, the Hyundai matter, that where a person has the ability to decide what should be disclosed to the public and a reasonable expectation that such a decision will be respected, well, the right to privacy is implicated. So we submit, therefore, that there can be no doubt that in all this debate about whether or not the address should be there and what where available means, well, the right to privacy is implicated in this case. And this is so particular if one has regard to, I know this is not the statute that has come into effect, but we would invite the court to take account of the Protection of Personal Information Act, not because it is before the court, but because it sets out some guidelines about how we should deal with personal information. It's called POPI popularly, and it contains an expanded definition of personal information, which includes personal addresses. We would submit, therefore, that this court has said in a number of cases, including the Hyundai one that I've said, and the NM and others versus Smith, the importance of the right to privacy. And we submit, Chief Justice and Justices of the Constitutional Court, that this aspect of the definition of where available and the possibility of people exercising that right, as well as people who just do not wish, because of their personal or professional circumstances, to disseminate their addresses, should be taken into account, because that right arises. And there would be, if it doesn't, if we ignore it, well, we would have to balance it, that limitation in terms of Section 36 of the Constitution. It would have to be limited only in accordance with that provision.
Well, we are entitled to interrupt you now, but maybe just to give you a minute or two to deal with the second one before we do.
Yes, I will try and then summarize it, Chief Justice. My parting shot on this aspect is obviously a statement that should be expected, that we're not suggesting that that right is absolute. I shouldn't be understood to be saying that. The next point, Chief Justice, is remedies. I think this question came very early. What now? Even if we're dealing with all the parties here as culprits who've caused this problem, what now? What do we do? And I think I would like to emphasize that point, because a misunderstanding about the word disenfranchisement as suggesting that it was done in CAM or it will be done here, I think it's not there. This court will be, if we're wrong on the appeal, or this court is disinclined to agree with us on the appeal, on the positions that I stated earlier, well, this court has 4 options we submit. One is that for all the imperfections that the court has identified in respect of the IEC, it would have to order that the details of all the historically registered voters be obtained by the 31st of May, at least in respect of
December, we're leaving pre-December 03 out after the debate with Mr. Trengo.
I'm including pre-December, Justice Cameron, because I accept that the law operates. There may have been reasonable and maybe different interpretations about what it meant, but I think we have to accept that it starts in 2003 when the Act came into operation. But the point we're making is that, well, the second option, you would have to remove the millions of people who would fall into that category, the historically registered.
Is that before 2003 or after?
After 2003.
Oh,
yes. Well, I don't want to get into the ones before that, because that brought broad proposition I was talking about affects our elections since 1994.
No, that's fine. Remember, I've given you 1 or 2 minutes, so I thought you would nip it in the bud so that we can debate.
The last one, you would have to postpone the election. We submit that the 3 are unavailable, ordering the details that the IEC, at least for the purposes of the 31st of May, our deadline to proclaim for the election. That's just unavailable. It doesn't matter who we call the culprit. Because of what we've been told in the IEC's papers, how long it would take. Remove about 12.2 million voters. Well, I think it's the only reason the word disenfranchised is used, at least from our submission, is the possibility that this option itself, given the right to vote and its importance, and what this court has said in many cases, the New National Party case, the August case, this option is unavailable. The last one, postponing. Well, Section 1592 of the Constitution tells us that given the time frames that we've been told about, well, you have 90 days, and any postponement beyond 90 days would require a constitutional amendment. So that option is unavailable. The option that is available with respect is that if the court is disinclined to agree with us on the submissions we've made, that Mr. Marcus and Mr. Tlokwe have made on the appeal, is to suspend that obligation, no matter how it is framed, to suspend that obligation to obtain the details that the court will identify have not been obtained for a reasonable period of time, so that we do not end up with a situation that we're trying to avoid, where the election does not happen simply because there are no addresses.
Now, let's start with the privacy aspect. It will have to be, it accommodates very few people, doesn't it?
I didn't get
it relates to a very, very, very small number of people. For starters, I don't know of any judge who would insist on his or her address not being known.
Well, Chief Justice, then maybe if that is the case, we can cut out that profession.
Yes, because I mean, even telephones, 12 midnight, you get an SMS, there's a special at my ladies. You don't know where they got your number from. So that one is out.
Well, with respect, Chief Justice, may I just on that point, because it is a serious proposition you are putting, that you don't know of any judge who would need that privacy.
There would have to be not more than 10, if any.
I accept that.
Like Justice Lamont the other time.
Absolutely.
Yes, so that's a very minute number, and even those who are on a witness protection program, there are very few people.
I consider that.
You're not looking at 1,000 people.
Yes.
Yes, so let's put that aside, perhaps, and focus
if I may just
on.
Make a follow-up, CJ.
All right.
Mr. Skakane, I find some difficulty in your reliance on privacy, because the IEC has not relied on privacy as a reason why details of the addresses of the voters have not been recorded.
Yes, I do recognize that, Justice Khampempe, that they may not have raised the issue. However, we think as a principle, it's an issue we would like to raise for the court to take into account of. What is important for us is not whether it has happened, is whether the principle is correct to take into account. And we would submit with respect that this principle about it is important for us, whether or not practically there are people we could count more than 10, but the principle is important.
And now, the solution. What do you consider to be the solution? I think is what we must focus on.
Yes.
Are you saying there is a legal basis for the solution you propose, or is it the same Section 7.2 suggestion?
Section 172 suggestion.
Not of the Constitution.
Oh, yes.
That procedure set out in the Electoral Act,
yes,
in relation to circumstances under which, in fact, the IFP proposal, in other words, is that what you are what you are suggesting?
No. My suggestion, as I prefaced it, is in the event that the court has to find or finds that we are wrong on all the points that we've made in the challenge, and it finds that the IEC has the obligation.
Then 2020.
Yeah.
Yours is the 2020 position.
I think I would put, we have not in our papers put a date.
That's why I'm asking you.
We don't answer that question, Chief Justice, and I'll explain why. Because the IEC is the body with the obligation to handle the elections as credibly as possible. We do not know how long that would take. We have no reason to reject that because the subcommittee that ConCourt that has been established to deal with because as a point of departure, one must accept that addresses are important or giving sufficient particularity for a credible election. What we are suggesting is simply that this court, if there was ever a case in which this court has to exercise its wide discretion to suspend the finding that indeed the IEC or anybody that has the obligation to do what they had to do between 2003 and now, this is the case, to suspend that order. Because
I'm sorry, Mr. Skakani.
Yes.
I don't know much about the IEC. I was only involved in 1994 in settling some disputes in the small locality of Mafike when the DCJ was the deputy chair of that body. So we need help from everybody who has the opportunity to assist us so that we can understand, have a better grasp of the issues. So it doesn't help saying a reasonable period. On your own analysis of the papers before you, what is reasonable?
Chief Justice.
Because I'm disinclined to say the IEC has said it, we are bound.
Yes.
It doesn't work that way. It's got to be interrogated, it's got to be analyzed, it must make sense to us. That is why I say, are you able to give us your own conception of what is reasonable in the circumstances?
Chief Justice, we have no reason to disagree with the timelines put by the IEC, but I would need to take an instruction if my clients have indeed considered the question of timing. On the papers that they stand, my clients have not, except to identify that process, they acknowledge that it would be complex. But I would have to take an instruction about what they think would be the time. But as I said, there is no suggestion in our papers that we do not believe the time frames given by the IEC.
Well, Counsel, you say you want to throw your punches first before we do.
I couldn't throw any.
Well, we're not going to throw any punches. I need clarification, actually, on the remedy aspect. If on the appeal we were to hold that the appeal is bad and the Electoral Court, and that there was no duty on the IEC in any event to register addresses before 2003. Do you agree that that segment of the argumentation would fall by the wayside? If we are persuaded by the argument that 2003 is the starting point for the obligation to record, keep, and furnish addresses, then the rest of the role would not be implicated. Do you agree with that?
Deputy Chief Justice, I mean, my understanding of your question is that, I'll phrase it this way if I'm wrong, is that will I drop my suggestion on remedy if what it meant is that the IEC must deal with the names that do not appear starting from 2003?
I'm not asking you to drop anything. Let's try again. I'm saying as a matter of law,
yes.
If we were to find that the IEC's duty to record, keep and furnish addresses started in December 2003, do you agree that it would be unnecessary to fashion a remedy in respect of the historical voters' roll?
Well, I agree with one aspect of of what the Chief Justice is putting to me, is that, well, as I said right at the outset, the law with which we concerned begins from 2003. So I would concede that that is when it begins. Now, I would still not abandon the remedy, because if you
to abandon the remedy, I want you to help us fashion a remedy. So I don't want you to abandon anything.
Oh.
Let's get to the next question then. So you concede that we don't have to make any declaration or decision about the period preceding December 2003?
Indeed, yes.
That's your position, and that's the minister's position?
Yes.
Very well. The second question is, do we know at all whether there are any lapses from 2003 to now? In other words, what would be the basis for the remedy? You see, we have to find an illegality to fashion a remedy. Remember, I debated this with Mr. Trengrove. So between December 2003 to now, do we know whether the IEC needs any remedy?
Well,
and so if so, why?
If the court were to find that, given the fact that they had that obligation since 2003, in how they have performed that duty since 2003, they have acted in conflict with that duty. Well, the remedy that I'm suggesting, that we are proposing, arises then because you would have to deal with whether they must correct that in respect of the upcoming elections. And we submit that if the remedy were, even if the court were to find that the IEC has not performed its duties since 2003, we submit that to correct and rectify whatever the IEC may not have done right is going to take much more time for us to have a postponement or giving time to correct that in time for this upcoming election.
These papers do not deal with that. IEC tells us that they've acted lawfully as far as they know, except for certain addresses or documentation that was destroyed in certain uncomfortable episodes.
Yes.
So what would be the basis for the remedy? Remember, we're talking about remedy.
Yes.
Just want to understand what the minister's suggestions are. What do we do with the period December 2003 up to now, unless there's evidence that shows obvious infractions?
Well, Deputy Chief Justice, I can only say this. I have no reason to suggest, to differ with the IEC that it has not, with its submission, that it has not acted unlawfully since 2003. My only proposal is that, to the effect that the court does not agree with them, to the extent that the court finds that with all the explanations with which we do not differ, because we are in no position to know what they have or have not done, at least not to that detail. If this court were to differ with the IEC on whether it has acted lawfully since 2003, that is the point at which the remedy we propose arises.
Mr. Skakan, I'm sorry. One of the remedies that you propose is that the court should suspend the duty imposed by Section 16, sub 3,
Yes.
for a fixed period. What would be the basis of that in a situation where we don't declare the section to be inconsistent with the Constitution? Do we have the competence as a court to suspend the operation of an act of parliament that is already in effect?
Well, we submit in our heads of arguments, Justice Chafter, that because of the effect it would have, this is one of those cases that in our submission fits in with what this court discussed in War School MLO, in which you give yourselves as the court a wide discretion to suspend an order of invalidity of action or a statute.
That's a different scenario.
Yes, I accept.
You would have a declaration of invalidity.
Yes.
And Section 172(1)(b) then gives the court a wider remedial power to suspend that declaration of invalidity to allow the law to operate whilst the suspension continues. But here it is different. You are asking us to say, Parliament, even though this piece of legislation that you have passed is consistent with the Constitution, there's nothing wrong with it, because the IEC, which was required to have taken certain steps, did not do that. And the consequences now would be that 12 million people would be enfranchised. Therefore, we, the court, we suspend the law that Parliament has put into operation. What would be the basis of that?
Well, I can put it no higher than this, Justice Chafter, is that we suggest, in our view, that for the point that you've mentioned of the consequences of what would happen if you were to remove the names of voters, because either they remain there unlawfully because something was not done by the IEC, we suggest that this is the case in which, in our view, a just and equitable order would be the order that allows the elections to take place, at least for purposes of the August 3, as has been suggested.
The emphasis has been, from the minister's submission, has been on permitting everybody who is entitled to vote. An order that the court has to issue should not deny people who are entitled to vote. But isn't the other side of the same coin is that people who are not eligible to vote in certain wards should not be allowed to vote because they interfere with that exercise of the right to vote, but those who are eligible to vote.
Well, maybe this is my answer to Justice Chafter about that, is that in these papers, I accept that in the Ham case and in the Electoral Court case, you were dealing with specific allegations of irregularities. It is my submission that for purposes of the upcoming election, no case is made or suggestion is made that there is a real possibility that the names that are not there would constitute fraud or an irregularity. There is no case made on the papers to suggest that.
Well, remedy again, Mr. Skakani. You know, the rule of law applies to all of us, even the judges or the courts.
Yes.
We can't exercise power that we don't have.
Yes.
Where do we get the power from to ignore the law that governs a particular situation? Because we are not the law unto ourselves. So which law allow us to suspend?
I am not suggesting that the court is above the law. If I was understood.
That was just a preface. I'm not attributing that statement to you. The real question to you is which law allows us to order the disregard of the natural legal consequences of Section 16.3?
Well, I would submit, Chief Justice, that Section 1721B of the Constitution confers what I would say are wide remedial powers on this court to adjudicate a matter of this nature and take into account what would happen if it did not suspend or condone the illegality that either has occurred or continues to occur.
And we suspend the operation of any act of parliament that has not been declared constitutionally invalid? Do we have that power?
No, you don't.
So in terms of which law then are we empowered to do what you say we must do?
I'm simply suggesting that, I'm simply submitting, Chief Justice, that given our suggestions about the consequences.
Consequences I appreciate. And nobody wants to find himself to be party to an outcome that says, millions will not vote.
Yes.
No. But how do we get there? It must be a legally sanctioned process.
I can put it no further than what in my submission, are the discretion, the remedial powers in Section 172. I have
what should we remedy here? What is admitted as wrong? In your debate, the Chief Justice, the one thing that popped up was, what should we remedy? The one is, do we have the power? And the answer might be no. But assume the power is yes. What is the wrong here that calls for a remedy? The IC does not admit that it did not do its function from December 2003. We don't have evidence that there are people whose addresses they don't have, which they should have, except where one, they are not available, or two, which is lawful, or two, those that were destroyed. So what must we remedy? What is the gap here?
Well,
what is the malady that ought to be remedied?
Well, Deputy Chief Justice, I prefaced my submissions with a statement that I make these submissions in the event that the court finds that the points made by Mr. Trengov explaining what the IEC says it has done up to so far. So I assume that is correct, but I've made my submissions on the basis that this court may well not agree with Mr. Trengov on that part, and that is the basis of the submissions that I've made.
Well, Mr. Skakani, let's go to Section 172, on the strength of which you say we may make the order you propose, and show me which part of Section 172 of the Constitution empowers us to suspend the operation of the law in the manner you propose. Just read it out.
Well, Chief Justice, I will refer to 172B.
172 1B. No, you mustn't start there. Start from 1.
Yes.
So that it can be properly contextualized.
I'm there. Do you want me to read 1? Well, 1 says when deciding a constitutional matter within its powers, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And B, may make an order that is, that is just and equitable, including 1, an order limiting the retrospective effect of the declaration of invalidity, 2, Roman figure 2 that is, an order suspending the declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect.
So you're going to be relying on section 172(1)(b).
Yes.
Now, which invalidity are we tying up the suspension to?
Well, I'm tying it up to a possibility that this court finds that there has been conduct on the part of the IEC. Conduct, as mentioned in...
Which is constitutionally invalid?
Yes, that they have not acted in a manner that they are expected by the Constitution and the relevant statute to act.
Which part of the Constitution says they must do what they haven't done?
I don't get that, Chief Justice.
Oh, if you say they have not acted in keeping or in line with a particular constitutional provision,
yes.
Which one is that?
Well,
that renders their conduct constitutionally invalid.
Well, first of all, it's not my submission, Chief Justice, that they've done so.
Just said that, anyway, explain yourself. Let me not put words into your mouth.
It's not my suggestion that they've done so. I've premised these submissions on the basis that the court is not in agreement with them. And we would like the court to fashion an order that is just and equitable. And in our view, it would be just and equitable if that order does not postpone the election, does not remove the names of people for different reasons.
Mr. Skakani, it's out of no disrespect that I interrupt you. Please allow me to interrupt you. You seek to rely on section 172(1)(b) of the Constitution.
Yes.
Now, that section makes reference or presupposes a declaration of invalidity. Within the context of this case, what is it that that amounts to some constitutional invalidity that would allow us to act in terms of that part of 172?
Well, I concede, Chief Justice, that there may be no constitutional invalidity we are dealing with.
So you appreciate our difficulty?
I do. I think on that point, I do appreciate that,
yes,
that distinction.
I'm sure some of your other colleagues will help us. At the end of the day, we must find a solution, but you people must assist us.
Absolutely.
Yes.
Well, the last point, Chief Justice, relates to the proposals that have been made by different parties to assist this court. And one does not criticize them because they do not come from a good place. Our only point about them is that first, while we appreciate that they're an attempt to assist the court, we make this submission that...
Which ones, you know? It's like we are speaking in parables now. Mention them.
Well, the DA suggestion, I will take the Chief Justice to each one of them, but the point I wanted to make the point about what they all imply, because in our respectful submission, they entail in different ways creating or tagging, but creating a separate role in our submission. So
now we'll interrogate their submissions in due course.
We submit that if one accepts that section 1D of the Constitution talks about one common national voters' roll, the suggestion that strays from that provision, in our view, is unlawful. And our submission is that there would be more problems if you created a separate roll, whether you call it a provisional roll or you have a certified or uncertified list. In our view, all of these suggestions create a list, a separate roll, and we submit that it would be unlawful to do so. Those are our submissions about the proposal.
Thank you very much, Mr. Skakani.
Thank you, Chief Justice.
Mr. Tokota told me that he doesn't need more than 10 minutes. Mr. Tokota, you'll be the last before we break for lunch. I assume you all agreed on a 30 minutes lunch? If I had it my way, we wouldn't even eat.
Thank you, Chief Justice.
Which issue are you going to deal with? Or issues?
Actually, Chief Justice, I said to you in chambers there that...
I beg your pardon?
I said to you there that we have agreed, the colleagues, Mr. Pham Trengov and Marcus and all of them, we agree in general terms. So there is no need for me to repeat what they have to say.
Sure. So it is on that reasonable approach that you highlighted much earlier that I want to know if there is a particular point or points you want to highlight, and if so, what are those points or what is that point?
No, 5 minutes is enough for me to say what I have to say.
To make which... I'm sorry, Mr. Tlokwe, just so that we can anticipate your submissions properly. 5 minutes to make which point?
The point I want
to emphasize which point?
Is to emphasize the interpretation of the Khams order. And then the distinction between the 2003 and period prior to that.
That one you can, I think, assume that we move from 2003. We haven't decided, but move from that assumption based on how the argument has panned out.
All I have to say about the Khams decision is that it should be, that prospective approach should be, the order should be interpreted in such a manner that the order didn't require the IEC to go back to 2003 and investigate whether those people in the voters' roll had in fact all the addresses. It must be interpreted on the assumption, unless there's a contrary view, that since 2003, the voters' roll contain the addresses where those addresses are available. So that the requirement for the registration of aspirant voters with addresses to be also included in the voters' roll should be interpreted after the Khams judgment. Then there will be no problem of suspension of anything. So in other words, all what the court has to say, no, Khams judgment didn't require the IEC to go back and investigate and furnish with all those voters' roll from 2003 to date or after the Khams, whatever, that all those, the voters' roll has got the addresses of everyone where it is available.
No, Mr. Tlokwe. What does section 16 subsection 3 expect of the IEC to have done since 2003? That is the question.
Yes.
Harm or no harm? What does the act... I'm sorry, Mr. Tlokwe. What does the Act of Parliament require of the IEC to have done? The law itself.
Chief Justice, the IEC was expected since 2003 to have the addresses where available on the voters' roll, harm or no harm.
Yes, and if there are addresses that could be or could have been easily ascertained, and yet the IEC did not ascertain them, what should we do? That should be the question. Help us to resolve that issue.
That question would only arise if there's a complaint. That's why I say the court should move on the assumption that the IEC complied with its duty to have those addresses on the voters' roll where such addresses are available.
Can on the understanding that the 5 minutes is up.
Yes.
Thank you very much, Mr. Tlokwe.
Chief Justice said, yes, please, yes. I know the Chief Justice said let's proceed on the assumption that we are looking at post-December 2003. I am actually interested in pre-December 2003. And in your preface, you indicated that you actually wanted to argue that. You probably recall the question that I raised with Mr. Trengov, which is that based on Section 190, subsection 1B of the Constitution, there may well have been an obligation on the IEC even pre-December 2003. What submissions would you make in that regard?
Firstly, Justice Madlanga, I accept that there was even pre-December 2003 an obligation on the IEC to register an aspirant voter to have the address of the place in which the voter is to exercise his right to vote.
Thank you.
Thank you. Thank you.
Thank you very much, Mr. Tegota. The court will adjourn until a little after 20 past 3 according to that watch. That will be 30 minutes. Court adjourns. Mr. Bosman?
Justices of the this.
Is it fair to assume that you'll need your 10 minutes?
Yes, no, I waive the 10 minutes requirement. So there's just a brief introduction, so it will take 2 minutes. Then I'm waiving that 10 minutes prerogative. Chief Justice, without repeating, much has been said during argument and debated. I think everybody present is aware of the highlights and the gist of the matters before the court, and more particularly the provisions of the Electoral Act, more particularly Section 8.3, that requires a person that must be entered into the voters' roll for voting is a person which is ordinarily resident and for no other voting district, only for that specific district, which coincides with Section 16.3 of the Act, which has been debated extensively in this court. Now, as was already said and argued, all legislation must obviously be interpreted in the light of our Constitution and in the light of free and fair elections. And when a voter's roll is incomplete, like the voters' roll in respect of the independents that served before Justice Weppener and the other honourable judges in the Electoral Court, such roll cannot be above suspicion or above the requirement that it should have the effect that a free and fair election process is to be taken place. And we submitted in our heads of argument, and we referred to various of the paragraphs in the decision of COM, where it was clearly underlined, Chief Justice, that the object of this particular section 16.3 is to allow candidates not to only detect who are the voters exactly on the roll, but they need to have the opportunity to canvass, to make contact with the specified voters. And it was not in COM a question of new law that was created, as was raised by several of the justices. It was an interpretation of existing law, existing since 2003. So the obligation we submit that rests upon the IEC already exists since the introduction of this law. And even before that, the whole purpose of the Constitution and the Electoral Act, Sections 7 and 8, requires that each voter has to vote in the specific district and ward where he is ordinarily resident. And if gaps or the absence of addresses in the voters' roll is merely condoned, so to speak, we submit that that would be contrary to the purpose of the Constitution and the purpose of the Electoral Act. Mr. Chief Justice, that is the summary of our argument. We have addressed it fully in our heads. We have proposed a solution, or as was put by the Deputy Chief Justice, a possible solution. And that is a fashion to remedy, as put by the Honourable Deputy Chief Justice. Fashion to remedy we have dealt with in our heads of argument by referring to Section 7 of the Municipal Electoral Act. And this section deals with registrations, applications, and I'm not going to read through the whole. It is well known to the Honourable Justices of this Court, but it deals with the fact that where a person claims that he has been registered, but his name is not on the roll, there is a certain procedure that can take place. We don't submit that this is without any flaw, or the splitting of the roles is without saying the intention of the Constitution, but it's a merely temporary measure to endeavour to furnish a remedy if this court is inclined to grant the direct application, which we submit has no merits. And whilst on that score, just in brief summary, the direct application deals with time frames and deals with the inability to timelessly comply with the obligations of the IEC themselves, which we submit, and as we addressed in our heads, they created that themselves. But there has to be a solution either.
Mr. Bosman?
He's still within 10 minutes.
Oh, I thought he said once he's done with his
Are you
outline.
done? I thought you were wrapping up the remedy part.
I'm done. We can...
Oh, very well.
Done.
Very well.
Yes. Thank you. I don't understand how one can use Section 7 for these purposes, because that, in so many words, is or concerns a situation where somebody is not on the voter's roll.
Yes.
But they are seeking to vote on the basis that they had applied. Now you are seeking, on the basis of that section, to have people removed from the roll. That section is just not meant for that situation at all. And added to that, once somebody is registered as a voter, they have an untrammeled right to vote.
Yes.
So why subject them to the Section 7.2 strictures, and which are made worse by regulations 5 and 6 on the processes that then have to be followed?
Yes.
Is that legislatively possible at all?
Well, Justice Mhlanga, we have considered that difficulty, and that's why we agree from the outset that we don't say this is an out-and-out solution without any difficulties. That is one of the difficulties that is implied in the wording of Section 7.2. Now, the only submission that we can make in this regard is if one has regard to the fact that this is a mere temporary measure to obtain addresses. And that is only in the event we submit that the main direct application succeeds. If the direct application does not succeed, we would submit it should be dismissed with costs. Well, we are seeking costs, and I will address this court very briefly on that. And that
Sorry to interrupt your answer, Mr. Bosman, but at an appropriate time, won't you just spell out for us what you think the implications would be if the court doesn't intervene to grant the IEC direct access? Just spell out for us in very simple terms what you think the come judgment would mean. Is the minister and is the INC and the IEC and the ANC correct?
Yes.
Maybe you would want to go there after this question. Maybe you would want to go directly to that point after this question.
Yes. Yeah.
What is it about Section 7, subsection 2 that you rely on that properly entitles this court to deregister people who have been registered? That's the first question. A related question is, in circumstances where you don't have anything in your hand to demonstrate that they were improperly registered, what is it in law that allows us to remove those people from the roll, voters' roll?
Well, we must concede that is one of the flaws that I initially referred to, and the only submission that we can make in this regard are already made. And if this court is inclined to use the mechanism of Section 7.2 just as a temporary measure to split the roll, so to speak. But we accept that it may have difficulties in regard.
Let's clear it up, because you see, we just want to make sure that we understand your argument, and if we don't, clarification is called for.
Yes.
Is there anything about Section 7, subsection 2 of the Electoral Act
Yes.
that, correctly interpreted, empowers this court to do what you propose should be done?
Yeah.
Really?
Yes, that is correct.
Is there anything?
Well, the object of 7.2 was obviously what the wording, the grammar, means to say.
It doesn't apply to this situation, does it?
No, we must concede. We raised this point as we already submitted, as I already stated before I get to the question raised by this court, and that is only in the event that this court can reach a temporary measurement, if, and that is only if, the direct application would succeed. And
I don't want to belabor the point, but we can only do that which the law allows us to do. And my simple question to you is, does this section allow us, does this law allow us to do what you submit we should do?
Well, we must admit, in the context of this section in the Act, in the Municipal Act, Electoral Act, the purpose of the section is not what we submit.
All right. Now, my brother has put a question to you. What is the solution? Let's try to find a solution.
Yeah, if I understood the question from Justice Cameron correctly, the COM decision, and more specifically paragraphs 62 and 63, and we dealt with the relevant paragraphs in our heads of argument, had into mind interpreting section 16.3 that the municipalities' elections are required to be determined in wards, specific wards, and the process is vulnerable to manipulation. In other words, if voters can be brought from outside into a ward, or where political balance is unclear, few votes may influence the outcome of such election. And that is why we submit, in the light of the constitutional requirement of fair and free elections, section 16.3 was coming into operation in December 2003. And there's no other way to determine the purpose of that section we submit. It is clear on the face of it, and even before this section came to light, we submit that it was envisaged in the Constitution and in sections 7 and 8 of the Electoral Act that with regard to wards in municipal elections, the voters that had to be voted, that was entitled to vote in the specific wards, are the voters ordinarily resident in that ward.
You can round up before I come with my...
We submit, Chief Justice, that there's no merit to the appeal. With regard to the direct access application, we also submit that there's no merit to that as well.
On the assumption, and let's accept it for argument's sake, that the IEC's position is simply this. We meant well when we registered people from 2003, because I think that's the argument. We meant well.
Yes.
Not to include the addresses. We simply did not think that the recordal of addresses was such a critical component of the overall requirements that we did not include them.
Yes.
Now, seeing that we meant no harm, people are already there, they've been voting in that fashion over the years. Let's look for some common ground. How can we accommodate How can we resolve, rather,
Yeah.
the problem? What would be your submission? And accepting that it won't be possible.
Yeah.
For the purpose of, let's confine it, well, no, let's not confine it. For the purpose of the 2016, and you can deal with them differently, 2016 and 2019 elections, we will not be able
Yeah.
to have addresses appearing against the names of those whose addresses are capable of verification. We won't be able to do it. What then must we do now that Section 7.2, the Section 7.2 option has fallen off? What is it that we must do to resolve the problem?
Well, the only other possible solution is possibly not viable, because a postponement, a further postponement to effect time.
Exclude that one. Exclude a postponement. What is it that we can do to ensure that the elections do happen as scheduled, without closing an eye to any law that applies
Well, that
to
is a very
this matter?
difficult aspect raised by you, Chief Justice. The problem we have with the version of the Commission is their opposition to the application before Electoral Court was on the basis that.
I missed the first part. The problem that you have with their submission is?
Well, to answer your question, the problem we have with the version of the Commission in the Court a quo was that they proposed that the calm judgment is prospective, which is not. If one reads subparagraph D, 6D, it means that the candidates must be provided with a row with all the addresses where available, not available on the systems, where they can, as put by you, Chief Justice.
Well, let's assume that they are
ascertainable or ascertainable practically.
Let's assume that they are wrong. Let's assume that they were required by Section 16.3
yes.
to record those addresses, but they haven't.
Yes.
What then is the solution to the problem that would ensure that the elections are held as determined? What is it that we must do? Remember, you must assist us. That's why we put in so many questions to you. What is it that we must do?
Yeah. The only submission that we can make really is that they don't bona fide take this court into their confidence if one has regard to their version of time frames and all that postulations. If the main application is dismissed, they must just do their work. And they must just go out and perform what they should have done already from 2003.
When will that end? And what if they are not able to do that by the time we have the elections in 2016, August 2016? What if the process is not completed by 2019?
Yeah. That is
what is it that must be done?
Great difficulty that they are faced with. And I don't want to repeat myself by submitting that they created the problems themselves. But that is indeed a problem that they are faced with. And
well, let me ask you this one. I think I put it to Mr. Marcus. I need assistance from you. The IEC, I know you don't represent them, and their submissions read with those of the minister seem to boil down to this. None of the 17 agencies whose assistance was solicited either by the IEC or the minister, which include, by the way, Statistics South Africa, are in a position to assist the process in a way that would result in all the addresses that are capable of ascertainment being ascertained and duly recorded before even the 2019 elections.
Yes.
Now, out of ignorance, and I ask again, I don't know these things. Yes. How long does it ordinarily take Statistics South Africa to conduct a census. You know, they come to your house, they put a sticker to show that they've been to this particular house. The next employee must not try and get the details because it's a job that has been done already. How long does Stats SA require to complete the process so that we can think through what the combined forces of the IEC and Stats South Africa are able to do? And if out of ignorance we assume that Stats SA might be of assistance when in fact it can't be of any assistance, let there be an explanation as to how impossible a task it is for both Stats SA assisting the IEC and the IEC with its 50,000 people to complete the process. Just help us there.
Yeah. Chief Justice, that was dealt with in our heads as well. The figures of non-available addresses or addresses which is not properly descriptive is at the moment 12.1 or 12.2 million. But in relation to a question put by yourself, Chief Justice, the census is usually done within a few months. And we submit, having regard, and we will almost submit the obstructive stance throughout these proceedings, and I don't want to get personal towards anybody, but they were obstructive with respect. They should come out of their corner and identify whether today or within a few days or within a week, which internet procedures or which whatever they can use through the internet or through the cell phone procedures regarding RICA and FICA, what exactly can they use? But to expect that they're going to bona fide answer that is a different question.
I thought, I don't know if they were obstructive because of their own accord. They did something which is somewhat embarrassing, and that is to admit that, you know, we had so much so that we identified over 1,000 people that were irregularly registered.
Yeah.
If you are not cooperative, if you are being obstructive, would you come up with those details of your own accord?
Yes. If I may just refer to... my learned colleague argued that 7 million voters doesn't have addresses, with reference to volume 5 on page 421 and 422. Volume 5, pages 421 and 422. That's a table that they dealt with in paragraph 66 of their answering affidavit. Now, it is clear from the answering affidavit that these addresses are unavailable in their system, not unavailable as objectively spoken. So if they could afford to, with 2 weekends promotions to reach approximately 4 million voters, what more can they do if they really go about and canvass and advertise? I know they plead poverty, so to speak, but they should just go ahead and do what they are required to do since 2003, we would submit.
You have familiarized yourself with their explanation, haven't you? You have familiarized yourself with their explanation in relation to the difficulties that confront them in this regard.
They raise a lot of difficulties.
What is it about the difficulties they outline that you believe is questionable, is of no substance?
Well, the mere figures that they were able to reach through the 2 weekends during April and March, proving that about 4 million, if I remember the figure correctly, addresses were obtained. 12 million can maybe be reached within a month. I know we are speculating here, but they should do their function properly. Chief Justice.
Mr. Bosman?
Yes.
Mr. Bosman, this side.
Sorry, Mr. Justice.
I'd like to come back to the appeal.
Yes.
I just want clarity on what your case was in the Electoral Court. Was there a breach of Section 8.3? Was it based on a breach of Section 8.3 or of Section 16.3? And what was the exact, what does the breach consist of in relation to either one or both? In other words, what did the IEC do wrong? Very briefly.
Well, the lack of the voters on the list, and it was, I think there was a typing error at some instance referring to a Section 18.3 where it should have read Section 16.3.
So I just want to know, as I read the Act, Section 8.3 creates the obligation on the IEC to ensure voting in correct districts.
Correct.
Section 16.3 creates an obligation to provide addresses to political participants in the electoral process.
Yes.
Now, I want to know on which one of those two sections do you rely, which one was breached, and how were they breached? What did the IEC do wrong in each case?
Yeah, the main course of action, so to speak, Justice Fruneman, was Section 16.3, and it appears from the Weapner judgment as well, and the lack of addresses. That was common cause. I think the Commission even mentioned a bit higher figure, but the figure is not, we submit, important. The fact is there were quite a lot of addresses that were lacking in the voters' roll. They couldn't canvass properly, and they couldn't properly function as spelled out in the COM matter in the relevant paragraph 60 onwards that we refer to in our heads.
And is it clear from the papers, please help me, that the alleged lack of addresses related only to post-2003 or even before that?
It was not, if I might just speak to my junior. Justice Fruneman, apparently no mention was made to that specific aspect. It must be remembered that an urgent application was brought. And I think it is also canvassed in the papers that literally a few hours before the start of the proceedings before the Electoral Court, the answering affidavit of the Commission was filed. So
I'm not asking for a justification for the papers. I just want to know what the case on the papers was.
Yeah.
And do I understand you correctly that on the papers it wasn't clear whether your case was breached only on post-2003 breaches or even breaches before 2003?
Yeah. Justice Fruneman, it seems to be that that particular issue, as I told you, was not canvassed at all before Justice Weapner and the other justices of the Electoral Court. But whilst on that, much debate has
I'm sorry to interrupt, but do I understand you as a matter of law today you restrict your submissions only to post-2003?
Yes. Yes, that is correct. And the lack of there was, as was put by, I think, Deputy Chief Justice, the Electoral Court was also challenged before the Electoral Court to answer that allegations and to raise a defence if they could, which was not done, we submit. So there was, in our submission, nothing wrong in the judgment of the Electoral Court. Unless there is anything else, the last aspects that we will briefly refer to.
Mr. Bosman, could I just get clarity on the impact of your case? So you would say that if any voter doesn't have an address where it was available objectively, that voter should not be able to vote in the upcoming local government elections?
Well, if the roll doesn't contain an address, does not mean he can still register, he can still go to the station and register.
Subject to your Section 7 solution.
Subject to the Section 7 solution.
And if the Section 7 solution, on the basis of the concessions you made in the debate with Justice Madlanga and the Chief Justice, doesn't apply, then what? Do you say that those voters shouldn't be able to vote in August?
Well, we don't say that. We don't say that. If there's any measurement or any solution to the problem, the aim of the Constitution, and we are 100% behind that, is to let everyone that is eligible to vote during the elections. That is the main.
So you're not opposed to the court trying to craft some constitutionally and statutorily responsible remedy on the basis of the evidence before it?
On the contrary, Justice Cameron, we initially thought that the solution offered by my learned colleague for the IFP was a possible solution. We considered that, and we also considered 7.2, which we proposed as a mere proposal. But we are 100% for some sort of a solution.
Mr. Bosman, two questions. The first relates to the application for leave to appeal and the appeal. On your case, if the appeal fails, what would be the consequences?
If the appeal fails, then comes into play the question whether the direct application should be allowed or not.
What would it mean for voters who are on the roll without addresses reflected?
Yeah. No, we have considered that proposition, Justice Masaniki. If
a matter of law.
Yeah, it's a matter of law.
If the appeal fails.
If the appeal fails, the only application that is still alive is the direct application. Now, if the court comes with some or other solution as raised by Justice Cameron, whatever this...
You have the solution already. I'm still talking about about the appeal. I would like to know, what do you say the consequence of the Electoral Court judgment is for voters whose addresses don't appear on the voters' roll since 2003? Well, what is the consequence of the judgment, if any?
Of the Electoral Court's judgment? Well, the consequences is that the elections were postponed, and the certification was set aside, so the elections couldn't go on.
Okay, we're struggling, aren't we? Let's start again. Let's try it bit by bit. Section 8.3, read together with 16.3, has appeared from the debate between you and Justice Froneman. The one imposes a duty to vote in the correct district, and the other a duty that the NCIC should ensure. And 16.3, of course, requires finishing of the roll.
Yes.
Do you agree with that?
Yes.
We have before us an appeal against the decision of the Electoral Court. And the basis of the appeal is that on its reasoning, it has made the entire roll vulnerable to the extent that there are voters whose addresses do not appear. And by implication, IEC would have to find all the addresses of voters whose addresses don't appear. Is that your understanding of the effect of the Electoral Court judgment?
That's how we understand it, yes. Obviously, in interpretation of the COM matter as well, because the Electoral Court intended to follow COM, obviously. And where addresses are available, not as meant or as argued by my learned colleagues, for the Commission, if it's in their system, if it's easily ascertainable or ascertainable, practically speaking, they must get those addresses.
I agree with you that available means objectively ascertainable.
Yes.
Then those who appear on the roll without addresses would be barred from voting. Is that your legal reasoning?
Deputy Chief Justice, and I'm saying it with all the greatest of respect, this court finds itself in a proverbial sense between...
Let's stick with the law for a moment, please. Let's just unravel the law. We can come back to our difficulties and so on. What do you understand the Ham judgment to mean?
Well, the Ham judgment is in our submission clear.
And in particular, does it mean that all those who have no names recorded against their names may not vote?
Yes. Well, if their names are not on the roll, it means, with respect, as we interpret COM, and more particularly the passages that I briefly referred to, that the roll, the voter's roll, is suspect, so to speak. And to go ahead with elections on such a roll would be contrary to the intention of the Constitution and with the intention of the Electoral Act, more particularly Section 16.3.
What do we do with the qualification that says, if available?
If available, as with respect put or raised in questions by the Honourable Chief Justice, if it's practically or easy ascertainable to get those addresses, they must get it. It will well mean that the situation that was created since 2003 until now, the inaction by the Commission, created a situation which is an unfortunate situation, but eventually the elections that goes ahead should be free and fair. And if there are a lack of addresses, if I may use this example, a ward that was created, so to speak, after 2003, on the version of the Commission, they would contain most probably most, or if not all, the addresses when they registered the voters. The wards that was created before that would not contain all the addresses because 16.3 only came to see the light in December 2003. That is the one situation. The other situation is where voters go from the one ward to the other or from the one district to the other. If there are no addresses
If the appeal succeeds, and then what would be the legal position?
The legal position is then that it means that the Electoral Court's decision is set aside and probably the elections will go ahead. That's how we see it.
I'm not talking about the elections in Tlokwe. I'm talking about the legal consequences. If we were to set aside the Electoral Court's judgment, what would that mean?
As we interpret it, Deputy Chief Justice, it will fly in the face, so to speak, of the COM judgment and the interpretation of the relevant laws, more particularly Section 16.3, if the appeal would succeed.
I don't understand most of the submissions you make, but I hear you. Thank you.
Well,
thank you.
Something just dawned on me. If at the end of the day we accept the IEC's explanation,
yes,
that it is unrealistic it is impracticable to have the addresses ascertained and linked to the names that don't have addresses on the common voters roll before the elections are held in August.
Yes.
Why does that not accord with the construction of where available that suggests
yes.
that those are the addresses that are not available? And because they are not available, you don't have them to be able to furnish the parties with them before the elections are held.
Yeah.
It is unjust to make an order that says, do it anyway because you are supposed to have done it from 2003. It's not just and equitable to make an order like that.
Yeah.
What's wrong with that argument?
Well, we submit that the position is that, to put it the other way around, to endeavour to answer your question, Chief Justice, is if they take action immediately and get more addresses in compliance with 16.3, they would at least minimise the effect, the negative effect, at least.
I don't understand the IEC to be saying, we now appreciate the need to obtain addresses, but we're not going to do it.
Yeah.
I understand them to be saying, we're working towards that, but it won't be possible for us to accomplish that mission before the local government elections are held and before the 2019 elections are held.
Yes.
Now, are those addresses available within that context then?
Sorry, Chief Justice, are what available are the?
Those addresses which it will require a long time to ascertain available for the purpose of compliance with Section 16.3.
On their version, it seems not to be possible to obtain those addresses. But as we submitted, at least they can minimize the negative effect.
Well, on that understanding, is it appropriate to then say, the addresses are not available, but do what you can in the meantime?
Maybe say they should be ordered and they must come to with.
I beg your pardon? I need your assistance, Mr. Bosman.
No, I know, Chief Justice.
Yes.
Yeah, I think they should be put on terms. If the direct applications succeed, we would submit that they be put on terms.
Okay, so you, in principle, you are not averse to finding a solution along those lines?
No, that's why we proposed.
Okay. What are the terms?
Say again.
What terms must they be put?
Well, they put certain proposals to this court, which is totally, we submit, we cannot challenge that, but it is proposals that's not practical, it seems. If one has regard to the 2 weekends during which they endeavoured by advertisements on the radio, etc., to make contact with voters, and in the process they reached approximately 4 million voters.
What then would be reasonable in the circumstances, in view of the concern that you have that they are able to do something, they ought to be able to do that which they are able to do? What are the reasonable terms that we must that you propose with that understanding?
Yeah. Well, we know, Chief Justice, that the voters' rolls are to be certified by the end of this month, we understand. So we have little time, but there is still time. Now, whilst on that score, so to speak, yeah, we sought in our heads of argument dismissal of the leave to appeal, and in the same vein as the IFP, if leave to appeal is granted, to dismiss the appeal with costs. And the direct application also stands to be dismissed, we submit, with costs.
Let me ask you this question. Is it open? Do you think, is it a reasonable a proposal to make to the parties that, well, judgment will obviously be reserved, that between now and the production of the judgment, if we have to get to that point, parties try to reach out to one another and find what you call a reasonable, or reasonable terms that could then be furnished to the court to consider, all designed to ensure that the elections happen, but subject to an effort be made to comply with such legal requirements as might not have been complied with within the time available to them, to do the little bit that they can do.
Chief Justice, it seems that this particular case before this court enjoys wide coverage in the media. If they could once again proceed, possibly, to advertise by SMS and on radio and possibly television. And I know my learned colleague addressed you on the lack of funds, but we submit that it is one of the proposals that maybe, or one of the campaigns that may be considered that is fairly quick and fairly effective, having regard to the recent history.
Yes, I'm asking whether the parties can find each other, can make an effort to find each other in the interim. Is there room for that, or have you explored all available avenues? You just can't talk to each other, you just can't find a solution to this problem?
We may definitely endeavour to do so, Chief Justice, and it will be in the interest of everyone concerned, we would submit. Then lastly, the question of costs, I'm not going to address you fully on that.
Before costs, Mr. Borsman, I just want clarity on a response you gave to a question by my brother, Justice Froneman. You said, as of today, you are only looking at the obligation insofar as post-December 2003 registrations are concerned. What, or rather you say your case, yes, concerns the obligation as from that date. I'm not sure that you actually referred to which registrations exactly.
No.
What arises from your response is this possibility. It may mean that you are saying the obligation itself arose under Section 16.3 with effect from December 2003 or after December 2003. But how that is then to apply is not necessarily that only addresses, the obligation is not necessarily that it addresses post-December 2003. What exactly is your point? The obligation starts from December or post-December 2003 and applies only to registrations post-December 2003, or the obligations comes to life then but applies to pre- and post-December 2003 registrations. What exactly is your point?
Justice Malonga, on the papers, it's clear our version, our client's versions are that not only new registrations, since either the COM judgment or post-2003, all voters' that's addresses can be obtained. Pre- and post-2003 must be obtained. That is the purpose of the Act. And that is the only real purpose that can really effect an election that is fair and free, if that can be reached. And I know of the difficulties that the Commission has, but that is how we interpret the Act, and more particularly Section 16.3, Justice Matlongo. Unless there's anything else, thank you very much.
Thank you very much, Mr. Bosman. Mr. Katz, while you are settling, which issues are you going to focus on?
The DA submits that the appeal, such as it is, because I want to come to it in a second, should not succeed. In order to analyse that, we would ask the court to turn to page 377 of volume 4, where the order appealed against will be found.
Are you going to insist on your 10 minutes or not?
May I ask for 5? May I ask for... Thank you, Chief.
What page?
Page 377. I'll come to that in a second. That's as far as the appeal is concerned. I'm going to turn to page 377. One sees the amended order made by the Electoral Court, and we will submit that the appeal should not succeed. But I'll turn to that in some detail. As far as the second, more difficult issue is concerned, assuming the appeal does not succeed, the question is, what does the court do? And that's a more difficult issue, which I would wish to spend a little bit of time on. As far as the second leg is concerned, the Chief Justice had a debate with our friend for the Minister. And the debates, as we understood it, centred around the question of where does the court get the power to make any order that is just and equitable on the particular facts? And we would submit that there are two legs. One is the court has the power by virtue of section 172(1)(b) to make any order that is just and equitable, even in the absence of a 172(1)(a) order. And for that we rely on the Ermelo case, as well as Minister of Safety and Security versus Van der Merwe, a judgment of the Chief Justice before he became the Chief Justice.
Are you hitting me with my own judgment?
If that's how you see it, Chief Justice, yes. But the issue is this. If I understood the debate, it was this. In order to find a 172(1)(b) remedial order available, there needs to be some understanding or finding that there was unlawful conduct by someone. On the papers, the court can find, and must find, we would submit, that the IEC have acted unlawfully since, on their own version, December 2003. So once one has that unlawful conduct as a foundation, this court is then free under 172(1)(b) to make any type of just and equitable order, notwithstanding that there's no 172(1)(a) order that is to be made. And that's what your Chief Justice, that's what you said in Minister of Safety and Security versus Van der Merwe. As to that second leg, we will ultimately propose an order along the lines, well, not an order, propose a suggested solution along the lines of the parties coming together, but in perhaps a more nuanced and difficult way. We would invite the court to invite or order the IEC and those who support the IEC's version of events to propose to the court within a few days or a week an order that they would see as just and equitable on the assumption that the appeal fails, but not the order that they've asked for, and give the other parties an opportunity to respond to that order. And the reason I say that is because through the debate that's come through today, one sees that the 16.3 purpose has twofold. We know this from come in any event. The one is the functional utility of canvassing, and secondly of verification. Now, on the IEC's version, canvassing is to protect the canvassing functional, I've lost the word, purpose. It's going to be impossible on their version. Verification, not necessarily so, because there could be some mechanism that the IEC could put in place that those who turn up to vote, whose addresses are not on the voter's roll, provide proof, and not along the lines of the IFP's version, but along some other lines, that they provide proof of their address at the time of voting, whether it be a Vodacom, perhaps that's given last week's judge, now, a cell phone type address, a FICA type address at the voting station at which they are, so that there can be a protection of that second functional purpose of 16.3, which is a verification, coupled with the type of order the potential for the type of order which could set aside a particular election in a particular ward were a particular set of candidates or parties to approach a court, the electoral court, to suggest that there had been the kind of difficulties that were experienced in Tlokwe. So that's broadly what I intend to deal with. Let me turn to the appeal first. On page 377, one finds the order that, and Chief Justice, I suppose, the few minutes that are asked as the window, I will waive going forward.
You want to waive?
I'll waive from now.
Yeah, no, then let me zoom in then. You have reminded us, indeed, of two judgments, one by the Deputy Chief Justice and the other by me, where we said, quite frankly, I had forgotten, where we both say, you need not find that there is a law or conduct that is inconsistent with the Constitution before. You can make a just and equitable order in terms of Section 172. Now, that opens the possibility for crafting an order that could facilitate the holding of elections, notwithstanding the challenges that are there.
That's right.
Maybe let's focus on that possibility.
Yes.
What in relation to time frames, if the 4-year or so period were to be found to be unreasonable, what period would you say is unreasonable, and why do you say the particular period you propose is reasonable as opposed to that proposed by the IEC?
May I?
On the facts.
I will try to answer that in a second, but Chief Justice, may I, with your leave, touch upon something that would underlie the type of order that you've asked me about, and that is the appeal, because not unimportant, the order that is being sought to be appealed against, and were it to be found that the appeal would not succeed, for purposes of answering the question as to the 172(1)B question. On page 377, because the submission is the court would have to deal with the kinds of orders that were made by the electoral court in determining the 172(1)B just and equitable order. The first is, the 4 orders were made are found at page 377. The first, and one sees an amended order. The reason for the amendment, as I understand it, is that there were originally 7 wards that were sought to be the elections in 7 wards, and then as the papers developed, it only became 6, and that was the result of the amendment. That prayer 1, we would submit, is moot. It's got no relevance for purposes of this court. Similarly, in respect of prayer 4, and as I understand it, the court has, subsequent to this order, made no orders to cost as a final order. So it's really prayers 2 and 3, or paragraphs 2 and 3 of the amended order, that is the subject of the appeal. The first is paragraph 2, which says that the certification of the voter's roll, which is the subject matter of this case, is set aside. So the first order of business for purposes of 172(1)B would be to protect the voter's roll despite it not complying with section 16(3) and come. There would have to be some kind of order under this 172(1)B broad remedial just and equitable jurisdiction that protects voters' rolls which don't comply with section 3. Otherwise, one would have the consequence that a voter's roll similar to the Tlokwe one would fall foul, and the whole election would be subject to the type of nullification that occurred in paragraph 1. Similarly,
would it be an option, while you're still there, to say it is a practical impossibility for the IEC to comply with section 16(3) in the time available? For that reason, 16(3) must be understood in this case to mean that those addresses are not available. But make an order that says, just thinking aloud, I haven't processed it, I must confess, this has been a very difficult case for me. 1, the IEC must do everything within its power to verify those addresses that are capable of being verified in the meantime. But more importantly, cut down on the 4-year period required. Maybe I'll understand in due course, but I've got difficulties with reconciling myself with the 4-year period. Reduce that period within which compliance with Section 16.3 would take place. With the result that come 2019, we have a common voters' roll that complies with 16.3 effective from 2003, accepting, of course, that there are places, if I may give evidence. Just on Saturday, I was talking to somebody in one village. He lives in a shack. I said, "What's your address?" He said, "I don't have it. They have not written addresses on our shacks." Accepting for that reason that some people simply don't have addresses, no number, nothing. And therefore, they are not those in relation to whom the IEC is required to provide physical addresses. Yes. Would something along those lines provide a model or the basis on which an order can be crafted?
The DA would support an order of that type, subject to one caveat. One of the serious difficulties that the DA identify, which is not on the papers, but it's in our heads of argument, is that by-elections by their nature are subject to the kinds of, let's call it, difficulties that Tlokwe experienced rather than general elections. By their nature, in a by-election, or in a general election, the voter has one vote which he or she may cast in a particular ward. Let's assume there's a voter who votes in the wrong ward. Busing takes place, or so whatever the problem is. In a by-election, that voter who's now bussed doesn't lose his or her right to vote in his correct ward.
How can that be? Because when you vote now, there's a particular ink that they put on your finger. So if they have put that ink now on my thumb, and I go to another station during the electoral period, the people have got a scanner now, and I've tested this ink as well as you have. It takes some time to clean it up. How can the scanner not detect?
That's our point, Chief Justice. That's our very point.
So the busing doesn't arise, does it?
In a general election.
But in a ward, don't they use ink in the municipal elections?
Yes. So Chief Justice, I'm with you.
Yes.
I'm making a different point.
Oh, and
that is the difficulty in a general election, which is when all the wards vote at the same time, let's say on the 3rd of August. I would go to a particular ward, my finger would be inked, I wouldn't be able to go to another ward. And whether I was in the wrong ward or not, I would lose my right to vote in the correct ward. In a by-election, that problem, or that mischief, or that difficulty doesn't arise because it's only one ward that has an election. So I would arrive at the ward, I would vote, even though I wasn't entitled to vote at that ward. I wouldn't miss out. There would be no problem because I'd have an extra 100 or an extra 1,000, whatever the number would be, voting in a ward where they weren't entitled to vote.
I see your point. You're saying, and I'm just thinking aloud, if I wanted to disadvantage my political rivals as a party, I would check where am I stronger. And if I can bus people without losing that ward,
that's right,
I would take the extra people to some other ward so that even where I wasn't supposed to win, I can win.
Yes, and the reason we make the point, the DA, is to deal with, Chief Justice, your point about, let's assume that the 2016 election goes ahead without addresses. But by 2019, the addresses must be there. The DA is very concerned about the by-elections that would take place for example, between 2016 and 2019, because of that difficulty that effectively, Chief Justice, you yourself have identified.
And it's a problem we can't do anything about if the period doesn't allow. We can't do anything about immediately.
Well, we would suggest that you could, because part of your just and equitable remedial discretion could be, for example, to say when it comes to a by-election, by their nature, the work of the IEC is far less pronounced than for a general election. So one could give the leniency, as we call it, for this 2016 election, but for no further election.
I think we will then have to leave it to Mr. Trengove when he addresses us with the benefit of some information being passed on by his clients, whether it is a feasible option.
But I do want to put that as part of the...
Yes, no, I see your point, yes. Whether I agree with it or not is another story, but I understand your point.
So we would suggest...
Just before you go past there, let's just get something clear. Both Ermelo and the Van der Merwe cases make it quite plain that you have to find unlawfulness. The remedy is not available for asking. You have to find something wrong. It need not be a declaration of invalidity of a statute. What would we find unlawful here?
The IEC having failed to comply with their 16.3 duty from December 2003 to date. That would be that finding would be that from post December 2003 there hasn't been compliance with.
That is very seductive, I think is the word. But let me tell you, the subject to what Mr. Trengove is going to say when he gets up his feet. Their position has been the addresses are not available. We have done nothing wrong. We have meticulously kept addresses from 203 if and when they were available. So how do we get to a finding of unlawfulness?
Well, I would like to give the court three answers in a sense. The first is, one, this court has already found that there was unlawful conduct by the IEC, at least in respect of Tlokwe, in the Come judgment. So Mr. Trengove would be hard-pressed to say that the IEC has never done anything wrong because this court has found that it's done something wrong.
Mr. Marcus, he says the issue was 4,000 voters and the addresses were not available and there can't be anything wrong.
Well, if one looks at 5A of Come, it is declared that by-elections conducted, and this was a rejection of the Electoral Court upholding the by-election, if the court recalls. This court in 5A, it is declared that the by-elections conducted in Tlokwe on 12 September 2013 were not free and fair. There's no room to argue that there has not, at least in one instance, on one particular by-election, been a violation of the constitutional demand of free and fair election.
It sounds very attractive, but in fact, it's a little more intractable than that. I'm talking about historical lapses from 203.
Yes.
How do we come to the assistance of the IEC if its attitude is we have recorded as well as we could from 203? If we should have a concession or a fact that shows that. Page 422 shows us that there are about do I have the right page? Shows that there are about 5.5 million people who have not been registered. But I haven't had them concede that that number indicates people with addresses that are or may be available. So we have to get to a solution and we have to get to a remedy, but remedy is not there for the taking. It is there when there's an unlawfulness.
I would borrow from Mr. Marcus in the Nkandla case where he acted for the other Chapter 9.
No, we don't have to get there. Shall we stick
his point was this.
Shall we stick to our knitting?
His point was this, if I understood it correctly, that even were in that case the President or Parliament to have misunderstood the law for whatever reasons, but they were bona fide, he relied on pharmaceuticals. That doesn't say the lawfulness of their conduct. So even if the IEC made every best effort and it perceived that it was complying with 16.3 in whatever manner it did, this court came to the conclusion that it didn't fulfill its 16.3 mandate. On pharmaceuticals, this court would be quite obliged, it would be obliged to find that that conduct was unlawful. And just, if I may pick up, if I may just for a second, if we read D in the way that we would suggest it's clear, the obligation on the IEC extended not just to post-2003 registrations, but to all registrations. And the IFP picked this up quite well, because they suggest, how many of us, 20 years later, are ordinarily resident in the same address that we had, for example, in 1998?
Carrying it far now, aren't we? Because you have to defeat the argument that says that there was no duty to keep addresses before 2003. If there's no duty and IC did not keep it, that's the end of that one, isn't it?
No, with respect. It's only the end of it as far as the potential unlawful or potential finding of unlawful conduct pre-2003. But once 2003 came along, then when a political party or candidate...
Show me the provision that creates a duty for the IEC to keep and disclose addresses. Before 2003. Before 2003.
No, before 2003, there was no duty on the IEC to provide addresses.
Oh, so we're in agreement, right? Okay.
Well, subject to the first sentence in paragraph 94 of COM, read with some of the questions that Justice Madlanga put, that there may well have, and this court doesn't have to go there, that there may well have been a duty under the Constitution to keep addresses for...
But do you accept that COM did not create any new law?
Well,
it sought to tell all of us what 16.3 requires, and 16.3 was made by Parliament.
That's right.
So we didn't create law, we didn't purport to. We just highlighted the duty that sits plainly in the section.
Correct.
Very well. So just my last point here is, what is your submission about what unlawfulness do you say we hold? Because if we do, it would be very unhelpful. Because it will get us to a solution. If we don't, I'm afraid it will be quite a difficult conundrum.
The submission is, if I may just qualify, I agreed with Deputy Chief Justice, your question to me, when you put it to me, that all that COM did was clarify what the law is. I accept that, if that was your proposition to me. But I just want to clarify my answer by saying, to the extent that D mentions all future municipal elections or by-elections, we would submit, meaning can only be given to 5D if it includes all voters, not just those voters who registered post-2003. That would be our submission.
Application where available is right there in the order.
And where available as...
It's an echo of the law, that's all that it is. It's an echo of the statute.
Yes, no, we accept that. But we would submit that where available means not objectively verifiable, not on the basis of, well, as the IEC would put it, it's not on their system, therefore it's not available. That's their line. It's not on the system, therefore it's not available. And therefore they've complied. But that's their argument. The high water, low water mark, and the middle mark of their argument. We disagree. And if the court is with us on that understanding, that where available has an objective meaning rather than the subjective meaning which they ascribe to it, then we would submit that the 172.1b remedy is available because they haven't done that which is required.
Mr. Katz, I'm sorry to interrupt you. Can I debate your reliance on Section 172 with you, because it really concerns me. Ermelo and Van der Merwe, can we start there, are not authority for the proposition that a court can order
condonation with non-compliance with a statutory requirement, or can order suspension of the operation of legislation. Do we agree there?
Well, as I recall the cases, they did not, this court did not order the suspension of the operation of a law for a period in those cases. But there's nothing in principle why the propositions or the findings of that court concerning the disjunctiveness, the disjunctive nature between A and B could not apply to, for example, the suspension of an operation of a valid law of Parliament. So that, for example, and why I refer to Van der Merwe in particular, is the first sentence of paragraph 59. The Chief Justice makes the point, in this case, in the Van der Merwe case, there's no law which has been found to be invalid.
I accept that. I accept that. Am I correct to say, Section 172, it is not a jurisdiction conferring clause? If you want to find the jurisdiction of the Constitutional Court, you go to 167. Supreme Court of Appeal, you go to 168. The High Courts, you go to 169. Are we agreed?
Agreed, we agree.
Okay.
It's a remedial.
And those sections, none of them say any of these courts, including this court, can suspend the operation of legislation. None of those sections say that.
Let me go back 15, 20 years where, for example, and it was, if I remember, Chaskelson CJ put the proposition to the government in that, to the UDM in that case. Let's assume tomorrow Parliament pass a law allowing for the death penalty. And before the law comes, and the law is going to come into operation in a month's time, whatever the situation would be. The debate centered around the following. Would it be appropriate for the court to strike down the law, as the High Court did in that case, without proper consideration of the issue, or would it perhaps have been preferable, which it was suggested in that case, for the operation of the law to be suspended pending something or other, pending the challenge to the law? Now, I understand that we're not in that territory in this case, but on the IEC's facts and on the assumption that the IEC did get it wrong in some respects, we would, as a matter of principle, suggest that this court should have no difficulty in suspending the operation of a law on the particular facts that are available in this case. Because if the court wasn't able to do so, and the appeal would succeed, it could have the effect of nullifying the entire election in August 2016, because the IEC, on their version, can't comply with the law for this particular election.
You see, my difficulty lies in there. What would be the source of the power that the court exercises? Because I said to you, if we have to check the jurisdiction of the Constitutional Court, we have to go to 167. If 167 doesn't tell us that, now we go to 172. 172 says a court that decides a constitutional matter within its power, okay, which is in line with what we have in 167. The Constitutional Court deciding a matter within its power.
Yes, and its power would be in 167.3. We would suggest. 167.3, sub 3, where the Constitutional Court is the highest court. B may decide only constitutional matters and issues connected with decisions on constitutional matters. And plainly, we would suggest this is a matter, well, we would suggest it's a constitutional matter, and certainly the types of issues that we've been debating, if not constitutional matters, are certainly issues connected with decisions on constitutional matters, which kicks in the 172 1B remedial power.
No. I'm not saying this matter doesn't raise a constitutional issue. You misunderstood me. It does. The question is whether this court has the power to suspend a law that is in operation. That's my difficulty. And I say to you, 172 says a court deciding a matter within its power.
Yes.
We need to find first, before we go to 172(1)B, we need to find first whether suspension of legislation that is operating is within the power of this court.
Yes.
Isn't it?
Yes, and we would suggest, yes, thank you, Justice Jafta, that 167(3) would give the court the answer to that the power to suspend a valid law, parliamentary law, is certainly a constitutional matter. It's a constitutional matter, and then this court has the power, the jurisdiction, to decide that matter. Once this court has that jurisdiction, power, I take Justice Jafta your point, but we would suggest that we do have the power because of 167(3), sub 3, and then the question of what to do comes under 172.
Well, my last question was going to be, but I think you have answered it already, was going to be, doesn't 172(1)B suggest that the just and equitable order that the court makes under 172(1)B, it's an order that falls within its jurisdiction. It can't, it can't do something that falls outside its jurisdiction. Therefore, if this court doesn't have the power to suspend an act of parliament that is in operation, it can't, under the guise of 172(1)B, grant that order.
And that must be right, Justice Jafta. I mean, the point, I suppose, to answer the question is to say, well, when deciding a constitutional matter within its power, of course, the issue must be within its power. In order to determine within its power, one jumps back to 167. And 167 does not preclude the court from suspending the operation of an order. If it's a constitutional matter, and it clearly is a constitutional matter, to suspend the operation of a valid piece of legislation in the particular circumstances of this case. So we would suggest the court has the power, the jurisdiction under 172(1) kicks in, and then B allows this court to do that which the IEC asks it to do effectively.
Finally, in respect of remedy, if we were to find that the IEC has not complied with Section 16 sub 3, and we can't condone its non-compliance with that section, wouldn't it be a matter that Parliament can appropriately deal with?
I'm not sure that Parliament can deal with it between now and it's not just the 3rd of August, but if I understand the IEC's appreciation of the law, it's now, end of May, 3rd of June, they say. There must be a period of time before the election for the voters' roll to be certified. We know that as things stand, they can't, on their version, comply with the requirements, the lawful requirements of certification within that time period. And we would submit it could never be regarded as just and equitable that, for example, and the court has made it plain in the debate, that the option of a postponement is even on the table. So what are the other options? One of them is this question that I've been debating with you, Justice Jafta.
No, I was just putting that we're trying to find a solution, all of us here. I was just putting that in the event that we find the law does not allow us to fashion a just and equitable order which will facilitate the holding of elections on the 3rd of August. From now, between now and the 3rd of August, can't Parliament attend to the matter and even suspend? It has the power to suspend the operation of 16.3, doesn't it?
I haven't applied my mind, and I'd be hesitant to give a full answer to that question about whether Parliament has the power to amend its own legislation to have the effect of suspending the operation of its own legislation, it's not something that I've thought through.
Let me just, I need to explain myself. There are times when one judge puts a question, you answer, another one asks a question as if he's seeking to contradict the another judge. That's not what I'm doing. Is this a matter that will require the participation of provinces or not? I'm just trying to reflect on the time frame. Because if it's something that falls squarely within the power of the National Assembly, that's quite an attractive option. Can just quickly meet, amend, and that's it. But it may be problematic if there has to be consultation with provinces. Takes its own time. And then are you able to tell now whether it will involve provinces or not?
I can't tell now, but what I would argue is
we will look at it if you don't have an answer.
No, but what I do want to say, Chief Justice, that were the court to find that the province's input was required, we would suggest that there's no reason why the municipalities and SALGA's input ought also not to be required. And that just would create a minefield of difficulties.
But back to the reason for my preamble, I need clarification. When a court has arrived at the conclusion that a piece of legislation is constitutionally invalid.
Invalid, sir.
Invalid, constitutionally invalid. It is entitled to suspend the operation of that section or legislation. So it is a power that it has within the context of Section 172. Now, if Ermelo and Van der Merwe permits us to make a just and equitable order in circumstances where there is no declaration of constitutional invalidity, but a conclusion has been arrived at that the IEC's conduct is unlawful in the sense that it ought to have provided addresses that were reasonably ascertainable and factored them into the common voters' roll. That's the unlawfulness. Do we, by reason of the power we have to suspend the invalidity of an act declared invalid, do we have, by reason of that power, to also suspend? I'm thinking aloud, that's why I need your comment. To also suspend, maybe even in certain respects, the operation of that unlawfulness of the IEC, even if it does not relate to a declaration of constitutional invalidity, with the result that is, this is unlawful, but we're going to make a just and equitable order.
That's how we.
And this is the Mr. Katz type of just and equitable. Is it open to us? I'm not sure what the answer is.
We would suggest certainly. And one will recall that where the court suspends the declaration of invalidity in legislation, let's put it this way, the distaste that one has is that for a period of time there's unlawful legislation that's being implied.
That you are allowed to operate.
That's the point. That's the point. And there's no difference in kind with the kind of order that we are suggesting for purposes of this particular general election.
I'm not suggesting it. I'm just thinking aloud.
When we suggest it, Chief Justice, we suggest it, and let me put it this way: the DA suggests it on the basis of the facts that have been put up by the IEC, particularly in reply to the facts that we put up. Because the DA put up certain facts in the answering affidavit in the direct access application, which seemed to suggest that the IEC hadn't done everything that they could have to be ready and compliant with 16.3 for this coming election. And in reply, the IEC put up certain facts which it's not in the realm or the remit of the DA to deny. So it's only on that basis that we come with our 172 1B read with 167.3 for purposes of Justice Jafta's question, just an equitable remedy.
In line, before my brother comes in line with what I put to Mr. Bosman earlier, is it an option to be considered that parties be not ordered, we can't make any order now, but be encouraged, albeit informally, that they explore the possibility of arriving at a possible order that is acceptable to all of them, that will ensure that the elections do happen?
Yes. I think I made the point. The answer is yes. In a perfect world, we could be put in a...
But I forgot to add, not waiting for the other side to come up with a proposal. They work on theirs, you work on yours, so that by the time the two proposals meet, a lot of spade work would have been done by both parties.
Yes. Perhaps Mr. Trendgrove could answer better than I, but as I understand it, there are committees within the IEC consisting of representatives of the different political parties which have attempted this. And as I understand it, there has been some sort of stalemate, if I may, stalemate is the wrong description. There has been an impasse, that there's been a logjam. So that's why I make the suggestion of the IEC coming up with their order, and then whoever wants to respond to it can do so within a few days, depending on this court's requirement. And if Justice Madlanga was going to ask me a question, perhaps
yes.
I should just deal with something.
Yes, please. I'm interested to know whether, and I would like Mr. Trengove to respond to this as well, even if I forget to raise the question with him. I would like to know whether in a constitutional state where the Constitution, or where a Constitution is the supreme law, there is any room for the applicability of the maxim lex non cogit ad impossibilia. I'm sure you know what that is.
Not often that I can say to a constitutional judge that he's being sure was wrong. So although you're sure that I knew it means I don't.
The one case I remember, I forget who the judge was, but I think it was a matter that was argued by the late Chief Justice Mohammed as counsel. It concerned the limited time periods within which to bring an action against the police. And there somebody had been held in detention in circumstances where he couldn't give instructions to attorneys and so on. And when the police insisted, or rather raised a defense, the defense that you are out of time, the court applied this maxim. Basically, it means you cannot insist on the doing of the impossible. That's what the rough translation of that would be. So I'm asking, in a constitutional state where the Constitution is supreme, would there be any room at all for the applicability of that maxim? I'm not at all trying to counter the point raised by my brother Justice Jafta, but I'm just trying to get assistance from counsel.
Mr. Trengove reminds me that it's Sinoli, if I remember the name of the case. But I think I'd like to answer it like this, off the cuff, without having had any thoughts percolating about the point. The answer is yes, but the court would still necessarily be restricted to 167 and 172. It would be a factor that would kick into the 172 1B type thinking. I would hesitate, and I haven't thought it through carefully enough, to suggest that principle could apply despite 167, despite the power under 172 read with 167.3.
Clarify one aspect, Mr. Katz, in relation to unlawfulness and the fashioning of appropriate remedy. Section 190 of the Constitution imposes certain obligations on the Electoral Commission. One being that it must manage elections of national, provincial, and municipal legislative bodies in accordance with national legislation. B, to ensure that those elections are free and fair. Now, assuming that this case also applied to the post-2003, if we found that these elections were not free and fair, it would mean that the IEC would not have discharged its obligation in terms of the Constitution. In that event, will it be open to us then to grant a declarator?
This court, we would submit that the answer is yes, and this court has already done so in Cum. The answer is yes. May I just add, it comes back to something that has been niggling, I think, Justice Madlanga. In answer to you, Justice Nkabinda, we would submit that although this court did not decide it in Cum, the first sentence in paragraph 94 of this court's judgment, which seems to suggest that even before December 2003, the IEC, in not having the addresses available on the roll, would not have satisfied 191 sub B, read with section 19. So the court knows our... Yes, perhaps I should read it. Perhaps I should read paragraph 94. This is the judgment of Wallace AJ for the full court. I can see force in the contention that in order for an election to be fairly conducted, it is necessary that the participants have available to them not simply a list of voters' names and identity numbers, but also some means of identifying and contacting them, of which the voters' addresses is the most obvious. And then there's reference to a case. But then he says, but it is unnecessary in the light of section 16.3 to reach a firm conclusion on this question. The simple point I make is, this court doesn't have to decide the case now, and it didn't have to decide it then. But we don't want to be seen to be suggesting that it's only because of section 16.3, which it is anyway, that it's necessary for a free and fair election to take place, that the addresses are on the voters' roll. Well, made of, no, not on the vote, that are on the voters' roll and be available to those who wish to stand for election, or who stand for election.
But will that not depend on whether prior to the 2003 amendment there was such an obligation?
Yeah, there was an obligation. 190, the section that Justice Nkabinda, you've read to me, section 191B, to ensure that those elections are free and fair. And what this court didn't deal with, it suggested there's an attractive argument for that purpose, that to ensure that those elections are free and fair, not with whether 16.3 was there or not, the candidates for election were entitled to a voter's roll with addresses for the purposes that 16.3 is there for purposes of canvassing and for purposes of verification. So to have a free and fair election, with or without 16.3, let's say without 16.3, there needs to be the addresses available to the candidates for purposes of canvassing and then verification. That would have been the argument.
T is an umbrella provision, so you'd have to satisfy us that even prior to 2003, there was a legislative requirement for the provision of addresses.
Well, Justice Nkabinda suggests that it's an umbrella provision is correct, but it's also a self-standing provision. It's a self-standing obligation under Chapter 9 of the Constitution that is hoisted upon the Electoral Commission. They must ensure that elections are free and fair. Whatever the content of that might mean would depend on a case-by-case basis. But this court suggested that it's a fair contention that that requirement would not be satisfied were addresses not to be available for candidates.
Let me put it this way. Maybe I'm just complicating the question. In 1998, the provision required that registration should be in the prescribed manner. So it means prescribed in terms of the regulations. What did the regulations prior to 2003 require? Did they require that there should be addresses? The pre-2003 position?
So with respect, Justice Nkabinda, the word "and" appears after 191B. So the prescribed national legislation that you're referring to is a self-standing requirement quite apart from the assurance that the elections are free and fair. The elections must be free and fair, and there must be compliance with whatever the prescribed national legislation refers to. But this court doesn't have to go there because 16.3 is there.
The Electoral Act prior to 2003, We know that there was an amendment in 2003. What was the position prior to 9/2003? Was there a requirement, a legislative requirement, requiring that addresses should be furnished? And if so, where?
No, there certainly was no legislative requirement. But we submit that there was a constitutional requirement, which is different. Self-standing constitutional requirement to ensure freeness and fairness, there was a requirement for it. That's the point that Justice Madlanga has been debating with various of the council throughout the day. And we would support the contention that in order to give effect to free and fair, addresses are required, quite apart from the existence or otherwise of Section 16.3. But there's certainly, prior to the introduction of 16.3, there was no legislative requirement of addresses for purposes of being provided to candidates for electoral office.
You were supposed to finish at 4:27. I know we are to blame. Have you not raised all you needed to raise?
Hope I have.
Yes.
As a pleasure.
Thank you. Thank you, Mr. Katz. Mr. Kemp?
Justices, may I first...
I suppose I don't have to declare that you are my lecturer.
If one waits long enough, Chief Justice, one always gets your own back.
Well, Mr. Kemp, you're not my lecturer, but I wondered whether you need candles now. Can you see well?
I shall be brief, Justices. I want to deal with...
Before you do that, should we give you 10 minutes uninterrupted, 5 minutes, or no time at all?
Chief Justice, give me 10 minutes.
Uninterrupted.
I shall...
As you do that, indicate to us what is it that you're going to be dealing with.
I want to briefly address the issue of availability, what it means, the importance of the IEC maintaining addresses even prior to 2003. I want to draw your attention simply to what the IEC said in its papers concerning the issue of unlawful conduct. And then I want to very briefly deal with the proposed solution that we have suggested as the IFP on the basis of you entertaining the application by the IEC. We are here today because what the IEC seeks here is an order to allow them to present the 2016 voters' rolls without being confronted with defects relating to absence of addresses. They anticipate such a challenge that if they certify such rolls, parties are going to embroil each other and the IEC on that basis, relying inter alia on the decision in Ham's matter in both the electoral and in the constitutional court. And what the IEC in fact states to this court is we cannot really, at this stage, it's not possible for us to give the addresses of all the voters. And I will briefly indicate to you why that concession or that premise includes also addresses that were available to the IEC. As far as that is concerned, what we say is
that the contention was that available means available to the IEC on its record system. We say, whatever it means in section 16.3, it cannot mean that. Because if it means that, then the IEC can simply decide what the extent of its obligation under 16.3 is by simply not putting it on their record system, or be tardy in putting the addresses on their record system. We say what available means is if the IEC has the capacity or the ability to provide the addresses the voter gave to the IEC, which premised its allocation of that voter to a certain segment of the voter's roll. In other words, it is implicit in the voter being on the voter's roll that he gave an address. And there's nothing magic about an address. An address is where you live. And we do know that the voters live somewhere. And they gave sufficient details to the IEC for it to decide in which ward these voters must be registered. So, we say, if one then looks at the papers, you can see quite clearly what happened. If one looks at the papers and one looks at volume 5 and one looks at page 418, one sees
18 or 80?
418, sorry, Chief Justice, at paragraph 60.4, although there seems to be a sentence missing, what the IEC says is that it originally considered that it wasn't under an obligation to maintain a record or to keep the addresses furnished to it. That is extraordinary, both as a result of what my learned friend Mr. Katz said with reference to paragraph 94 of the Kham decision. But if one looks, for example, at section 15 of the Electoral Act, that allows parties to challenge the inclusion of a person's name on the voter's roll. The first thing that that challenger must do, he must serve that objection on that voter. Now one can see the dilemma. The challenger says, he doesn't even live anywhere in this ward. I don't believe that he lives here. I want to serve this on him. And he says to the IEC, that is my objection. Where can I serve it on him? The IEC says, we have no idea where you can serve it on him because we haven't got his address. It is implicit, we suggest, on the scheme of the Act from 1998 that the IEC would keep a record of the information, of the data, of the addresses that caused them to put a voter in a certain specific district. We say, if one looks further in the affidavit that I've referred to, you will see that what the IEC admits, and if one looks for unlawfulness, in the case in which there was an appeal, and which appeal is before you, the Electoral Court said the unlawfulness was in you certifying a role that did not meet the requirements of Section 16(3). And that, of course, is the problem that the IEC has come to this court for and asked whether you can grant the relief in the direct application matter. On page 419, you will see that the IEC says that indeed, even after the 2003, the IEC was not especially focused on ensuring that every voter's address was fully and accurately captured on its systems. And it says that was because prior to that, there were few requests for addresses from political parties, and that the increased focus on the addresses only arose in the last 2 or 3 years. That does not take away that you have there a concession that they were not, even after Section 16(3) was put on the statute book, focused in ensuring that they maintain the record and keep it available of each voter. If this court then seeks for unlawfulness, it can readily find it in that conduct. The IEC's problem is, and if one for 1 minute forgets that maybe it was self-created, the problem is that if one looks at the application of 16(3) in the light of these circumstances and in the light of these legal obligations, it cannot really provide by 31 May voters' rolls that contains all the available addresses. For various reasons, they had let slip of some of the addresses. You will see that in the passages that I've referred to, and if you read from page 417 to 422 of the papers in volume 5.
417 or 470?
417 to 422. You will see that the IEC says in 1998, when the Electoral Act was passed, they had some 18 million registration forms. But they say not all of them have survived until today. I assume that is the fire that we've been talked about maybe and some of the other things. But the point is they had this information and it was available, and now they are, as a matter of fact, on their version not able to provide all the addresses that they had been furnished over the years. And it is to combat that impossibility of complying fully with Section 16(3) that has prompted the special application where they seek for this court to say, well, seeing that you cannot comply with the letter of the law, we are willing to grant you the relief that you may certify the voters' rolls without full compliance with Section 16(3). And in that regard, what has been asked and put by this court to my learned friend Mr. Katz certainly provides the basis for this court being able to furnish or to supply a just and equitable remedy in the light of the fact that it is impossible to comply fully with the Section 16(3) provisions with reference to the upcoming elections. Everyone here is of the view that the elections should go ahead. In the light thereof, one must then look at the IEC's application and say, well, if we grant that, it must be granted in such a manner so as to ameliorate the fact that there has not been and cannot now be full compliance with Section 16(3). In our submission, and we've made a proposal which is fashioned on Section 320 of the Help America Vote Act, that the voters' roll must then be published without the availability of all the addresses. And the one way of balancing it and giving effect to one of the purposes of Section 16(3), namely to ensure that a voter votes in the right district and no one else votes in such a district, to have the system of those people who do not have addresses voting and the two envelope system that the IFB have presented to this court. It is one way of ensuring that the parties can, post-election, because it is simply not possible to give effect to the canvassing purpose of Section 16.
Let us explore that. You've been very helpful in trying to find a solution. Let's explore that. You see, the difficulty with that seems to be that when a voter's name appears on the common voters' roll, that voter is entitled to vote. You need something to remove the name of that voter from the common voters' roll in terms of the law. And another complication comes up. I haven't quite reflected on it, but let me say it anyway. It seems to be the following. If in line with what appears at page, I made a note here, paragraph 61, page 419, if in line with that, having regard to that, that the IEC admits that it has not been recording the addresses of the voters since 2003, then you are going to have to go through, I suspect, the whole process that they say it will take them very long to go through for you to be able to separate those whose addresses are ascertainable from those whose addresses are not ascertainable. How are you going to tell that this one has a physical address? What do? You complete the form upon arrival, considering that it's millions whose physical addresses have not been recorded. How do you deal with that?
Chief Justice, as I understand the affidavit, the IEC has identified the voters who do not have addresses on their systems, and they have identified those who have inadequate addresses.
Let's confine ourselves to those who do have addresses, but there are some challenges. I understand their position to be that it's millions of voters whose addresses,
yes,
who have addresses, but addresses are not recorded. Now, how then, in terms of the IFP's proposal, would it be possible come election time to act in line with that proposal? What happens when you arrive and it's millions of you whose addresses are not there?
Chief Justice, as I understand the answer of the IEC, what they have been doing, they have 51,000 electoral officers.
52, I think they say, but it doesn't matter.
I also thought it was 52, but I was corrected. But Chief Justice, be that as it may, if each of them deals with 20 voters on the day, that is 10 million. There are approximately 12 million, and one must be realistic about it. We're not going to have 100% turnout. It's unlikely if one is practical and realistic about it. It does not seem to be impossible.
No, but what do you mean? They say it's not possible. It's not practicable to do that. And we can't leave anything to chance. Elections must happen, whatever remedy we fashion, must be capable of implementation, must be capable of yielding the desired outcome, which is elections must happen. So how then is it going to work out on the IFP reasoning? How is it going to be achieved?
Chief Justice, as far as that is concerned, what is necessary is, of course, if there is to be such a system to compensate for non-compliance of 16.3, then this court will have to fashion some order in those terms, because the legislation doesn't obviously make provision for anything like that. But it seems, and it's our submission, that it is by no means impossible, even if the IEC has to take into employment another 20,000 persons for that day. It does not seem to us to be an impossible task to have a very short statement from that person. He has to show his identification document in any case. To complete that form will generally, and Chief Justice, I do not accept that because rural communities are involved that they cannot very concisely indicate where they live. It is not a difficult job. Indeed.
Is it not a difficult or is it not an impossible task?
Chief Justice, if you ask most people, where do you live, they're able to tell you in a few sentences where they live. And in this case, what the system we suggest is that then that data, what they convey there, is made available to the other candidates. And if they don't challenge it, it goes ahead and they add those votes, and nobody knows who they come from, to the others.
Does your system not depend on the applicability of 7.2?
No.
Okay.
Chief Justice, as I understand 7.2, that applies to someone who's not registered. So we're dealing with people who are registered in this.
So your system depends on what for the removal of people from the voters' roll in which their names already appear?
No, Chief Justice, they are not removed from the voters' roll.
Conditionally.
They go there, they vote. What this system is designed to do is to give the parties who consider that these people may not have been duly registered a chance to object on that basis. If they don't object within a short period, then nothing of that sort happens. That person's status will in the end depend on whether there is a valid objection to him having been registered in that district. All that the system that we propose does is it allows the other candidates to, on an intelligible basis and with reference to specific addresses furnished to them, to establish whether there is any significant room for objection. And we submit that it is not impossible to do that. And if you ask me about the 4 years that we have been confronted with in which we have come here, I cannot give you any greater factual assurance that it can be done shorter, except a generalization that generally when there's an onerous task on any state body and they say they will complete it in 4 years, they can normally do it in 2 if it really comes to the push.
Let me just run this possibility through you, and then you can tell me how unworkable or objectionable you consider it to be. And that is an order that accepts that there is unlawfulness in the sense that there has been non-compliance with Section 16.3. But then it also recognizes that after before we get there, and then requires of the IEC to do whatever is reasonably capable of being done in the interim before the elections are held to get those addresses that can be reasonably ascertained, and essentially suspending the requirement that all the addresses that Section 16.3 requires that the IEC should have obtained from 2003 to date must be obtained before the elections can be held. So you suspend that partially. And 3, in line with, I don't remember whether it's Mr. Bosman or Mr. Katz, their concern relating to by-elections, you make an order that says all by-elections that will be held after the August 2016 local government elections must be held based on the voters' roll that complies with 16.3 insofar as it affects that particular district or those districts. Mr. Katz makes a point. He says, look, it's not for the whole nation that you'll be requiring this to be done. It's just a small area. So you can have all 62 of your employees, 52,000 of your employees in that area, cover it up and clear whatever needs to be covered. It's with that in mind that I'm raising this possibility. And then you say, as for the 2019 elections, the common voters' roll must be cleaned up, say with effect by May 2018, with the result that when political parties begin to ask for the common voters' roll, it complies fully with Section 16.3. All the resources that are required for the purpose of preserving the track record that the IEC has maintained over the years must be maintained, and that is to be done by cleaning up this, not within 4 years, but maybe 1.5 years or 2 years as the case
2 years
might be. Would you find that to be objectionable, or does it provide the basis on which a solution can be found?
Chief Justice, any solution that and any proposal that compensates for the fact that parties have not been able via addresses to check registrations. Will and I do not recall any of the parties before you today suggesting that that would not advance the principle of free and fair elections. That is always a question of degree and a value judgment. But it is an obvious step that needs to be taken, if it can feasibly be taken, to advance that even in relation to the 2016 elections. And what you have put to me, the IFP would, that is why we are here today, and why we say that the relief that was sought from you by way of direct access was simply unacceptable, and the IFP had to come here to make its case on that. Because if it did not come here, it would be confronted, if it complained after these elections about the voters' roll, with the argument that we could not keep this objection in our back pocket. We had to put it before the court today. And that is what we're here for and what we have done.
But the cleaner route would, of course, be that proposed by my brother Jafta, which is, remedying a defective legislation is the terrain or the domain of Parliament.
Yes.
And saying to Parliament, this is your business, Section 16.3 comes from you, it has created this problem, sort it out. Is it a feasible option, maybe? Because it's the better of all, the best of all options we could possibly think of.
Chief Justice, I'm afraid if that happens and Parliament decides to suspend Section 16.3 in a blanket manner without compensating.
Amend it, maybe.
Then, if I amend it, then I'm afraid there will probably be another day like today in this court on the basis of a constitutionality of that.
Mr. Kemp, does that suggest that your client has more confidence on this court than Parliament where it serves?
That is why we are here today and why we make these submissions. We do not enter into the fray on all accounts, and on the appeal we simply say that insofar as the court followed the Ham decision, which we submit, if one looks at the order paragraph 6 that says this relates to all future municipal elections, and one looks at paragraph 114 of that decision, one sees this court spelling out why it wanted it to be prospective, because it didn't want a challenge to anything done by the council that had in the interim operated in those areas, or any other council that had been elected in the past, any other municipal council. And we say it is quite clear that the requirement that the addresses of all voters must be given, in fact, relates to all voters. But obviously, there must be a reasonable time for that to implement. Sorry.
Cap, you refer us to page 420.
4?
You refer us to page 420 and 421.
Yes.
It just struck me that the IEC tells us that they don't have the addresses, complete addresses of 65% of all registered voters.
Yes.
Only 1/3.
That is correct.
Of voters are, so addresses are properly documented.
Yes.
And you invite us on that basis to find that they acted unlawfully.
What I am inviting this court to find is to allow them to use this voters' roll with these voters exercising their voting rights, but subject to a check and balance to make up for non-compliance with Section 16.3. That is the submission.
Okay, in relation to the appeal, should we uphold it at all? Your approach?
It's our submission that you should not, Deputy Chief Justice. It seems to us that the court in that case simply applied the earlier decision of this court in that matter, and that in the circumstances of the case, especially given that it had been to this court before, and if one reads, the issue seems to have been about what does the prospective effect of this court's decision, and that is why the IEC felt quite confident in putting up that voters' roll that it had. And we submit that in the circumstances, the court below seemed to be quite correct in saying, well, if you want to put up a voters' list like that, then you must explain how it complies with Section 16.3.
And on direct access, I just want to wrap up clearly and understand in my own mind, and we should also refuse direct access, right? Or should we grant it?
Should you, sorry?
Because should we refuse or grant direct access application? Because if we don't grant it, we might not reach the remedy.
If you refuse the direct access, Deputy Chief Justice, then what is going to happen is that there are going to be challenges to the rolls, and it does seem in our submission a far better outcome for everyone involved if this court rather hears the direct access application and allow these voters. After all, it is not their fault that they're not properly registered, to vote and only balance it with a check on information that they do have. It is very few voters that actually cannot tell you where they live.
So in essence, we have to save the IEC from challenges against the voters' roll. 2/3 of the voters' roll.
Yes.
And that we should do by way of direct access.
Yes.
Yeah, I understand the point. Thank you.
Thank you, Mr. Gam.
Thank you. Sorry, Chief Justice, my Leonard Jr. has given me a note and said there's an issue of condemnation. We filed the electronic
We
aids.
will reflect on it on the basis of your argument on papers.
And we do want costs of two counsel. We make that request because we came here on the basis of relief being sought from this court to suspend wholly for this coming up elections the operation and the effect of section 16.3, that must be ignored, and also that the proper compliance thereof was going to be postponed till after
we will deal with that.
Thank
you. And Mr. Kemp, this is not because you are his lecturer, but because you have put up a very good case, I must say.
Thank you, Molly.
Mr. Trengove, can we have 2 to 3 minutes break?
Certainly, Chief Justice.
Thank you. The court will adjourn for 2 to 3 minutes.
Just
struggling to manage. I mean, how do you say this thing is based on the 16th? You say that we address constitutional
It's like a moving target, that's for sure. It's a moving target. You actually look at how they created once it's a moving target because you don't know what it is.
They dismissed you, and then 15 minutes later they remembered that, oh, by the way.
Challenge it based on. You will accept everybody who suggests the same ways you challenge. You don't remove anybody. That's the best solution I've heard. So, what is the solution?
Q?
Meanwhile, lawyers representing independent candidates in Tlokwe have argued that addresses boost the principle of free and fair elections. They're worried that a voter's roll without addresses opens the door to fraud. Voters' roll with
And Q?
Meanwhile, lawyers representing independent candidates in Tlokwe have argued that addresses boost the principle of free and fair elections. They're worried that a voter's roll without addresses opens the door to fraud.
Beautiful. They'll look for a solution to and my reason is actually time to have court. That's my reason. That's the application of how you... Well, they think it takes too long. But when then it's easy. Stats will say we're going to but also we've seen do them for a reason. I've already said
Yes, Mr. Trengov.
Chief Justice, I will...
should it be 15 minutes or more? I know that we do interrupt and make it longer.
Let me say, I think what I'm going to do is to address one or two important issues. My learned friend, Ms. Blizzard, will address the alternative remedies proposed, particularly by the IFP. For my part, I should be able to finish in about 15 minutes. But if you would, after that, allow her a further 5 minutes to address that remedy. I'd like to spend my time really on three topics. The one is the only cause of action that was raised in the papers. The second is the other causes of action that have been advanced today that were not raised on the papers, and why it would be unfair to the IEC to consider any of those causes of action. The third issue that I will address is the remedy that we seek in the direct access application, and merely the competence of that remedy, because that has been elicited much debate.
Can I put something else in your basket, if you allow me? Page 420 of your affidavit.
Page 120.
420.
420.
Tells us 32% of voters' addresses have not been captured. Then it says 33% are incomplete or generic addresses. And says only 34% are complete addresses. And over the page in 421, the IC tells us that it is clear that across the country, the IC will be unable to satisfy addresses in the manner required by the Electoral Act judgment in respect of approximately 65% of all registered voters. When you find time, come to that issue and tell me why shouldn't we find that the IEC acted unlawfully and inconsistent with Section 16.3 of the Act. You can deal with that at your own time when it's convenient.
Certainly, Deputy Chief Justice. If I may start with the cause of action raised in this case. And remember, this case was an urgent application launched on the 22nd of January and heard on the 23rd. So the papers were prepared overnight. And the application launched on one day, on the 22nd. My client filed their answer the next morning on the 23rd, and the case was heard and decided on that day, the order made. So this was a highly pressurized, urgent application. And the issue in that application, I submit with respect, was a very, very narrow issue. And that was a contention advanced by the independents that the voters' roll provided to them did not comply with the COM judgment because there were 4,000 names on the roll without addresses. That was the contention. Now, if I may go firstly to the two letters that were exchanged in the days immediately before the application was launched, because the parties referred to them and incorporated them in their papers. The first letter was the letter of the independents' attorneys, which commences at page 55 of the papers. And the particular cause of action which they advanced in the application was set out at page 56 in paragraph 4. And this was what they said. Ex facie the contents of the voters' roll. The voters' roll provided to our client does not comply with paragraphs C and D of the order of the Constitutional Court, in that the following numbers of registered voters in each of the respective wards of the by-elections does not reflect a verified address. And there the numbers are given, and that is the 4,000 names without addresses. So the contention at that paragraph was simply, there are 4,000 names on the roll without addresses, and that does not comply with the COM, with paragraphs 5, C, and D of the COM judgment. The answer to it came in the letter from the IEC's attorneys in volume 3 at page 208 of the papers, but the particular paragraph is addressed from page 209 in paragraphs 8.4 to 8.6. And the answer at page 209 in paragraph 8.4 says, with regard to paragraph 4 of your letter, we point out that the Constitutional Court was at pains to point out that its order did not impose on the Commission the obligation to verify addresses provided by voters. And then over the page in paragraph 8.6, it deals with the contention that the COM judgment required every name to have an address. And what it says is the following. To the extent that the complaint in paragraph 4 of your letter relates to the fact that, in respect of some of the voters appearing on the relevant segments of the voters' roll for the affected voting districts, no addresses have been provided, we are instructed that there are at least two reasons for such lack of addresses. One, some voters were registered on the relevant segments of the voters' roll prior to the judgment without providing a conventional address. And two, some voters were registered on the relevant segments of the voters' roll after 30 November, that's after the COM order, 2015, who were unable to provide a conventional address. So the answer, the case made against them was COM required all names to have addresses. There are 4,000 names without addresses, therefore the roll does not comply with section 16.3. The answer is no. Harm judgment was prospectively made, the orders was prospectively made from the 30th of November. Some of the names on the list that you see without addresses are old names, not post-Ham. And insofar as some of them are post-Ham, those are people who do not have addresses. That was the debate. The application was then launched, and the application simply perpetuated exactly the same contentions. And it is made clearest in the notice of motion in volume 1 at page 2 of the papers. Because the order that was sought was an order declaring, that's in prayer 1, an order declaring the segments of the certified voters' roll of the by-elections to be held in the Tlokwe local municipality in those wards are not compliant with section 16.3 of the Electoral Act, in that the said certified voters' roll does not contain the physical addresses of all voters. That's exactly the same case. It's a case that says Ham required the roll to include all voters, and because there are 4,000 absent addresses, the roll is non-compliant. That was the cause of action that was advanced, and that was also the...
I think one should read that whole of 1. It goes beyond that. All voters, alternatively, an indication that the said physical addresses could not be verified or established. That's the whole complaint in full.
Yes. Yes, indeed. But it fails to recognize that Ham does not impose a duty to include addresses in the voters' roll of people previously registered without addresses, people whose addresses were not kept and recorded.
Complaint requires an indication that the addresses could not be verified or established. It's an invitation to the IEC either to have them all there or to indicate why they are not there. Isn't that the two struts of the complaint?
No, with respect not. We accept that in relation to every voter that was registered, the address was determined and established. It is true that none addresses were ever verified, in the sense that nobody ever checked on the IEC, and that's also the point made. We had never had a duty to check on the address given to us by the voter. But we're talking about names that do not appear on the voters' roll, in respect of whom the IEC was given addresses at the time when there was no duty to keep and record their addresses. And that is frankly also how the Electoral Court understood that cause of action. In the Electoral Court's judgment in paragraphs 8, 9, and 12 make that clear. In paragraph 8 says, the complaint is that the roll did not comply with section 16.3. Paragraph 9 says, that complaint is made because there are 4,146 voters without addresses. And then paragraph 12 explains that the fact that there are those many voters without addresses, the 4,000 odd voters without addresses, that is in itself a fatal defect. 12 says the fact that they do not have addresses, the fact that there is common cause that they do not have addresses, this admission implies that there are indeed voters on the roll, as before the Constitutional Court, who should not have been included therein. So it's a simplistic case that proceeds from the premise that Ham required all voters in the roll to have addresses, and simply because there are 4,000 voters without addresses, therefore the roll is deficient. And that, with respect, was the only cause of action that the IEC was called upon to meet at the time. The causes of action that was not raised and therefore not canvassed on the papers, but suggested at various times here today, is in the first place a cause of action that says, although there is no obligation on you to record historical addresses, i.e. the addresses of the 18 million pre-December 2003, you had a duty to record the addresses of new registrations from December 2003, and you failed to do so. That case was never raised against the IEC.
But the notice of motion recalls the requirement of 16.3 in so many words. You've just read it to us.
Yes,
Isn't it so? In volume 1.
Yes.
The notice of motion says, an order declaring segments of certified rolls held there not to be complied with 16.3 of the Electoral Act.
Yes.
So it's slam bang in front of us.
No,
Why is it a new cause of action?
No, with respect. Because what it said is, you do not comply with 16.3 because there are voters on the roll without addresses. It is the cause of action, a cause of complaint that I'm referring to. They said there's a breach of 16.3 because there are 4,000 voters on the roll without addresses. That's not only what they said, but that's also what the court understood their cause of action.
Yeah, but why is that a new cause of action? It is right in front of us. They rely on 16.3, they say so, and say alternatively, you must tell us why there are no addresses. That's the cause of action, and that's what we're debating today.
No, with respect, not Deputy Chief Justice. The cause of action contended that COM had held that all names on the roll must have addresses. That was the whole premise of the attack. And they say merely because there are 4,000 names without addresses, therefore you don't comply with Section 16.3. And that is what the Electoral Court found. It found that because you admit that there are 4,000 odd names on the roll without addresses, therefore there's a violation.
Sorry to interrupt, Mr. Trengo, but the Electoral Court's order echoes the COM order that echoes Section 16.3 that says expressly we're available. So is it difficult, as the Deputy Chief Justice is doing, to read that as a complaint that you haven't, whether since before or after December 2003, been doing your duty as a commission?
No, but the argument there was the argument made by our learned friends today that where available means where available in the market. In other words, you had a duty to go back. Don't tell me about old registrations which do not have addresses. You have a duty to go back into the field and to find the addresses for all the voters. That was the entire premise. And it is true that it recites the language of 16.4, but that is based on a premise that's 16.3. 16.3 means that you have to furnish in the voters' roll not only the addresses of people registered since December 2003, but the addresses of everybody, because where available means where available in the field.
I understand that, and we will have to determine what where available means, because it's become up before us squarely now, whereas it hadn't come. But whatever the details of that, the complaint is of a breach of duty by the Electoral Commission of Section 16.3 in failing to supply addresses where available.
Yes, where available in that sense, available in the field. If you were to uphold that interpretation, in other words, that there was such a duty to obtain the addresses of those on the roll where that address is available to you in the field, well, then it is clear that the IEC did not comply with that duty, because it never went out in search of the addresses of people already on the roll.
Or reasonably available, as the debate between you and the Chief Justice took, and other counsel.
Let me make it quite clear. The IEC did not, before this judgment, go out into the field to find the addresses of people registered on the roll before December 2003. What it did after December 2003 is that it recorded on its system all the available application forms that it still had, some of the people of the 18 million, but it never went out into the field to find their addresses. So that if the court were to hold that the section means that there was a duty on the IEC to go out and find the addresses of those people where it was possible for them to do so, well, then the IEC did not comply with that with that obligation. They just never understood that obligation to mean that they were obliged to find the addresses of people already registered. And let me submit with respect that that is an eminently reasonable and the appropriate interpretation.
Listen to what they say, a side interpretation, page 419, paragraph 61. Yeah. Indeed, even after 2003, the IC tells us, the IC was not especially focused on ensuring that every voter's address was fully and accurately captured on its systems. This was because, until relatively recently, there had been very few requests made by political parties for the addresses of voters to be provided, despite the existence of 16.3. The increased interest and focus on addresses has only occurred in the last 2 to 3 years. This appears to have been partly as a consequence of there being more contested municipal elections. So, out of their own mouths, they tell us that even after 2003, they didn't focus on ensuring every voter's address was fully captured. I mean, what should we make of that? I mean, we don't need interpretation because they tell us so.
Yeah.
And then thereafter they tell us, as a result of this, 2/3 of their people on the voters' roll have not full or proper addresses.
Well,
or proper address.
Yes. Well, what they say is that they weren't careful, as they are today, to make sure that every one of those people are registered. There was sometimes a time lag between the registration and the recordal of the address on the roll. But the case made against them has never been that the 4,000 are people registered after December 2003, but that they have failed to record their addresses. The case against them is one that says you must have all the addresses on the roll, and here are 4,000 people whose addresses you did not provide. And
Mr. Trango, on the formulation of the cause of action, could the applicants in the Electoral Court have been able to tell of the 4,000 people whose addresses were not available or furnished to them?
Yes.
How many were voters who registered before December 2003, and how many thereafter, so that they can formulate this cause of action properly? My assumption was that they didn't know. The IEC as well in its papers does not tell us of those 4,000 voters, how many registered before December 2003 and how many thereafter. It doesn't even tell us how many were registered after CAM. It does tell us that some were registered after CAM, but it doesn't tell us how many.
Justice Jafta, you're quite correct. The issue of when these people were registered, before or after December 2003, was not canvassed by anybody on the papers. I guess that the independents wouldn't know. I also guess that my clients would be able to establish, I think they can establish when a voter was registered. But that's guesswork because the issue was never raised and was never canvassed. You're quite right, but that, with respect, is because nobody raised that complaint. The other cause of action, the suggestion that one has to have the addresses for the election to be free and fair within the meaning of Section 191C. We submit with respect, firstly, that that's also not a cause of action that's been pleaded. The question of whether the addresses are a necessary ingredient of a free and fair election, that was never raised. And it's not an abstract legal question, it's very much a factual question. But, so the issue has never been canvassed. we submit with respect that it can't be a condition precedent for a free and fair election. Otherwise, it would suggest that all our elections before 2003 were not free and fair, because none of them were held with such a voters' roll. And if one were to ask yourself what the significance is, then we submit with respect that a free and fair election at national or provincial level can manifestly be held without an address list, because it's proportional representation and it's immaterial where the voter, in which voting district the voter votes. Ultimately, it's the totals that matter and not their distribution in voting districts. Location of registration matters only for local government elections. And there it does matter, it is significant. But the requirement there is that people should be correctly registered where they are resident. The requirement is not that address be in the voters' roll. I accept that the requirement of disclosure of the address would help to keep the voters' roll honest, because it would allow everybody to check the voters' roll. But to say that it is a condition precedent for a free and fair election, we submit with respect is unfounded.
The requirements of the address, doesn't it satisfy the requirements of ordinarily resident in 16.3?
The requirement of? I'm not sure that I'm with you, Justice Kambina.
Section 16.3
yes.
also requires that upon registration,
yes,
those people must be resident, ordinarily resident within the particular area.
Indeed.
So once you have the address, you'll be in a position to ascertain whether that requirement has been satisfied.
Yes, I accept that the address list is useful because it allows you to check on the accuracy of the voters' roll. I'm not suggesting that it is not a useful tool. The question is whether it is a tool that is necessary for a free and fair election. And I submit with respect it is not. It is a requirement that was introduced, as you made the point earlier. It's a requirement that was introduced when Section 16.3 was introduced in December 2003. The third cause of action, Justice Jafta, I'm not quite sure in what context you intended to refer to it, but you did make mention of the IEC's own acknowledgement of the 1,600 voters that it discovered were wrongly registered. And you're quite right. That is what the IEC acknowledged in its letter of the 19th of February. But what it made clear was that that was part of its own initiative that it took after COM. It discovered that there were 1,600 people seemingly wrongly registered. It gave them notice that it intended to remove their names from the list, and only 2 people protested, and they were left on the list, and everybody else, 1,598 or whatever, were removed from the list. So clearly there was a significant problem in Tlokwe, and that problem was investigated and addressed. But that was done before this application was launched. So this application did not complain that there were 1,600 people wrongly registered in Tlokwe.
Just help me, Mr. Trango. Does those 1,600 people have any relation to the 4,000 not registered with it?
No, they were taken off the roll before this application was launched. They had nothing to do with it. And that much is clear from the attorney's letter of the 19th of February. The paragraph was read earlier, but it is on page 211 of the papers in paragraph 8.10.5. It was made clear that they had already been removed from the roll before the letter had been written, and therefore before this application was launched.
The debate, Mr. Trango, was based on the assertion that the IEC in that letter says we have determined that the 1,600 people should be removed because they were registered in wards other than in those in respect of which they have given addresses, which suggests that it used the availability of addresses to determine whether those people were properly registered. Now, the difficulty was it doesn't say on what basis or what satisfied it in respect of the balance that they were correctly registered, even though the addresses were not available.
You're quite correct, Justice Chafta. They don't say that, but it was never a case that they were required to meet, that there's reason to believe that other people were wrongly registered and therefore give us your justification for that.
Sorry, Mr. Tringa, we're squabbling with you at this late stage, but that complaint follows immediately after, in the letter you read to us. It follows immediately after. They say our own researchers have found these 545 other people. So reading the founding papers together, and together with what the Deputy Chief Justice quoted to you from paragraph 1 of the Notice of Motion, it does broaden the basis of complaint to say that we are unhappy about the non-compliance with 16.3 and with CUM because we're suspicious of all the registrations.
It is true that they raised the 500 in the letter. As I stand there, I'm very uncertain of my recollection of whether they raised that in the founding affidavit. My recollection is that it was not raised in the founding affidavit, that the cause of action with which they proceeded in the application was purely the 4,000 names on the list without addresses, and that they didn't raise a case, and that's the issue my learned friend Mr. Marcus addressed earlier. They didn't make a case in the application that there are, apart from the complaint about the 4,000, 500 people who have been wrongly registered on the list. They, in any event, never produced any evidence to substantiate that suggestion.
I struggle with this. I sit with half disbelief. IEC, a statutory body, it is challenged.
Sorry, IEC?
I sit with half disbelief, the submission. IEC statutory body, I think the point was made quite early by the Chief Justice. We're all fresh and early at about 10 o'clock. IEC statutory body is confronted with a notice of motion that says you have not complied with the law. You've breached 16.3. And we're worried about these 4,000. In one liner, they say we don't have the addresses available. They don't say, yes, they are entitled to be there. They're entitled to be registered there. This is how we know it. And therefore, your claim has no traction. They do none of all that. And you're still pressing on us that that was an adequate and legitimate response from a body which bears the duty to ensure, as we know from 8.3, read with 16.3. So how could that be adequate? How could that be a response that you say other people didn't do anything when it's the IEC that bore the responsibility to say, these 4,000 will vote here, and I know why, because it complies with the law. And here are the facts. Not a scintilla of evidence that suggests...
No, with respect, Deputy Chief Justice. Remember, they receive papers today, and they're in court tomorrow. They produce papers overnight to respond to the accusation made against them. The accusation made against them is one that says that the effect of the Constitutional Court's judgment in CUM is that all the names on the list must have addresses. And if there is a name without an address, then that name is unlawfully on the list. That is the case they make. And it is true that the Commission didn't overnight research the origin of 4,000 registrations. What they did instead was to say, but your premise is wrong. You are wrong to say that the implication of CUM is that all names must have addresses. There are two categories of people who do not have addresses despite our compliance with CUM. They said we fastidiously complied with COM, but it leaves two categories of people without addresses. The first is the old registrations, without telling us whether that means before and after 2003. They simply say, refer to the registrations that were not made pursuant to paragraph 5C of COM. The second is those that were registered after COM but who simply do not have addresses. So says the IEC to this application launched, dumped on it overnight. It says the premise of your complaint is wrong. I haven't had time to, well, they didn't explain any further. They said the premise is wrong. To say that they should, in those hours between the 22nd and the 23rd, have researched and explained the registration of more than 4,000 voters is with respect to expect make unrealistic demands of it in an overnight urgent application. They had a short, complete answer to the premise on which the application...
The answer is they didn't have time. Not even to supplement, not even to hand up an affidavit in court.
Well,
they
handed
bear
up an
the
affidavit
duty...
in court. They lodged this affidavit on the morning of the 23rd, and they walked into court and the debate began. The order was made that afternoon.
They could have supplemented even before us. They could have supplemented in before that court. So the defense now is that there was little time. This is the point I'm making from where I sit. If you bear constitutional duty and you are a state organ and you are challenged and charged with unlawfulness, you step up to show that you acted lawfully.
Well, in this court, what it made clear is that it had always complied with the law as it understood the law to be. And it explained that it understood the law to be that there was no duty on it to retain and record addresses before December 2003. There was such a duty since then, which it complied with generally, but not carefully and fastidiously, and that it has done so fastidiously since this court's order on the 30th of November. But what is important in that explanation is that it addresses two things. The first is the very complaint about the Tlokwe election that it said was based on a misconception. But, says it, if it was right and I am wrong, then it has vast implications for elections nationally. And that is when I come on my direct access application. That is.
And has IC complied with the 16.3 obligations?
Yes, with respect it has.
The role, when you take the role and look at it now, do they need any assistance from us if they have complied? Why must we grant direct access?
No.
If in fact they've done everything squeaky clean?
Well, Deputy Chief Justice, what they have said is that they have always complied with the law and the requirements as they understood them. The matter as to how they complied since December 2003, how effective their compliance has been, was never canvassed in the papers at any length at all. You asked me to get instructions on that score this morning, which I did, and I gave you the best response that I could get within the minutes that we had available.
Till I discovered some valuable parts in the record.
No, with respect, that's unfair to the IEC.
I mean, through the IEC's own lips.
All it said there is that I wasn't as careful then as I am today, because it was not an issue that was pressing at all. And that the explanation that you got this morning was that there were sometimes delays between registration on the one hand and recordal on the other. But that is because we are debating an issue never canvassed on the papers at any length at all.
I'm getting increasingly worried, Mr. Trengov, because we were moving towards finding a way to accommodate the IEC, but it appears that the IEC is determined to take a particular position, and that is the position that seems to suggest that we have, from where we sit, we did all that we were required to do.
Yes.
Here is page 420. It's worrisome. From their own mouth, they say it's only just over 8 million people who were registered with addresses. We are not told, as far as I can recall, why is it that the other 8 million in relation to which there are challenges with addresses, that something was not done, and if something was done, what is it? The banning of some warehouse in KwaZulu-Natal, does it appear here?
No.
Why is it not there? Because clearly I'm sorry to speak long, but I'm expressing my maybe a bit of frustration. You see, it appears that the IEC identified the need to clarify its position and to highlight its difficulties. That is why it was able to come up with numbers, 8 million plus, there are addresses. Another 8 million, there are addresses, but they are not complete or there are challenges in relation to them. Why is it, as a way of taking the court into its confidence, that the IEC did not explain why the other 8 million does not have addresses attached to it?
But with respect, it did, Chief Justice. What it said was, in December 2003, there were 18 million people on the roll without addresses because we didn't keep and record addresses up to that point. So your starting point is a roll with 18 million people without addresses. Since then, we have recorded the addresses, we have kept and recorded the addresses, but there still are two categories of people for whom we don't have addresses, and that's the 8 million and the 8 million. We started off with 18 million people without addresses in December 2003. That number had reduced to 16 million when this application was launched. Let me give the full picture. There were 18 million people on the roll without addresses in December 2003. By the time this application was launched, that 18 million voters on the roll had increased to 24 odd million, but the number of people without addresses was 16 odd million. So you had, despite a significant increase in the number of people on the roll to 24, there were 16 million left without addresses. And what it explained about those 16 million is that they fell into two categories of people. The one category was people registered before November 2003 at a time when we didn't keep and record addresses. That's the one category. The other category is people registered since then who do not have addresses. And that is roughly the 8 million and the 8 million. 8 million left of historical registrations and 8 million people who do not have addresses. So the explanation was given. I don't know that they could have given more explanations. What they could possibly have done, if they had been asked to do so, is to give the divide in that breakdown, a further breakdown of before and after December 2003, that they hadn't done because they didn't understand that to be an issue on these papers.
Well, let me tell you where my difficulty comes from, and it flows from what the Deputy Chief Justice raised with you much earlier. Page 420, paragraph 16.2. It says there are 8,314,822 registered voters whose address are captured on the IEC systems, or whose address captured on the IEC systems is either incomplete or generic. This includes, but is not limited to, what this court described in the CAM judgment as generic addresses such as Crossroads in Cape Town or Morningside in Durban. Now, incomplete, do we know why they are incomplete? Is there an explanation? When you are confronted with a problem, you seek to explain to those who are to adjudicate, you know what, I've got a problem. It was not deliberate. Let me tell you what my challenges were. Yes. I had this difficulty. I had this difficulty. That's why I find myself in this position. The paragraph that Justice Jafta earlier referred to I understand that to mean, 16.3 is there, but we didn't understand it to impose an obligation on us. But at least some explanation as to why then, if it wasn't an obligation, were addresses of some 8,468,000 people captured properly and others not captured. That's what I meant by an explanation.
Yeah, but with respect, they did give that explanation. They said because there was no duty on us to capture the addresses before December 2003. So you'd have an address that says Crossroads. Now that's one of two possibilities. The one is that this is somebody who doesn't have a more particular address. They live in Crossroads in a shack which doesn't have an address.
That's generic, isn't it?
Well,
is that generic or is that incomplete?
Well, it can be either, because sometimes that voter doesn't have a better address than Crossroads.
I thought incomplete. I'm sorry, I'm interrupting you. I apologize to you, Mr. I thought incomplete is where the address is ascertainable, but for some reason, the one taking down the particulars did not complete the address, in which event there could be an explanation. Is there a difference between incomplete and generic, or is it the same thing?
No, it's not the same thing. But when I mentioned the example of somebody who said, I live in Crossroads, then it can fall into either of those two categories. It can either be a generic, purely generic, because the voter doesn't have a better address. He lives in a shack in Crossroads without an address, and he doesn't have a better one. And he was registered because he explained to the voting officer, the electoral officer, where in Crossroads he lives, and the long explanation satisfied the officer that he was registered in the correct voting district. That's the one possibility. The other possibility is that he lives in Crossroad, that he has an address, he lives in shack number so-and-so, but that those particulars were not completed in his rec form. In other words, the rec form was incomplete in that it said Crossroads, and it was only on interrogation by the officer that they determined that it was a shack with a particular number which placed him within the voting district.
Or he or she forgot it by the time it was asked for.
Well, I don't know about forgetting, but what we are told is that a lot of people fill in their form in an incomplete way, and there is then a conversation between the registering officer and the person seeking registration, and sometimes that conversation discloses that the person has no better address, or it discloses that he has an address, but that record was not kept before December 2003. So that we submit with respect that the cause of action on which the IEC was taken to court was not established, because it was a cause of action based on an incorrect reading of COM. And the mere presence of names on the list without addresses does not say or suggest that there is a violation of 16.3.
We reach the direct access. If the appeal fails, we've had your submissions on the appeal. And if we go past there, how do we provide relief that your clients seek under direct access?
Well, if the appeal fails, then it means that the IEC had failed to discharge its duties under Section 16.3. And then the question arises what the appropriate remedy is for that failure. Now, it did not seek that remedy for the national problem in the Electoral Court, because that was not the issue before it. And that is why it is here on direct access, where it says, I say that the Electoral Court was wrong, but if I'm mistaken, if the Electoral Court was correct, then I have a very serious problem, a national problem, not a Tlokwe problem. And that is why I seek this court's assistance in addressing that problem. The appropriate remedy
is that problem. Let's just define it. We have to write the judgment. What are we going to say the problem is?
If problem
say
is...
the appeal fails.
The voters,
what is the
Section
problem?
16.3 requires that the addresses of all of the voters be included in the voters' roll where it is possible to obtain them. That is the implication of the judgment.
So the problem would be, in fact, unlawfulness, would be that it acted unlawfully.
Not unlawful registration, but unlawful roll. Unlawful 16.3, the roll that you disclose is incomplete.
The roll doesn't comply with 16.3.
Indeed.
Yeah. But we have to go there first, and then what remedy would we give them?
Well, then the remedy depends on where you find, precisely what you find the unlawfulness is. Is it because it seems in this debate that you may come to two different conclusions. The one conclusion, the extreme one, advocated by the independents and upheld by the Electoral Court, would be one that says there's a duty under 16.3 to obtain the addresses of all the voters, even those registered before December 2003. That's the one possible conclusion. And then the remedy would have to be designed to address that problem, and that is the assumption underlying our direct access application. There is another possibility, and that is that you find that there was no duty ever to find the addresses of people already on the roll in December 2003, but there was a duty to record all of the addresses registered since then, and that duty has not been discharged. Well, then it's a much more confined problem and a more confined remedy. Has not been canvassed on the papers because that conclusion has not been suggested until this debate. But there are those two possibilities. You asked us whether, Chief Justice, whether it might not make sense for the IEC and the parties to discuss the matter. I am told that my learned friends are correct. There are in fact committees in which extensive discussions have been had. But the problem is that until clarity is obtained on the question whether the IEC has acted lawfully or not, and if not, in what respect, it is not particularly helpful or possible for the parties to agree on a remedy if they don't know what it is that they need to cure.
What I had in mind was, as at the time when they found it difficult to find each other, they would not have had, they obviously did not have the benefit of the debate that we have had for the whole day. Now that the issues have been thoroughly ventilated, it may well be that upon further reflection, parties adopt a different attitude altogether to say, you know, coming to think about it, this thing is worth exploring. This possibility of finding each other is worth exploring. And I put it no higher than that.
I accept that is so, because the IEC would be amenable to a satisfactory outcome, even if they are not legally obliged to adopt that outcome. So that certainly a discussion we accept would be a meaningful endeavor. Could I address one last issue, and that is the issue of the competence of the remedy sought, because there was debate as to whether it's competent. May I submit with the greatest of respect that the remedy sought by the IEC would be competent under section 172(1) on one of two different bases. Firstly, because 172(1) empowers the court in any case within its jurisdiction to grant a just and equitable remedy, whatever it might be. And the case is within its jurisdiction if it raises constitutional matter. Once the case passes that threshold, the court has a broad power under 172, a remedial power, to grant any remedy that is just and equitable. And it has made it clear in the past that that's a broad remedy which it has not boxed in any way. And that remedy we submit would go a long way to allowing the court to regulate the process going forward in whatever way it deems appropriate. But even if the court were not to act under its general just and equitable power, even with specific power, is one that can, the specific power relating to conduct that is unconstitutional is a power that would enable it to grant an appropriate remedy in this case. For this reason, if the IEC should have recorded and included those addresses in the roll under 16.3, then it means that it acted in breach of Section 16.3. Its conduct in providing a roll without those addresses is unlawful. Not only does it breach Section 16.3, but if it conducts elections in a way that does not accord with the law, then that would also be in violation of Section 1C of the Constitution, which requires the IEC to observe the rule of law. So its conduct in providing an incomplete voter's roll would constitute unconstitutional conduct. And this could, the appropriate remedy for this court would then be to declare that the IEC's disclosure under 16.3 of a roll which does not include these addresses that should be included is unconstitutional. But it may then qualify that declaration of invalidity by an order that says, I suspend that declaration of invalidity that declares its conduct to be unconstitutional. I suspend that declaration for as long as it is necessary for it to cure the shortcoming in its conduct. In other words, for as long as it's necessary for it to act constitutionally. So at the level of competence, the order we submit with respect can both be made under the general, just, and equitable jurisdiction or under the power to suspend a declaration that conduct is unconstitutional.
Mr. Trangov, I think the debate arose from the proposal by the minister.
By the minister?
By the minister, that we should suspend the operation of the Act.
Yeah.
It was in that context that the debate arose.
Yeah.
And the question was, do we have the power to suspend the operation of an Act of Parliament? What you have just articulated is different.
Yes, it is. And
you'll be happy to know that at least there's one thing I agree with you for today.
Happy and surprised, you know. Let me just say this, Justice Matlanga. You spoke about the rule that the law does not require the impossible. And let me say that that rule, which is really a rule of interpretation, does play a part in one respect but not in another. It assists us in the interpretation of Section 16.3. We submit that it means you can't interpret 16.3 to mean that the IEC must record and provide not only the addresses of new registrations, but of old registrations, and do so overnight, because remember 16.3 kicked in December 2003. So the rule assists one in the interpretation of 16.3. Where the rule doesn't help, or doesn't help us, is that the rule doesn't excuse self-made impossibility. So if we're wrong, if we ought to have recorded those addresses, the old addresses, but failed to do so, then we can't ask you to manipulate the law to accommodate our impossibility. What we can still urge you to do is when you exercise your remedial discretion, when you make a just and equitable order, it is never just and equitable to require the impossible. So in the design of your order, it is important that you design an order that can reasonably be achieved and not something which is impossible. My learned friend, Ms. Blizzard, lastly will address the IFP alternative proposal, because we do submit that it's both unlawful and impractical. Those, Chief Justice, are my submissions.
We've been asked for costs from all sides. That is, if you lose, everybody's been asking for costs. They must follow the result, surely, shouldn't they?
I beg your pardon?
Should costs follow the result? various respondents have asked for costs. I'm just asking, is there any reason why costs should not follow the result?
No, I can't contend that there is reason to make an exception to that rule, no.
Well, maybe we should just, before we finish, find out from National House of Traditional Leaders and the minister can't ask for costs.
With respect, the party is entitled to costs.
No.
Would only be those who opposed us, not those who supported us.
They would have lost as well. I think you have a point.
No, I mean, the question is why those costs? Costs follow the results. Successful parties get their costs against the unsuccessful parties. If you find against me, you'll also find against the minister and against the ANC.
You're in the same block.
And there's no reason why the cost shouldn't go against them as well. Yeah.
No, you are right. Thank you. Ms. Blizzard, your 5 minutes. Mr. Turngrove, we cost him to take 35 minutes, but we are to blame.
Thank you, Chief Justice. As Mr. Turngrove indicated, I'm going to address the IFP's provisional ballot proposal. I'm not going to address the independence proposal because I accept that it's been conceded that that proposal is not a lawful option. If I may just start by summarizing what we understand the IFP's proposal to be. Essentially what it is that it envisages allowing millions of registered voters, lawfully registered voters, but who do not have their addresses on record with the IEC, to cast only provisional ballots. And then requiring that these millions of voters, many of whom will be illiterate, to complete a fresh voter registration form on voting day. And then thirdly, that the addresses of these voters must then be collated by the IEC and published to allow for a public objection process to unfold in terms of Section 15 of the Electoral Act. So I'm going to just address briefly the practical difficulties with the proposal and then the legal difficulties. So starting with the practical problems, in its replying affidavit, the IEC highlighted several difficulties in response to the IFP's proposal. And quite frankly, these difficulties have not been meaningfully addressed by the IFP. And really there are 4 practical difficulties. The first is that the IEC explains that to allow for a provisional balloting system like the IFP has proposed would require an additional 40-odd million distinct and security-coded provisional ballots to be generated, and that there's simply not enough time in the election timetable before the local government elections for this process to unfold. And that hasn't been addressed at all by the IFP. The second problem is that the voting process on election day will be seriously delayed if what there are presently 12 million voters without recorded addresses, and that's about 45% of all voters, if they are required to complete a fresh registration process essentially on voting day. And as we've explained, many of those voters will be illiterate. They are voters whose addresses are not on record with the IEC because they have no formal address. So they're not sophisticated voters often. And so they will need dedicated assistance to complete that registration process. And the IEC has estimated in its reply that conducting this mass re-registration process on voting day will delay the voting process by about 4 times, and that will in all likelihood deter many lawfully registered voters from exercising their right to vote altogether. The IFP's answer to this is that, well, all 52,000 electoral staff can assist these voters in this registration process, but of course that ignores the fact that there is also a voting process going on at the same time. The third problem then is that the Electoral Commission will, after voting has been concluded, but before the counting can commence and before the election results can be announced, the Electoral Commission will have to compile a list of 12 million voters who cast a provisional ballot. They'll have to publish the relevant segments of that list at each voting station. And really the scale of this exercise shouldn't be underestimated, and I think it has been underestimated by the IFP, who haven't really addressed our concerns in this regard. If one just considers that there are 12 million voters in this position, if we have just 100 names per page, you're looking at 120,000 pages. That's the scale of the list. Another comparator is the time periods that the IEC has proposed in its 8-phase process. Its phase 4 estimates that 3 months would be required for a similar mechanical process of capturing the address details of all voters on the roll. And then fourthly, there is the Section 15 objections process, which we say would take possibly months to conclude, given the scale of the exercise, and that this would imperil the integrity of 22,000 ballot boxes, which would have to be safely secured and kept secure over this period. And that concern has also not been taken seriously enough, and certainly hasn't been credibly rejected. So that's the practical problems. There are also legal issues. And here I would really just echo what the Chief Justice was saying earlier today, which is that public bodies must exercise powers that they have under statutes, under governing statutes. It's no good for the IFP to point us to an American statute to say that this is a lawful process. That goes without saying. The real problem really is that the Municipal Electoral Act, and in particular Section 7 and Section 47, entitles every person who is registered as a voter on the certified segment of the voter's roll to vote in the voting district where they are registered. And really what this means is that once a voter's name appears on the segment of the certified roll, he or she is entitled to vote in that voting district. There's just no provision for provisional voting system. And I'm not going to take the court to the provisions given the hour of the day, but I would just alert you to section...
And your time is up. I'll give you one more minute.
Right, so it's Section 7.1 and Section 47. There are other technical legal problems that arise relating to how it would interrupt the counting process, it would delay the announcement of election results, and that too would be in violation of provisions of the Municipal Electoral Act, but that is all set out in our reply in our heads. So that is it. Thank you.
Thank you very much, Ms. Blissett. And all I can say to the parties is nobody can ever force you to agree, but it's an option worth pursuing, that possibility of finding each other. Otherwise, judgment is reserved and the court will adjourn.